Happy Monday. I am so excited, over the moon. Before we get started, though, let's make sure that you can hear me because, I tend to rattle on and don't even realize that I cannot be heard. That don't usually happen. It happened one day last week, but I just want to make sure that you can hear me. Hear me. Hey, everybody. Hey. Okay, Patricia says loud and clear. Yay. All right. So, first of all, you guys, we hit the 1K subscriber mark. We actually went way beyond. So, what had happened was yesterday, our lovely Tanika from Tanika's 2 Cents had an incredible live stream interview with a Florida corrections officer. And it was such a good interview. If you missed it, please make sure to go check it out. I'm going to post Tanika. I'm sure everybody is already subscribed to Tanika. But please make sure to go over there and subscribe if you're not already. I'm sure you are, but just in case. But if you didn't watch it, go watch her interview from yesterday with the Florida corrections officer. It was so good, so good. But in that stream, she gave me a huge shout out and let her viewers know that we were super close to the 1,000 mark. And she sent her folks over again, and it just went poof right over the 1,000 mark, and then it's kept on going. So it was crazy. It just kept climbing and climbing and climbing, and now it's like over 1,200 people. So anyway, I'm so thankful for you, Tanika, that you were sweet and generous enough to do that. And thank you for sharing your fine folks with me. Thank you for letting me love on them too. Okay? I appreciate that. And please go check out that interview. It was beyond amazing. It was so good. And I hope, Tanika, that you have her back very soon because she was so good. So good. All right. So I want to say hey to all the new faces that happened to pop in today or during the stream later on, or who watched the replay. I would love for you to click that thumbs up button. That always helps. And that 2 hours did fly by. It absolutely did, Tanika. Yeah, it did. Wasn't planning on, I'd forgotten that you were doing it. I was just scrolling on my phone, and all of a sudden there it was, and I was like, ooh, I gotta watch this, because I don't get to catch you live as often as I would like to. But let me say hey to everybody. Hey, Kel, good morning. Good morning. It's afternoon for me now, but Dog Mom, I hope you feel better. She says she's got the flu. I'm sorry. Let me see. Hey, Michelle. Happy Monday to all. Throws caffeine to everybody in the chat. Thank you, Michelle. I appreciate the congratulations. Thank you, all you guys. Tanika's ready for day number 13. Day number 13. Today is his yellow shirt box fort throw a fit day. Michelle says, like, shared, and begged for more subs. Thanks. Thank you. Hey, Miss Margaret. Hey, ma'am. There, Tanika. Yeah, thank you so much. And so what for those that don't know, I'm sure everybody else knows that monetized means that our channel is now available for ads to earn ad revenue, which is pretty cool. Also, kind of annoying for those who don't have paid premium subscriptions to YouTube. Not gonna lie, but you know what? That premium is where it's at. I have had premium YouTube for I don't know how long now. I can't live without it. Let's see. Yeah, now that you're here with us, you'll feel better. Hey, Patricia. Hello. Ooh, I need to watch that one. Patricia. Thank you, doll. Thank you. Hey, Laura. Good to see you. Hey, Sherry. Hello. Oh, my goodness, Tanika. She gifted 5 Crime Cafe memberships. Thank you. Thank you. Who got them? Let's see. Do we know who got them? Look on my phone. See if I can see if it says. Because those don't show up on StreamYard. Daggone it. Okay, Susan B. was gifted a membership. Kayleen. Yay. P. Lola. Jean Doherty. And Debbie Cook. Wow. Lots of folks that hang out in the chat. They got a nice little gifted membership. Thank you, Tanika. You have been way more than generous, ma'am. I appreciate that so much. I really, really do. I got to throw you a little bit of sparkle, ma'am. Let's have a little sparkle for Tanika. Yeah. A little sparkle dust. Never hurt nobody, right? That's very cool. Thank you. I appreciate it. All right. I feel like I'm getting down to the bottom. Hey, Donnie, good morning to you. Hey, Sam, welcome. You heard Tanika say that. Yeah, it was very cool. Very cool. Okay. Hi, Ron. Welcome. Thank you. Thank you. Yeah. Hello, new faces. We love new faces. Hey, Miss King, did you see it? It was good, huh? Pretty good. Patricia, the interview was amazing. Laura, yeah, premium is where it's at. I have it thanks to my daughter. It's a life changer premium. Absolutely it is, right? I mean, I went forever with just regular YouTube, right? But then I was like, you know what? Let me just get this premium, see if I like it. And yeah, I ain't looked back. Couple years, have nothing else. I have premium. Premium, yes. The cool thing is about premium, though, because for a long time, I thought that the creators that I like to watch wouldn't get paid for those ads, that ad revenue, if I watched it on premium because I wasn't watching the ads. But that's not true. YouTube creators get a portion of the videos that they watch, even on premium without ads. So, very good. She's the very sweetest. And that beautiful baby. Yes. I sent you a message on Instagram, Tanika. I don't know if you'll see it, but I hope that you do. I sent you a message yesterday on Instagram. I didn't know how else to snag you. You get what you give. Yeah. I believe that. I believe you get what you give, you know? We're carving out a community over here of like-minded people, you know? So, there's channels that I jive with that I like, and then there's channels that I go to where I'm like, yeah, I don't need to do that. So, You find who you like, and that's where you stick. All right. I am going to put our banner up for Darrell Brooks. I need to go back and find my yellow color, though, because I liked my yellow color. Where did my yellow color go? Oh, I took my yellow color down because I took my green screen down. You guys, okay, here's what had happened again. Kiddo had her first virtual learning day today. She loved it. She had an incredible time. They were on a delay because snow, 2 hour delay. So I took the green screen down because it would be hard to explain to her teacher why I have like a neon green poster board in the background. Anyway, because we do like the Google Meet thing instead of, StreamYard. So it is what it is, right? It is what it is. I'll fix that. I still like the yellow. I don't know, it just kind of pops really good. And I'll have my green screen back soon. Hi, Lisa. No crime scene today? I know, right? I'll look for it. I want to do a collab. Oh, that would be fun. I would love to do a collab with you. That would be pretty cool. That would be really cool. And there's something else I want to talk to you about that has nothing to do with crime that I think we could do a cool collab about too. Just saying. All right. I do love her teacher, Tanika. Yes, I love her teacher. She actually has two teachers now. She has her regular kindergarten teacher, and then she also has a resource teacher who is sort of like a, I don't want to say special needs teacher, but she's a teacher because of the hospitalizations that kiddo had. We have decided to keep her home and do virtual learning through the winter months because she had back-to-back pneumonia and RSV and was hospitalized for both before Thanksgiving. And so between her doctors and I, we decided we were going to just do virtual learning through the winter months because it's obvious she has a compromised immune system right now. So the resource teacher is kind of the one that does like the homebound learning instruction, that kind of thing. So, but yeah, I know her resource teacher. Like I went to school with her resource teacher. So we know each other very well and I love her. The other gal that is her regular kindergarten teacher, kiddo loves her. She loves her so much. So we're blessed. Definitely blessed in that aspect. So, I'm going to make this screen big and we're going to get started with day 13. You guys, this is the box fort day, like I said. We don't have much longer to go with Darrell Brooks, probably another day or two, maybe at the most. And then we need to be discussing what we're going to do next because there are a couple of trials getting ready to start. One has started that, can't remember his name. He stabbed his girlfriend. It's on Law and Crime. But anyway, yeah. Let's get started with Darrell Brooks. Day number 13. Day number 13. He's getting his papers all in order. Yeah. So he can look all important. He can look all important. Yeah, that's the one, Tanika, Chin. But there's one that's coming up that should be starting this week, and they're dubbing it the Rose Petal Murder. That one looks interesting. And then there was another one. can't remember what it was about, though. I'd have to go back and look. Let me scooch. Okay, here we go.
I don't.
A mask.
Getting all of his readies ready.
Morning, Judge Sue Upper, Leslie Basie, and Zach Waukesha appearing for the state of Wisconsin.
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value in return for value all of the charging instruments in this matter and make my exemption available for the discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and make a reservation of all my rights here this morning. All rights reserved.
All right, good morning.
All rights reserved.
As well, the records reflect the individual.
This reminds me, too. We'll read it here in a little bit, but you guys remember Glenn? I think his name is Glenn Johnson that's been in our chat the last few days. He made a replay. On the replay, he made a really nice comment. It was a long comment that goes into depth about why Brooks did what he did. It was really good. It was a really good, it made me kind of understand some things. So I thought that would be good to share with you guys here in a little bit. Dog Mom says, Tanika, I loved it on New Year's Eve how we went over the Sarah Boone trial. That was such a great night. And I love it when we go over old trials because we all know that they're in prison, right? They should be, Lisa. I'm assuming they are. I think I read earlier that they were not live streaming the jury selection, but they should be streaming the trial, I'm assuming. Dog Mom says this jack wagon right here makes me having the flu feel like I'm laying on a beach in Hawaii. He does sound like an infomercial. All rights reserved. Dog Mom's saying it's a different experience when we aren't worried about the verdict, right? That's true. Very true.
Known to this court as Darrell Brooks is present in person in custody. However, he is wearing street clothes, a suit and tie, and a mask.
And for the record, I don't consent to being called to the name.
It is noted.
It is noted.
All right, Mr. Brooks, just preliminarily, do you anticipate calling any additional witnesses today?
For the record, I don't consent to being called that name. And what was the question?
Do you anticipate calling any witnesses today?
I don't believe today.
Well, we are here for the continuation of testimony. The only witness that I'm aware of that's on your list that you added is your mother, Dawn Woods. So I would expect that if she's going to testify, she would be here. Otherwise, I will be going through the colloquy with you as to whether you intend to testify today or not.
Did you receive my ICS that I addressed to you?
Oh, I haven't looked. Let me look.
Actually, I just went to you and then went to the prosecution. Is the audio on?
It is.
Glenn, hey, no. Don't say you're sorry. I loved it. I was just saying in here a minute ago, I don't know if you missed it, but I literally just said Glenn made this amazing comment on the replay. And I want to share that with people here in a little bit. When we get to another little breaky break, which probably won't be very long from now, because, but yeah, I want to read through that because that was a great comment. It was very informative. So I appreciate that you left that.
The audio's on.
Hey, Sharon. Dog mom, I don't, did the daughter wasn't.
Saturday.
Nothing happened to the daughter, right? Tanika?
So that would have been the 22nd.
It was just the mom, right?
State receive anything through, like, the inter-office communication?
We have not, I just checked this morning to see if there's anything new. Nothing has been received at my office. And I should say the clerical that was assisting me went to the mailroom to double check. So not only has it not made its way to the DA's office, it hasn't even made its way over to the mailroom.
I can email the jail administrator to find out if there's anything in transit, if there's no objection from the parties, from the state,
No objection?
from you, sir.
No objection. I definitely want those documents received that they obtain.
I'm going to put it on
important information.
1.25.
You said you forwarded them to a staff member on Saturday?
Yes.
Do you know if that was morning, afternoon, or some other time?
Maybe afternoon.
And those are 2 ICF forms?
Yep, one addressed to you directly and one addressed to the district attorney's office.
Oh, I got you, dog mom. Gotcha.
Alright, I'm sending that. I will send it with high importance and we'll see what response I get. But I don't have anything. If you want to generally tell me the topic, we can cover it verbally.
The topic is pertaining to exculpatory evidence. Some things were learned, and once they came to my attention, I felt the need to immediately address the court about this information.
All right, what information make an offer of proof for me, sir?
The expert witness for the prosecution in regards to, I believe it was.
Oh, shoot.
Inspected.
Her biological daughter's name, it's a shoot, it's such a pretty name too. Somebody will remind us in the chat what Letitia Stouck's daughter's name is. It's right on the tip of my tongue, and she's beautiful, might I add. Her daughter is stunning. Hey, Kelly, good morning. Good morning. He can be so nice when he thinks he has something on the judge and DA, right? Hello. Harley. Yeah, it's Harley. That's it. Lisa said Haley, and I was like, that sounds right, but it don't sound right. But Harley is it. Yeah. Very cool.
In the vehicle, Officer Ryan Schultz, question was asked of, did he know if there were any recalls on that vehicle?
Oh, here we go on the recall thing.
I believe that a Brady claim should be visited because there were, in fact, recalls on that vehicle. In fact, there were recalls on the Ford Escape models from 2008 through 2010 in regards to the throttle body malfunctioning and causing the vehicles to accelerate and not being able to be stopped. There is a class action lawsuit where Ford Company were sued because of this, and those vehicles models from the year 2008 through 2010 were recalled, and that is very important information in regards to the vehicle in question being a Ford Escape 2010. This information is very easily obtained just by pulling it up, and you'll see a class action lawsuit. Obviously, if it's a class action lawsuit, then it's pretty easy to.
So what's your request, sir?
My request is
No worries, honey. Lurk and work away.
to find out
Work
if
and work
Officer
away.
Schultz knew, to find out if the prosecution knew that there was a recall on those vehicles,
Hi, Susan.
and in light of
Susan's having a struggle.
the fact that these vehicles were recalled because of this malfunctioning throttle body. For
Tanika, or not Tanika. Susan, that's how I am. My phone hates me.
counts 1 through 73 to be dismissed.
All right, what's the response from the state defendant?
Thank you, Your Honor. As Trooper Schultz testified during his examination, consistent with our research, there are no active recalls listed for the Ford Escape. As Trooper Inspector Schultz noted during his testimony, that Ford listed an extended warranty for the throttle body on the Escape. The warranty was extended to 10 years of age and 150,000 miles. The Escape is more than 10 years old and has more than 150,000 miles. Also, he noted specifically in his report that he did not note any defect in the throttle body as previously described in this report. There was no recall in the throttle body. NHTSA did do an investigation into allegedly defective Ford throttle bodies, which would have impacted this year. Basically, the electronic throttle body failures would have resulted in engine stall.
Thank you,
Or
Susan.
surge while entering traffic from a stop position or while driving at highway speed.
She is wonderful.
Neither of
Sorry
which
for that
I believe
loud,
occurred here.
obnoxious
Further,
noise on
Inspector
my phone.
Schultz would testify that that does not prevent the brake from working. So if this had been activated on this car, which it was not, but if it had been, and this defendant would have pushed down on the brake, it would have stopped the car. Further, if this was a problem, there would have been the malfunction indicator lamp or the wrench light would have been illuminated, as Trooper Schultz or Inspector Schultz testified when he started the vehicle and checked the indicator lights. None of them were lit. Further, if there was this, he would have observed material buildup on the commutator. There was no such buildup observed. There were no problems with the throttle, electronic throttle body.
Right.
That was part of his report. Therefore, this is, although there may have been some cars who had this problem, the car that the defendant was driving on this day did not have that problem. That was testified during the vehicle inspection. The defendant had the opportunity to cross-examine Inspector Schultz with regard to that. And again, in running the defendant's mom's VIN number through NHTSA.
Michelle, thank you. I appreciate that. I am very appreciative. You don't find people do that very often. You know what I mean? And Tanika described it perfectly yesterday when she said that it's not like a lot of us are not like rivals or competition. You know what I mean? That's not, you know, there's a lot of other people out there that do trial coverage, and like she said, people just have a different view of it, a different way of looking at things. The commentary is different. There's just a lot of that, a lot of different personalities out there, and yeah, I think it's important to lift other people up, you know. And I appreciate that she did that. I really appreciate that. And I appreciate that she knows that she feels safe to send her people to me. You know what I'm saying? So that makes me happy. Definitely not Sharon, right? Thank you, Michelle. I appreciate that. I like the homey feel. I like that. That's why I called it the Crime Cafe, because I said initially I wanted it to be a place where we could come together like a cafe. You know, I love coffee. That's a big reason why I called it the cafe. For people to just hang out and chit chat about crime and watch these trials together. Yes, Miss King, exactly. I watch different creators on the same subject. I like different views. Kelly says I've stopped following content creators who have a don't mention other YouTubers on my channel. It's gross. Yeah. Yeah. Yep. Thanks, Michelle. Yeah, I love our people here. I love our people.
Highway Traffic and Safety, I think, Administration.
Margaret.
There are, for this particular VIN number, for this car that
Margaret's
was
our
driving,
resident
0
spiller and
unreported
dropper.
recalls. So it's a mood issue.
I don't believe it's a new issue. And I actually have
Ooh, wow, look at
it
that.
should, the report should be in the mailroom as we speak. I had everything sent over already
Really?
mailed, the actual information about the class action lawsuit, the actual information about the recalls for those models, like I said, 2008 through 2010. Now, in all fairness,
Hi, Tara.
Your Honor,
Hi and welcome.
that's why I was asking for a Brady claim on this.
So is this
Seeing as how
online?
When
Too, or
vehicles
just
are
local,
purchased
Dog
from the
Mom?
manufacturer, they're still sold as is. There would be no way to know that there's anything malfunctioning with the vehicle until it actually happens. And seeing it's a class action lawsuit, no one would sue the Ford company if there weren't malfunctioning vehicles. There would be no class action lawsuit if these vehicles were not malfunctioning. And I believe with that, like I said, the information is easily obtainable. I should have the information in the mailroom right now.
Here, hold on, I'll fix that.
You can
I'll fix that,
readily
Gail. Hold
view
on.
this information about the class action lawsuit, about the recall. It wasn't just the 2010 model in question. It was 2008 through 2010. The information about the malfunctioning pertains strictly to the throttle body.
Let me address your claim, sir. So, not trying to cut you off, I don't need the specifics about a class action because
Class action. Here we go. Chilling with my homies. Chilling with my homies. There we go. How's that, Gail? Is that good? There we go. Hold on. There we go. Hold on. Let me get my my Gail gabble. Whack, 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 whack. Whack. A little sideways. There we go. Okay. I haven't worn this in forever, by the way. I bought this in New York whenever me and my goodest, bestest friend Grace from Australia went to New York. I haven't worn this in forever. All right, let's go.
as it relates to this case, the fact that there's a class action would not mean there's a Brady violation by the state. In fact, you even indicate it was readily known and something you were able to find out. I'd further note that you had a full and fair opportunity to cross-examine the inspector regarding his mechanical inspection. It's not new information. And more importantly, as it relates to this particular vehicle, based upon the testimony of Inspector Schultz, it's speculative as to whether this vehicle would be impacted, number one, by the class action, and number two, any throttle body problems. Because again, there was a full inspection. That report was provided to you. He testified on direct examination about there being no active recalls. And more importantly, he testified about what impact the throttle body would have and what he would expect to see if there were any issues with it. I am aware that the ICF, I did receive an email, it's one page with what you said. I have to turn my head, I gotta figure out how to flip it. So give me a second.
Okay. And just for the record, Your Honor.
Hold on, let me finish my record, okay? So I'm gonna turn, because so I can read, it says, your ICF says the state's expert witness who did the inspection on the vehicle in this incident needs to be recalled no later than Wednesday. I just learned of some information that is extremely vital. I understand the information that you're providing me, But again, you had a full and fair opportunity to cross-examine this witness. This information was apparently well known. I'd also note the vehicle's registered to your mother. And from my understanding of recalls, I think what is common knowledge is that a registered owner would receive information regarding the recalls and what to do. And presumably she would have provided that information to anyone operating that vehicle or taking care of it. We have none of that information before us by way of fact or even an offer of proof that even she received that information and did nothing with it, or whether anyone else who operated that did anything with it or not. The bottom line is there is absolutely no Brady violation by the state. This is not the type of information they would have been required to turn over. And from my understanding and review of Exhibit 83, what's important to this case is that the mechanical inspection specifically looked at that issue nonetheless and found that as to this particular vehicle, there were no issues with that would have impacted the mechanical function during the incident in question. I'll accept the state's offer of proof as to what would have been the issues based upon the information provided. And again, without anything further from you by way of your offer of proof, I can't make a finding, number one, that there's a Brady violation, and number two, that the information you seek to cross-examine him on would have any impact whatsoever. So I'll deny the request to dismiss the case, and I'll deny the request to recall this witness.
Hold on.
Hold on. Let me have the state just make their statement. I'll give you the last word on it. Go ahead.
The Inspector Schultz's mechanical inspection report was provided to the defense on April 29th, 2022. I noted that when the defendant was cross-examining Inspector Schultz, he did have the report in front of him and was asking questions directly related to information contained in that report.
Gotta
Right,
do that
go ahead,
snow
Mr.
angel, right?
Yeah, when you spoke to the owner of the vehicle, that's who gave me the information. My mother gave me the information of this. I had no knowledge until she told me. And that's how I came into the information. And she was the one that said, I'm going to send you all the information that you need
Hey, Sheree.
so you can present it to the court. So
Great
I
to
didn't.
see
I
you.
understand that, sir,
This
but
wasn't
your request
information.
is not timely. So you have had this information for quite some time, either through
I
counsel.
did not have it for quite
Let
some
me make
time.
my
It was
record,
just,
either through
it
counsel.
was just told to me.
That's not what I'm saying. You've had the information about this report for quite some time, either through prior counsel or through all of the discovery that was turned over to you when you took over your representation of your own case. The fact that you have now learned this, it's a little bit too late. And I understand that may seem fair to you, but even when I consider the information that you're providing to me, it's speculative on your part as to whether there's any impact on this particular vehicle because of the inspection that was done. And you had a full and fair opportunity to cross-examine the inspector about information that was readily obtainable and researchable by you prior to the time that you cross-examined this witness.
It was not readily available for me to expect at the time. I don't have access to the internet. So how would I be able to?
Mr. Brooks, you're telling me your mother had that information.
No,
So,
I'm
and I'm
telling
going to
you, she
trust.
just told me this information. I have the phone calls to prove it.
I understand that. I'm denying the request, sir.
And I would like a.
So that's my decision.
I object to that, Your Honor.
I understand.
I
I've made
object
my
to that.
decision. I expect that you respect the decision, at least
No.
as we're not going
He's
to
like, oh, no,
debate
no,
it
no,
further.
wait,
Yes.
wait.
I now have the
It needs to be-
ICF,
it
the
needs to
one
be
for the state
addressed,
that
Your
provided
Honor.
for the state.
It
Madam
needs to
Clerk,
be
I just gave
addressed.
that to you. All right, so
I
Mr. Brooks, in
respectfully
light of that,
object. I respectfully object, Your Honor, and request the legal reconsideration of your ruling, Your Honor.
it's denied. The request for reconsideration is denied. There's no legal basis for me to do
I
that at this point.
respectfully reject that ruling and take exception to that ruling, Your Honor.
All right, Mr. Brooks, we need to keep going.
For the record, may I request a legal or factual basis for your ruling, Your Honor?
I provided an oral ruling today. The record stands, sir.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law on this issue?
Your request is denied.
For the record, may I respectfully move for an interlocutory declaratory appeal of this matter?
I wouldn't be the one you would make that request to, sir. So I
For
can't
the record, may I
answer that
move
yes
to
or no.
stay these proceedings until the instant matter is adjudicated by a court of competent jurisdiction?
That request is denied.
Based on what law and fact, Your Honor?
The request is denied.
Based on what law and fact, Your Honor?
Any other requests, sir? I'd like to move on.
Based on what law?
There's no
Or
legal
fact.
basis that you've stated for me to do that, sir.
It has been, Your Honor.
The request is denied. The request is not a proper motion. There's no legal support for the motion. There's no factual support for the motion. So it's denied.
For the record, it appears that this court is acting in contempt of the law, Your Honor. Can you show me how or where this court is following the law of respecting this matter?
That's a very vague statement, sir. There's no legal relief that you're claiming. There's no motion before the court based in law or fact. So this court cannot address that last statement of yours.
Your Honor, with all due respect, I would like a motion for finding of fact.
Denied.
Under what law, fact?
I made an oral ruling, sir. There's no requirement I do so in writing.
So you're denying a legal, you're denying a motion for finding of fact.
I am.
So how do I know what you're doing is legal, Your Honor?
All right, Mr. Brooks, we're going to move forward. At this time, I want to,
How do I know that this is legal, Your Honor? Can you show me that it's legal?
Mr. Brooks, we're moving forward. So your
Doesn't
request
seem
is
like
denied.
it doesn't seem
Mr.
like
Brooks,
you're-
I need to give you some
It
advisements,
doesn't
and
seem
I
like
ask that
you're,
you
I
stop
don't need
interrupting
your
me.
advice.
No, I have to
need
give you
you,
advisements, sir, regarding
I
your
need
right
you
to
to do,
testify.
I need you to do your job without prejudice and without
Mr.
bias.
Brooks has now interrupted me multiple times. He's failing to respect the court's oral rulings here today. It's something that he's done repeatedly throughout this trial. Mr. Brooks, I need to go through some advisements. Unless you have a witness to immediately call, I need to go through this particular discussion on the record with you regarding your right to testify.
You don't
Do you
need to
have
go
a witness
through,
to call,
you don't need to
sir?
go through anything with me on record. You need
Actually,
to-
I do so,
Actually,
sir.
you
That is
don't.
required by law.
Actually, you don't. You need to do your job as a public servant.
Mr. Brooks,
and honor the oath that you
I
took,
need to go
Your
through
Honor.
these advisements, and if you're going to keep interrupting me, you will forfeit your right to be present, and you
So
will
you're
be
holding me in
removed to
contempt
the next courtroom so that I can properly go through these advisements without being interrupted.
And I still don't have to answer. I still don't have to answer whether I'm in this court or not. So you're holding me in contempt yet again.
Mr. Brooks, I have not held you in contempt. I've found that you have forfeited your right to be present by your conduct, which is one of the options available to this court under Illinois versus Allen, under State versus Vaughn. It's also referenced in State versus Anthony. So I am going to keep going, sir, despite your protestations.
Your Honor, with
I
all
need
due
you
respect, in
to
Illinois
not
versus
interrupt me.
Allen, in
This is
Illinois
another
versus-
interruption.
In Illinois versus Allen.
Mr. Brooks,
do
I'm
they
not
say-
going to have a debate with you on
I'm
the
not
meaning
trying
of
to have a
Illinois
debate.
versus
I'm not
Allen.
trying to have a debate.
You are
I'm merely
advised
trying
that
to
a
understand
continued
Illinois versus Allen.
Mr. Brooks, you are advised that continued interruptions will result in you forfeiting your right to be present during this next phase of the trial.
Okay, but you saying that I'm
I've said
forfeiting
that
my
multiple
right.
times.
You
I've
saying-
given you multiple
You're
opportunities to
holding
stop
me in
interrupting
contempt. You're
me.
holding me in contempt.
Mr. Brooks,
By
I'm not holding
removing
you
me
in
from the
contempt for
courtroom.
the second time here, and I've
Your
also
Honor,
repeated that.
Your Honor,
He's
with all-
interrupting me yet again.
with all
Mr. Brooks, I
respect-
need you to stop talking.
With all respect, in Illinois versus Allen.
All right, Mr. Brooks continues to want to debate with me the meaning of Illinois versus Allen. It is a clear indication to this court
trying to
that
understand,
he
Your
wants to disrupt these proceedings, even
That's
in
not
a
true.
mild manner tone
That's
of
not
voice.
true.
I've
I'm
reminded
seeking
him
to
repeatedly
understand, Your
regarding
Honor,
the standards
because
of
it
form
doesn't.
and civility, and one of the
Illinois doesn't.
bedrocks is that he
Illinois
not
versus
interrupt.
Allen does not state.
All right, I'm going to
that-
remove him to the next courtroom so that I can go through
It does
proper
not state-
advisements with him without being
It
interrupted.
does not
We'll clear the
state
courtroom
that
and
you
we'll
can be
resume
present from
once he
cameras.
is over there.
If
Again, I'll
it
make
doesn't
the
state that
appropriate
you can be
findings when
present
he is
from
there.
cameras, or that you could be,
Yes, we're off the record.
or that you
until,
could be.
he's in the
Okay,
other
so
courtroom. I'll
you're
be
making a
stepping
tacit
off.
agreement for something that I.
Lord, 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 Lord. All right. He does have zero critical thinking skills, 100%. He certainly has none. Right, Susan? Me too. Me too. I was like my mouth, my jaw stayed on the floor 99% of the time throughout this trial when I watched it live. Yeah. I was like, oh my God, is this for real? The poor court reporter. Tacket agreement, yeah. Love that. Yes. Absolutely. Yep. Yeah, here's my break, Glenn. I'm getting ready to go find that. I'm going to go grab that comment and read it. Give me a second to go find it. All right, so this comment from Glenn Johnson, who's in the chat. He posted this on trial day 10 on the replay. And it's a really good read. I'll try to read through it pretty quickly. It says, I apologize in advance for this long explanation, but let me best try to explain Brooks' defense and why he asks what he does. We all know he has claimed sovereign citizen, but why is he asking what he's asking? 1, he's asking about the plaintiff because according to Sovsits, the only way they can be prosecuted is the plaintiff has to be a living, breathing human, not an entity. So therefore, the state of Wisconsin versus Brooks, in their minds, is faulty. Number 2, Sovsits don't believe that there is criminal trials. All of it is civil. And this entire process is just a way to steal his trust that is in a secret account totaling over $1 million or something to that effect. Now, is that true? And if so, where did that come from? So therefore, the witnesses testifying against him have a financial interest in testifying. Number 3, subject matter jurisdiction. In Sovsits' minds, the courts will never be able to prove subject matter jurisdiction because 1, he has not consented to the laws of the state. As a sovereign, they only recognize the Constitution. 2, he has not gotten into a written or verbal contract with the state, so therefore any laws they claim he has violated are irrelevant because since he hasn't provided written consent, he's not bound to state laws. Number 4, his name. Sovsits believe in the straw man theory. There's 2 of you, the corporate you and the name that appears in all... Wait. Let me restart that. Sovsits believe in the straw man theory. There's 2 of you, the corporate you, which is the name that appears in all capital letters, and the real you of flesh and blood. They do not consent to being referred to as the name in all capital letters because that is not them, that is the corporate entity that the state has created upon birth. That straw man is responsible for all legal obligations, etc., and the real you is not. That's just crazy to me. That's just crazy to me. All of this is not, this is the end of Glenn's comment. It says all of this is nonsense, but Brooks has taken comfort in this comic book reality because he doesn't want to face reality that there is nothing that will get him out of what
Madam
he's
Clerk,
done.
may I please get verification that the audio and video are working?
This was a desperate attempt by him to delay the trial cause a mistrial or something. In the past, he has been able to get out of serious charges because of a speedy trial violation. And he was hoping to do the same thing here. But there was no way to get out of this, and he knew that from day 1. Excellent comment. With lots of information. And I really do appreciate that, Glenn, because I mean, I knew that all of his shenanigans would was surrounding the whole sovereign citizen thing, but I didn't understand the little aspects. Lisa says they also believe that their social security number is money. Wow. Let me see. Tanika said, by that logic, no one would ever be held responsible for unaliving unless we're hearing testimony from the great beyond, right? I know. Let's all go get, what do they call those things that static comes through, like in that movie Frequency? I love that movie Frequency, by the way. That's a pretty cool movie. But those let's go set one of those little spirit box things on top of the thing and see if something comes through. it was a really great explanation, right, Patricia? Yeah. If only soft sit spent as much time understanding the actual law. Patricia said there's also two me's. There's a customer service voice Patricia and regular Patricia, right? This is my normal voice, but when I have to call to pay a bill, I'm like, hi, this is Jenny. I would like to pay my electric bill over the phone. Thank you. I don't really do that, but I probably have in the past. I think we all have that normal voice and then that customer service voice. Detective Casey, who is on this case, also was on the strawman case. Jeez. His mom, I remember hearing that his mom used this soft sit nonsense during a traffic case. Good Lord. Excellent, right? I loved it. If Darrell Brooks has a trust, why was he sleeping in his mama's SUV? Well, it's a situation where he can only get into it like every so often. Do they also believe they don't have to work? I don't know. License place. They never want a contract with the government, but yet when they're handing out benefits, they're first in the line. I want to know where the trust came from, you know? Like, he has $1 million trust? For what? And do his kids get the money now since he's going to be in jail for 1 billion years? She had a boyfriend who was coaching him? Oh, okay. Wow. All right. He will want that trust added to his commissary. Sharon says there is no trust. It's pretend. Tanika said Darrell used Erica's food stamps. So somebody contracted with the government and taxpayer money, right? Jeez. He's ridiculous.
In the neighboring courtroom.
Okay.
All right, thank you. I do have verification. There are headphones on the table in front of Mr. Brooks should he choose to wear them. I see he's reading from a book at the moment. I do need to make a record that this morning, although Mr. Brooks was not raising his voice, there were repeated interruptions. He wanted to debate rulings that I made after the fact. Just this morning alone, about 26, 27 different times he interrupted me or spoke over me. Once I made a decision on his motion to dismiss and his request to recall a witness, he then asked if for written findings. I denied that. He then asked for what law I was following. I indicated I wouldn't explain that further, that I already made an oral ruling. He
As
asked
it
for,
should, Sharon. Yeah.
a stay. He asked for dismissal. All of those things I either denied or said I wouldn't answer,
it is, Kelly.
specifically as it relates to the request for an
Boxport
interlocutory
Day.
appeal, since I would not be the judge or court to which a request would be made. That is something that would be made to the Court of Appeals. And although I would have authority to grant a stay pending appeal, there is no appeal that's pending. I gave Mr. Brooks multiple opportunities to stop talking. I asked him repeatedly to stop interrupting me. I advised him that if he continued, he would forfeit his right to be present in this courtroom and would be taken to the neighboring courtroom I believe I gave that warning at least twice. Of course, this comes on the record before this court over the first 15 days of trial, where Mr. Brooks has, by his conduct, forfeited his right to be present on a number of occasions due to his conduct. I do appreciate that this morning he didn't yell at me, he didn't raise his voice, he didn't speak in an angry tone. But given the history in this case leading up to today, and knowing what this court needs to get through in terms of whether he has any witnesses or whether he intends to testify himself, there's a very important colloquy I need to have and an advisement of his rights that I need to go through, and I simply am not able to do that with him constantly interrupting me and then not respecting the oral rulings that are made. Of course, at any point in time, Mr. Brooks can ask to be brought back over to this courtroom under Illinois versus Allen. Of course, he needs to pledge that he is willing to conduct himself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. Of course, I've repeatedly, even without him making such a pledge, brought him back into the courtroom where I felt a sufficient time has passed, and he at many times has been able to conform his conduct. I would note during the vast majority of the testimony that was provided during the state's case, he was in the courtroom, if not during the entire time. He was able to cross-examine witnesses. We had a couple of issues during the testimony of witnesses he called. And of course, last Friday was, in my opinion, probably one of the most challenging days, I should say, to date. It's my hope that we can continue with Mr. Brooks in this courtroom. At some point today, I'll certainly invite him back over when I get through these advisements. Mr. Brooks, you have been muted. I will make that, put that on the record as well. I will unmute though and ask Mr. Brooks, because you did not answer the question previously, other than you potentially testifying on your behalf, do you have any other witnesses present at the courtroom, at the courthouse to call today? I need an answer to that question, sir.
So we addressing subject matter jurisdiction that we haven't addressed when I was just over here, or since I've been over here? Are we addressing subject matter jurisdiction?
I'm going to mute him just for a second. No, I'm not going to address subject matter jurisdiction. This is a common ploy by Mr. Brooks. When I attempt to go through certain things with him, ask him questions, he tries to divert our attention away to subject matter jurisdiction. I have issued a written decision on that. He has not filed any type of interlocutory appeal regarding that. This court's position is there is subject matter jurisdiction, and I'll deny verbally and orally at this point his request to dismiss the case based on a lack of subject matter jurisdiction. Mr. Brooks, I will be asking you a couple of questions. I do need a response. I am unmuting you. Do you have any other witnesses other than yourself available at the courthouse to call this morning, meaning now?
This is the jurisdictional challenge right here. So are you going to address subject matter jurisdiction and prove it for the record or not?
So I've asked Mr. Brooks twice now whether he has any witnesses to call other than himself. He has declined to answer that question. Sir, if you fail to answer that question, I will interpret your failure to answer that as a no, and you will lose the opportunity, you will forfeit the opportunity to call any other witnesses on your behalf other than yourself. So I will ask you one last time, sir, do you have any other witnesses at the courthouse available to testify right now? I'm not getting a response at all.
Am I unmuted?
You've been unmuted, sir.
You just said I was muted, so I'm not sure. I don't know when you muted me or when I'm not muted.
Well, me muting you doesn't affect you being able to hear the court, because
Yes, it does.
that only
Yes, it does.
mutes your audio coming into this courtroom. I confirmed already
Why is my
that
audio muted to begin with?
that is simply a misstatement. I confirmed with the bailiffs that the audio and visual were working.
Why is my audio muted to begin with?
Because you interrupt the court repeatedly. So I'm going to ask you yet another way, even though for 3 times now he has failed to answer this court. You indicated last week that you would like to call your mom as a witness, Dawn Woods. You were provided with notice that the state would not be assisting with that in any way. You indicated when that was said that if you wanted your mom to testify, she would obey you and she would be here. So I trust that you've made arrangements for her to be here. Are you going to call Dawn Woods as a witness this morning, and specifically now? I will ask him a second time. Sir, do you have Dawn Woods available to call as a witness this morning? He's been unmuted for a while now. We can obviously hear him. I will ask Mr. Brooks a third time for the record. He's finally putting on the headphones. Is Dawn Woods in the courthouse available to testify right now? Do you intend to call her?
Hold on.
For the record, Mr. Brooks only puts on the headphones when he's in the other courtroom. He does not put them on when he's in here. The audio and the visual work just fine in that courtroom.
When I'm in the actual courtroom, I can hear it. I don't need to be muted.
Mr. Brooks' statements that the audio doesn't work when I mute him is simply false.
I didn't say nothing about the audio not working, so you need to stop lying on the record.
I'm not lying on the record, sir.
You are lying on the record.
All right, I'm going to mute him once again because now he's raising his voice. Now he's angry. He's thrown the headphones.
Yeah, now's when he throws a fit.
He certainly does not seem to want to answer any of the questions this court has. I asked him 3 times if he had any additional witnesses to call. I warned him that if he did not answer that question, he would forfeit his right to call additional witnesses, other than perhaps himself. I then specifically asked him about Dawn Woods, because that is the person he indicated he wanted to add to his witness list last week, and I granted his request to do that. I asked him twice. He did not respond to that. Based upon his failure to respond, based upon this court advising him that if he failed to answer that question, he would forfeit his right to present any additional witnesses, again, other than perhaps himself. I'll find that he has forfeited his right to present and call any additional witnesses based upon his conduct in this case. I would direct Mr. Brooks to the case of State versus Anthony, although that squarely dealt with a person's right to be themselves a witness in their own case. They talk at length in that case about how rights, even constitutional rights, can be forfeited by conduct. Of course, the right to be present can be forfeited by conduct. That was established in Illinois versus Allen. And then the right to present evidence on your behalf can also be forfeited based upon conduct. Although a criminal defendant does have a right to present a defense, doing so must be guided by the rules of evidence, the rules of procedure, and also with respect for the dignity, order, and decorum that is needed in the courtroom. Mr. Brooks has demonstrated this morning that he is not willing to answer simple questions about calling witnesses. He reverts back to raising the issue of subject matter jurisdiction, which, as this court has previously found, I believe is simply a distraction tactic, a delay tactic, and a disruption tactic. When considering that the court must be concerned not only with the defendant's right to present a defense, this court must balance that with preservation of dignity, order, and decorum, and the numerous procedural and evidentiary rules that control the presentation of evidence. Because in my findings today, Mr. Brooks has been unwilling to answer simple questions regarding the calling of witnesses. Again, I'll find that he has forfeited his right to present further witnesses. I would like to go through a number of advisements with Mr. Brooks regarding his right to testify. I will unmute him for that. I ask Mr. Brooks to put on his headphones if he is unable to hear me, and just to be 100% safe and secure on the record, I'd ask the bailiffs who are over there to advise him. I'm going to directly be speaking with him, and if he's unable to hear me, to put on the headphones at this point.
Mr. Brooks, you're unmuted.
He's unmuted.
You're unmuted. Just keep directing to you on the microphone. I'm here. Can you hear that?
I've also been advised by not just the bailiffs who are over there, who I can hear through the audio, but also from the clerk who's in that courtroom, through my clerk who's in this courtroom, that the audio is very loud and clear. Mr. Brooks, I would like to go through with you your right to testify and your right not to testify. We are at the stage in the proceedings where it is important that this court conduct a colloquy with you. I will advise you that if you refuse to answer my questions, refuse to acknowledge me, you can forfeit your right to testify on your own behalf. Again, that's State versus Anthony, 2015, Wisconsin 20. Mr. Brooks, you need to be aware and are so advised that you have a constitutional right to testify. Did you hear me say that? There's no response by Mr. Brooks, and he does not have the headphones on, and he has a book in front of him, although I haven't seen a page turned. If you testify, sir, the state has the right to cross-examine you. That means to ask you questions after you give your initial testimony. Did you hear me advise you of that? No response by Mr. Brooks. Sir, you also have a constitutional right not to testify. If you decide not to testify, you are further advised that doing so cannot be used against you, and I would so advise the jury. Did you hear me advise you of that? Once again, no response by Mr. Brooks. The decision to testify is for you and you alone to make. Did you hear me say that? There's no response by Mr. Brooks. It's my understanding that Mr. Brooks has the equivalent of a 12th grade education, that he attended school either up to or through 12th grade, and either has a GED or an HSED. There's been some conflicting information on paperwork throughout this case, but I'll find that he does have a high school education. He is currently in custody, of course, at the Waukesha County Jail. I'm not aware of any medication that he has been taking. Sir, have you taken any medication within the last 24 hours, or any drugs or any alcohol? I'm not receiving a response to that. I'm aware that he's able to read and write English. I would refer back to the record made during my colloquy with him regarding the waiver of counsel and his ability to be aware of rights, his ability to, I made a finding at that point of his understanding, and based upon his conduct throughout this trial, including the waiver of right to attorney hearing, I'll make a finding that he has the ability and understand, he can read, write, and understand the English language.
Am I unmuted?
You've been unmuted the entire time, sir.
So what are you talking about? Is you talking about subject matter jurisdiction and how you going to verify it on record?
So he did not answer my question if the record's not clear about whether he's had any drugs, alcohol, or medication within the last 24 hours. I'll ask him, sir, has anyone made any threats against you to influence your decision on whether to testify on your behalf in this trial? Although he turned and said, what did you say? Again, I believe he's fully able to hear this court at this time based upon how the audio is functioning in the other courtroom. He did not respond to that. Has anyone made any promises to you to influence your decision?
So if you can hear me, I don't hear everything you're saying, and you know I don't hear everything you're saying, so cut the crap.
Mr. Brooks has interrupted with very disrespectful words at this moment. I believe that he is feigning his inability to hear and that he's done so throughout this case. There's absolutely no indication. He puts the headphones on when he wants. He takes them off when he wants to. While in this courtroom, he hasn't had them on. He's only used them while in the other courtroom. But again, I've confirmed multiple times that the audio is loud and clear. And his statements that he can't hear, his statements that when I mute his audio, that it mutes his audio, are simply false.
Hey, Morgana. Good to see
Mr. Brooks,
you.
have you made?
Am I still unmuted?
You are, sir. And I'll make a record that per the lieutenant over in the other courtroom, the volume is 2 to 3 times louder.
So I was over in Canva just now, and hold on. I finally got it added like I wanted to. This is Darrell Brooks currently, only I hate to say that because I love this little girl. Right? She's my favorite GIF ever on planet Earth and everywhere else. But you also know that that is Judge Darrow when she goes back to her chambers. Right? She's my favorite. I love her so much. But now I've got that little GIF in StreamYard, so I can play it. I don't know. We'll see. YouTube might be like, no, and like copyright me. But anyway, I love it a lot. I feel that way a lot of the time. Yeah, he doesn't know what the word feigning means. No.
Than it is in this courtroom.
You need to stop making false records saying that I said I can't hear you at all. I said I have trouble hearing you when I'm
He
over
probably
here.
thinks it means
That's what I said.
fainting.
So I would appreciate if you would make the record clear and correct.
clearly he heard me say that for him to make that distinguishing statement.
I'm sitting right
So,
here. Don't you see me looking all up to the microphone so you can hear me?
I don't have an issue hearing you at all, sir.
Can you hear me when I'm right here?
I can. Once again, per the lieutenant who's been in both of these courtrooms, the volume in the adjacent courtroom where Mr. Brooks is at is 2 to 3 times
Margaret,
louder than
get
it
out
is
of
in
my
this
brain.
courtroom. Mr. Brooks, have you made a decision?
What about this courtroom?
Have you made a decision to testify in this case?
No. Have you
Get out of my brain.
made a decision
Dun,
to tell me?
dun, dun, dun.
I'll ask you again, sir. Have you made a decision to testify
Have you made a
in this
decision to
case?
address subject matter jurisdiction? Have you made a decision to be impartial? To answer what your name is? To answer if you have a claim against me? If
I'm going to mute him for the moment just because, once again, he's attempting to divert away from what this court needs to do by going through the proper colloquy with him regarding his right to testify. He is asking me about subject matter jurisdiction. He's making statements about this court that are disparaging and about my oath. Again, a clear attempt, in my opinion, to simply stall these proceedings and to disrupt them. I will unmute him and I will ask him for a third time with the understanding that if he fails to answer the question in the affirmative, I will interpret his failure to respond as a no and that he is not going to testify. So once again, I am unmuting him. Sir, have you made a decision on whether to testify in this case? There's no response by Mr. Brooks. I will ask it yet another way, sir. Do you want to testify on your behalf in this case?
Am I unmuted?
Yes, you have been. Sir, do you want to,
How long have I been unmuted? 'Cause you just
sir, do you want to testify in
You
this
just said you
case?
was muting me when I had the headphones on just a minute ago. You just said you was muting. So when have I become unmuted? Or did you even mute me in the first place?
Mr. Brooks, I'm asking you one last time. Do
didn't
you
ask
want
me
to,
nothing because I haven't heard nothing that you asked. So how you gonna ask me something and then just answer for me?
Mr. Brooks, do you want to
You can't answer
testify?
for me.
All right, I'm
You
going
can't
to
answer for
answer,
me.
I'm going to
You
move
can't
him
answer
again.
for me.
Again, it is very clear to this court that he uses the statement that he can't hear as a means to delay. It's a distraction. It's very evident that he hears this court and that he's choosing to willfully not answer this court. This court, as I indicated earlier, is tasked with the duty to ensure that there is efficient and effective presentation of relevant and probative evidence in this case. This court is attempting to go through the needed colloquy with Mr. Brooks, and he at all times during this colloquy has refused to answer simple questions. I personally do not want to make this more difficult, but I must establish these ground rules that he must answer these questions in order for this court to make the appropriate findings. Without him providing answers, this court is left with no choice but to find that he is forfeiting his right to testify on his own behalf. This court must also preserve dignity, order, and decorum. Again, ensure relevant and admissible evidence is presented, and also honor the defendant's right to present a defense. The simple requirement that he answer questions is required, frankly, due to the defendant's prior conduct throughout this trial. His repeated defiance, his repeated outbursts, his repeated failure to follow simple rules of courtesy and decorum, his repeated interruptions of this court, and this court having to repeatedly remove him to the neighboring courtroom and making findings that he has forfeited his right to be present. Of course, this record is abundantly clear at this point that Mr. Brooks is not even in the main courtroom because this morning alone, he is yet to conform his conduct to the simple standards of courtesy and decorum that are required of all participants in these court proceedings: the court, the prosecutor, the defendant, the jurors, the public. Absent an adherence to these simple rules, including the rules of evidence, the rules of procedure, and the rules of civility and decorum, and without a pledge by Mr. Brooks that he will follow these things, then on balance, this court will find that he has forfeited his right to testify. I've now made a much more full record of what is at stake, and I will give Mr. Brooks an opportunity again to go through the colloquy with the court regarding his right to testify. I am unmuting him and will attempt to go through this procedure once again. If he fails to answer these questions, then he is forfeiting his right to testify by his own conduct. I would acknowledge that such a procedure is certainly not ideal, or making a finding that he is forfeited is not ideal, but as Mr. Brooks's conduct and Mr. Brooks's conduct alone that has forced the court to make this determination. So Mr. Brooks, you are unmuted. You have been for about a minute. I want to go through the questions again. Are you aware that you have a constitutional right to testify? Mr. Brooks, are you aware that you have the constitutional right to testify?
Hi, and welcome, LaTanya.
Mr. Brooks,
Thank
do you
you for
understand
joining.
and are aware that you have a constitutional right not to testify?
I don't understand. No, I don't understand.
Are you aware that you have a constitutional right not to
I don't
testify?
understand. I don't understand, and I'm not aware, so why are you asking me questions?
All right, I'll do this another way, sir. Sir, you are advised that you have a constitutional right to testify, and that if you choose to testify, that you would be subject to cross-examination by the state. Did you hear me say that?
I don't hear you say anything. I don't understand what you're asking. I don't
He is
understand.
willfully choosing not to answer that. Sir, you are also advised that you have a constitutional right not to testify.
Your Honor, with all respect, you've been trying
Did
to
you hear me say
answer
that?
questions for, I didn't hear you ask me anything. And I
Sir?
don't understand.
Stop talking and I'll ask it again. Sir,
Can you ask me to stop talking?
I'm asking you to stop interrupting me so that you can hear the questions. Even though I fully believe you hear them, I will attempt to do this one last time.
It's like, are you asking
Right, then
or
let's-
are you telling me?
Once again, Mr. Brooks is being disrespectful. He is blurting out information. He reverts back to subject matter jurisdiction. He accuses this court of not honoring its oath. He just accused me of practicing law without a license. Again, all attempts to deflect away. I'm going to mute him once again. This court has simply tried to no avail to get Mr. Brooks to answer simple questions, confirming on the record that he has been advised that he has a constitutional right to testify. And that he also has a constitutional right to testify. I was very clear prior to unmuting him and telling him that I would go through these questions once again, that I needed him to follow the rules of decorum and civility and not interrupt this court. He has done nothing to demonstrate decorum. Again, repeated interruptions. It is, again, from my perspective, simply a tactic on his part to delay these proceedings, to disrupt these proceedings. He reverts back again to things like subject matter jurisdiction, practicing law without a license. Then he makes requests about interlocutory appeals, etc. The record is full of his tactics in this case. He would not pledge to be civil, to be courteous. He would not pledge to honor the rules of evidence or the rules of procedure. He would not even answer simple questions regarding his right to testify and whether he heard that or not. And based upon, pursuant to State versus Anthony, and looking at the balancing test that this court must consider, this court simply cannot allow Mr. Brooks to get on the witness stand unfettered without an acknowledgement that he will honor the rules of procedure, that he will abide by the rules of evidence, that he will honor rulings that are made by the court. He has demonstrated repeatedly throughout this trial that when this court makes a ruling that he disagrees with, he tries to engage the court in an argument about the legal basis, even though I've provided the legal basis on the record, or
Yeah, thumbs up,
in
everybody,
case,
if
in
you
the case of
haven't
subject
yet.
matter jurisdiction,
Please
even
hit
when
that
there's a
thumbs up
written
button.
determination on the issue.
I would appreciate it.
When looking at State versus Anthony, this is a case where the Wisconsin Supreme Court was faced with a similar situation, although
Thank you,
not
Morgana.
as egregious as I would say here. Because in State versus Anthony, that was not a case where the defendant was ever removed from the courtroom based upon his conduct. Although in State versus Anthony, they noted it isn't a requirement to forfeit your right to testify to previous to that be removed from the courtroom. So not as egregious as a case, but this court has a history over 15 days of trial where Mr. Brooks has repeatedly been removed from the courtroom, where he has repeatedly demonstrated he has absolutely no regard for courtesy and decorum. He is what I would describe as a stubbornly defiant individual who simply wants to say what he wants, when he wants, without a filter, without regard to the rules of evidence and the rules of procedure. As State v. Anthony discussed, the right to testify, although a fundamental constitutional right grounded in personal autonomy, is not
Thanks, Tony.
absolute. For example, there's no constitutional right to commit perjury. There's no constitutional right to present irrelevant evidence. Moreover, a criminal defendant's right to present
Is it you,
relevant
Tony, that
testimony is
has to
subject
do
to
it
reasonable
twice?
restrictions. Those
One's on your
restrictions,
phone and
again,
one's on
fall
your TV.
primarily under the rules of evidence and the rules of procedure. The court in Anthony
I'm
cited
eager
the
for that,
the U.S.
Latonya.
Supreme Court from Arkansas versus Rock, wherein that court stated the right to present relevant testimony is not limitless. and
I'm
may
not
in
even gonna
appropriate
lie,
cases
I'm
out to
anxious for that
accommodate
one.
Other legitimate interests in the criminal trial process. For example, numerous procedural and evidentiary rules control the presentation of evidence and do not offend the defendant's right to testify. Throughout this trial, Mr. Brooks has repeatedly accused this court of violating his First Amendment rights of free speech. I've told him repeatedly his First Amendment free speech rights are not unfettered and that they are limited in the court of law for the very reasons cited by the Supreme Court in Rock. The takeaway from Arkansas versus Rock is that a defendant may forfeit his right to testify by his conduct. Whether a criminal defendant may forfeit his or her right to testify through conduct incompatible with the assertion of a right was reviewed by that court.
Really,
That court
Susan?
went on to discuss waiver and forfeiture and ultimately went on to conclude the following. We now conclude that the right to testify may in appropriate cases be subject to forfeiture where conduct incompatible with the assertion of the right is at issue. The balancing test that this court must go through are the interests, again, as I've already stated, for the rules of evidence, the rules of procedure, civility, and decorum, and balancing all of that against Mr. Brooks's right to testify. This court is not making an arbitrary decision. The decision I make here today is, in my opinion, proportionate to the conduct demonstrated by Mr. Brooks throughout this trial, and specifically today, based upon his failure to even engage the court in a simple colloquy regarding his right to testify and his right not to testify. He was repeatedly warned that the failure to answer the questions would be taken as by this court really as no, meaning the specific question, have you made a decision? And as for all of those reasons that this court will make a finding, he has forfeited his right to testify. With that, then, there are no other witnesses to present for the defense. Before I bring the jury out, I'll ask the state if you intend to call any rebuttal witnesses.
We have no rebuttal case, Your Honor. Thank you.
No
All right.
rebuttal case. I forgot. I couldn't
I would
remember
like
if there
Mr.
was one
Brooks
or
to be
not.
brought back over so that he is present in the courtroom when the court advises the jury that the defense is resting. I realize that will be over his objection. I'd ask that he honor that. Mr. Brooks, I'm going to unmute you. If you can pledge to this court that you will honor that ruling and that you won't challenge that directly in the presence of the jury, I will bring you back over for that. Are you willing to make that pledge, sir?
Make what, please? I'm not making no.
Right, Glenn, I
Sir,
know.
you
You're trying to, you asked me a question I can't answer.
yeah, no, go ahead, answer.
You're trying to coerce me into violating my right to remain silent. How can you coerce me into my right to remain silent? So you're not gonna protect my constitutional rights? Because I didn't answer nothing that you was trying to ask me before when I had the headphones on, and you can't make a decision for me. You can't do that. You're violating my constitutional rights.
She can and
Sir,
she will.
if you'd
and
like to
she
testify,
has.
then you need to simply go through the colloquy with this court, which I've given you 3 opportunities to do, and you have decided not to.
No, you can't tell me what I decided to do, because I didn't decide to do or not do anything.
Are you
By
willing
law,
to?
Your Honor, by law, you cannot coerce me.
I'm not coercing you, sir.
Well, you're making a decision for me based on something that I did not say myself.
Last Friday, I specifically directed your attention to State versus Anthony. I discussed very briefly at the end of the day on Friday the case law that is relevant on this topic, including State versus Anthony, Rock versus Arkansas, and Chambers versus Mississippi, to specifically put you on notice.
Do you recall what was going on Friday?
Mr. Brooks, I'm going to mute him. Again, I'm not going to have a debate. I've made a finding. I've given him yet another opportunity. If he's willing to go through the colloquy with the court, he wants to challenge me instead and saying he doesn't consent. His lack of consent to this entire
Sorry, I
procedure
just slurped.
is noted for the record. Based on his inability to pledge to this court that he will honor that ruling and be respectful of the jury, I'm going to leave him in the other courtroom. The jury's going to be brought out. And he will remain muted, and I will simply advise them, as I have throughout this case, that he's appearing from another courtroom and that his appearance from the other courtroom should not in any way be held against him or influence their verdict in any way. I will tell them that there are no further witnesses for the defense, and then I'll ask the state if there is any rebuttal, and then the jury will be excused.
He ain't got no home training.
For the day, because we will have I anticipate will be a very lengthy discussion on jury instructions. Again, I will advise Mr. Brooks that if at any point in time he wants to come back over, he needs to advise the bailiffs, but it does need to be accompanied by a pledge that he will follow the rules of civility and decorum, and he will not specifically challenge the court's rulings regarding closing off of his ability to call witnesses or testify on his behalf. All right, let's have the jury brought out.
Right, Dog Mom? Dog Mom says, I absolutely love how he tells the judge what she can and can't do. This coming from a man who is an utter moron and doesn't have a working brain cell. Tanika said he should have installed his act right. He don't have no act right. He got to have one before he can install it. There's Hunka back there against the wall. Cohorse, right? Cohorse.
All right.
He's going on and on and on and on and on. Ain't nobody listening.
Thank you, everyone.
Breathing
Please be
hot
seated.
air into that mask, mister.
Ladies and gentlemen of the jury, at the moment, Mr. Brooks is appearing from another courtroom. This must not be held against him in any way and must
100%.
not influence your verdict in any manner. At this time, I will advise the jury that the defense case is rested, and I'll ask the state whether there's any rebuttal
Dunzo.
evidence to present.
No rebuttal, Your Honor.
Dunzo.
All right, then with that, I will declare the evidentiary phase of this trial concluded. I'm going to excuse the jury for the remainder of the day so that the parties and I go through all of the jury instructions, and I anticipate bringing you in tomorrow morning. Instructions may very well take most of the day. My hope is to then have the closing arguments and then have the case be turned over to the jurors. If not by tomorrow evening, sometime Wednesday morning
Right, Kelly?
or early afternoon. With that, I'll rise for the jury then. Please turn your
I think that's one reason why I do too. I always love the cases where the defendant represents themselves. I find that very intriguing. I would have loved for Sarah Boone to have represented herself. I would have loved that. Of course, we would still be sitting here watching it because she don't know how to shut up. But I love to watch them. They're just interesting. There's only been one that I've seen that like did themselves, did well-ish for themselves, and that was the Tyrone Tucker. If anybody in here, I know my normal crew watched it, but I don't know about a lot of you new folks watched the Tyrone Tucker. They called it the Treehouse Murder Trial or whatever. That was pretty interesting, and as annoying as he could be, he still did the best job out of anybody representing themselves that I've seen. And, Margaret said, I was just going to say we'd still be watching if she'd done that. Tanika said, is it true that no appeal was filed for this case? For Brooks? Treehouse Tucker, yeah. Oh, yeah, I heard that. I haven't watched it. Dog mom says my heart goes out to that poor mask. Okay. All right, let's see. Do you guys remember if there is anything I don't remember.
Our IT specialist, he too will take the witness stand, and I just want to make a full record of, he did a...
Hold on. Is this about the what do you call it? Recall on the car?
Record appearances courtroom. I would like to make a record regarding the audio and visual from the other courtroom. I've asked that one of the bailiffs who was present during the last session, present in that courtroom, come to this courtroom. I'm going to put him under oath and have him testify about the audio. I also have information from Zach Tremaine, our IT specialist. He too will take the witness stand, and I just want to make a full record of, he did a
Sharon.
decibel reading regarding the audio as well. All right, we have Deputy Kibler, if you could take the witness stand, please. Sir, could you please raise your right hand? Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
It is.
Thank you. Please have a seat. Please state your first and last names for the record.
First name is Nicholas, last name is Kibler. First name Nicholas, last name Kibler.
Thank you. And you are a Waukesha County Sheriff's Deputy?
I am.
And have you been assigned to work this case?
I have.
And were you present in courtroom 20 this morning with Mr. Brooks when he was removed from this courtroom to that courtroom?
I was.
And did you make any personal observations regarding the audio and visual setup that we have over there?
Both the audio and visual were working properly. The audio was a lot louder than it has been in the past while we were in that room.
Did you have any difficulty hearing the court?
I did not.
And then, of course, you could see through the cameras from this courtroom and the neighboring courtroom.
I could.
All right, that's the only record I wanted to make. State, have any questions?
Just briefly, Deputy Kibler, the defendant asked many times if he was muted or unmuted. Do you remember that?
Yes.
Can you confirm that even on the occasions when his microphone was muted, the audio in the courtroom continued to work?
It was.
And at any time while Mr. Brooks was muted, or even if you didn't know, at any time did Mr. Brooks ask to be brought back over to this courtroom, sir?
He did not. He is telling us he prefers right now to be in that courtroom. He did not want to come back in here.
All right, thank you. Those are all my questions, Your Honor.
Mr. Brooks, you are unmuted. Do you have any questions for this deputy?
No.
All right, thank you. You may step down. All right, then I'm going to have Zach Tremaine also take the witness stand. Do you have, I have it on my screen. Can you do a project it, please? I can share it. If I share the clerk's screen? Yes. All right. There is, first of all, sir, stand and raise your right hand. Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? All right, thank you. Be seated. State your first and last name for the record, please.
Zachary Tremaine, Zachary. Tremaine is Tremaine.
All right, and what is your position with the Clerk of Courts office here in Waukesha?
I'm the IT coordinator for the Waukesha County Circuit Courts.
Were you in courtroom 20 this morning following Mr. Brooks being taken to that courtroom?
Only temporarily. I was there when the call started, and then we came back to do a measurement of the DVD later.
There's a document or a photograph that's displayed on the monitors throughout this courtroom. Can you tell me what we're looking at?
So my phone is in the photo, overlaid on top of what we call the X panel. It is our AV control panel. So you push buttons on it and actions happen in the courtroom, AV related. At that time of the photo, my phone is registering 67.3 decibels in that courtroom, and that was when the judge or the court was talking, and the sound was coming over the speakers in the other courtroom.
And what, if anything, based on your training and experience, can you tell me 67 decibels means?
It's plenty loud. For comparison, I did a quick reading in the media pooling room,
Okay,
which
thanks,
is CD6
Sharon.
in our courthouse. The meter there was reading between 55 and 65, so it's louder than the audio feed going to the media right now.
Thank you.
All right, thank you. Any questions from the state?
Sir, I'm looking at the photo, and Your Honor, for the record, this photo will be made a court exhibit?
Yes.
Okay. I'm looking at your phone screen, and it looks like in the upper right-hand corner, it appears the time is either 9:26 or 9:36 a.m.
On my phone, yes, I believe our AV processor, which is the other time of 9:23, I believe that just needs to be updated, but
Okay,
it is approximately 9:26 when the photo was taken.
okay. Those are my questions.
All right, thank you, Mr.
I'm sorry.
Oh, go ahead.
Do you happen to know what the decibels are in this room?
I don't. I'd have to pull the same thing up on my phone while people are talking.
Okay, thank you.
Mr. Brooks, any questions
I think
for this
he was
witness?
lying. I think it was just another delay tactic.
Do you know anything about the hearing when someone has the hearing loss in any of their ears?
I do not.
So it'd be fair to say you don't know if I can hear everything good from this courtroom?
I can tell you what the readout of the room is. Beyond that, I don't know.
Well, I can't see with the photo that everybody else is in there seeing that was supposed to be made an exhibit. I have not viewed that, so I don't know what's being referred to when you refer to the picture.
I'll have to show you that in a different way. I don't have the Zoom up and running, which would have been the mechanism to allow for an exhibit to be displayed. I can start that and have that up momentarily. Fair enough. So give me a moment. For the moment, we'll print it in black and white so you have it until I can get the Zoom up.
I can't stand the way he says
Sure.
everything.
You are in the meeting now.
I need to get the other courtroom in, so just one moment.
Doesn't he just look so defeated sitting there?
Will I have to stop the Polycom, Zach?
Yep, you have to hang up and then join into the Zoom meeting.
Okay, hold on, please. Can you do that? Stop the call for Polycom to Polycom, and then I'm going to call it in through the Zoom so I can share the screen with the exhibit, which will actually help when we do jury instructions. Hang it up.
Well, I don't know who that was, Sharon.
Except now both the room systems are out, so hold on. One more.
You are in the meeting now.
All right, so the record should reflect that I've now changed the audio visual from the Polycom unit to the use of Zoom. I've called in both courtrooms, and they can hear from over there, and then I'll do, I just need to get back on so I can get the email. Give me a second, I have to go from double screen to single screen, the way I sign in, but that'll take me just a second, and then I'll share screen so the color exhibit can be viewed by the defendant.
Oh, did Judge Judy say that?
All right, now the court is sharing screen and the image is being displayed. You see it? Okay, thank you. Any questions regarding that then, sir?
My question was, pretty much already answered. You don't know if me myself can hear everything you do in the courtroom, correct?
I do not, correct.
Hey, California Dreamer. Good to see you, hun.
Okay.
How are you?
Okay, thank you, sir.
How
I'll stop
are
sharing.
you? Hi.
Okay, thank you, Zach. You can step down. All right, I just wanted to put that on the record since that was an issue raised by Mr. Brooks previously. Now, I need to get a copy of the jury instructions. They were quite lengthy. The record should reflect that Mr. Brooks was provided with a written copy. It's 107 pages, and the state was provided with a written copy as well. Again, it's all the same 107 pages, and then my written copy is on its way.
I accept the value, return the value, each document. That's if I'm not muted.
You're not muted.
I also would like to, again, ask for subject matter jurisdiction proven on the record.
Your request is denied.
That's yet to be verified. It has yet to be verified.
Your request is noted. It's denied without further hearing or consideration.
I was just told that,
Without
the
further
every
hearing or
injuring phase is
consideration.
supposed to be closed. How come I haven't been able to present my evidence into the record as I've asked numerous times on the record to be able to do? I've said I have numerous documents that needed to go into the record. Why have they not been permitted to be made evidence? I didn't rest my case, so I don't know why that's being told. And I have yet to be able to offer my exhibits into the record for evidence. How is that so, Your Honor?
So the court did declare the evidentiary phase of this trial closed. I specifically found that you forfeited your right to present any further evidence or testimony when you failed to answer my questions regarding the calling of witnesses. And then I also declared that you forfeited your right to testify. Specifically as it relates to your trial filing, sir, I would note that all evidence in a trial must be proper, it must be probative, it must be relevant, and it must follow all rules of procedure and all rules of evidence. To the extent that you wrote all of those documents, sir, that would be hearsay. And for that reason, I'm denying your request to make them part of the record.
They were not hearsay, Your Honor. I did what you told me to do. You told me, since I was representing myself pro per, that I had to write everything out and present them to the court.
So that's not what I said. You're misquoting me, but in any event, I'm
No, that's
denying
what
your
you said.
request. I
So
said,
you're saying that I have no right to present evidence and to have exhibits as the state's been able to do.
Mr. Brooks, I'm
Are you
not going to
denying
have a debate about this
Are you
now.
denying-
I got to mute you
denying
once
your
again.
right?
So, Mr. Brooks, I have muted you because I declared the evidentiary phase of this trial closed. You forfeited your right to present further evidence and testimony previously by refusing to answer the court's questions. I will specifically address the filings. Number one, it is not true that I advised him that any filing would become evidence. That is simply false. Number two, filings, I told him if he wanted to present motions, should be written down and should be based in law and fact and request specific relief. I'm well aware that previously he has referenced he would like his filings made exhibits. I've reviewed those filings. There's nothing relevant, nothing probative, or the information contained therein is hearsay. Mr. Brooks would have needed to testify regarding any statements that from himself, testimony. He cannot simply put.
You know what? I kind of envision that, her mute button, as like the Staples easy button. You know what I mean? You know what I'm saying? Do they even still have that? You remember you could buy those too. They were the red Staples button. It's so funny. So funny. Yes. Yes, Michelle. Yes. Yes.
Put in an affidavit. That's not proper. That's hearsay. And he hasn't asked in any of those filings that he hasn't put forth any exception
so
to the
mad.
hearsay rule that would allow this court to admit his written filings. I believe without fail they are all irrelevant, not probative, and hearsay, and therefore not admissible. So we're moving on to the discussion of jury instructions. When Mr. Brooks wants to abide by the rules of decorum and civility, I will unmute him. He clearly just took the entire packet of jury instructions and put them, I don't know what's under the table, if it's a garbage can or if he just simply put them under the table, but they are no longer in front of him. I will, however, unmute him so that we can get his feedback.
He is such a big,
regarding jury instructions.
pouty
It's typically a back and
baby.
forth. We'll go through them. And I'll ask the parties
Big pouty
whether there are
baby.
any instructions they believe should be included, and we'll have a discussion on that. And then we'll talk about whether any of the instructions that are in here need to be modified in any way, taken out, edited, etc.
Muted.
Right, you're unmuted now, but but you have to not interrupt.
No, you can't, I'm not trying to interrupt, but how can you deny me the chance to put on the adequate defense by saying nothing that you told me to do can be presented into evidence? So you filed everything that I gave to you.
Right,
filed.
Mr. Brooks, I'm
And
going
that's
to
all I'm
mute you
saying.
because this is not relevant at this time.
It is.
He's raised tone of voice. He's very animated. He threw the jury instructions on the floor. I understand you're upset, sir. I understand you believe I'm violating your right to present a defense. I've made my rulings. I determine you forfeited your right to testify,
Hey,
which
hot
includes
mess.
the right to present evidence as you would have testified. I closed your, and I closed.
Good to see you back, hot mess. How are you? Hope you're doing well. Hey, Brenda, good to see you. Yes, Miss King. Could you imagine? Oh my God. And I was going to say it earlier. You know, somebody was talking about him as a kid. Could you imagine him as a teenager? Like being his mom with him as a teenager. Oh my God. His prison name is Old Yeller. That's funny. That's so funny. I'm a grown man with grown kids, right? Watch me throw my paperwork on the floor. Exactly. Exactly. Dog Mom says, I love when he says hearsay, but when it's not even close. Right? He don't even know the meaning of the word. Yeah, none of his objections are like his grounds for his objections are never right. Never. Right, Michelle? Right, no wonder.
Closed off your ability to call any other witnesses by finding that you forfeited your right to do so based upon your conduct. I understand you're frustrated. I understand you believe that I'm not without authority to do that. I made specific factual findings. I've referenced the law, and you being upset with the decision is not going to change my mind. He's also taken the headphones off. It's his choice right now whether he participates in this jury instruction conference. It is his choice. But if he is going to spout off about things that I've already determined, I will continue to exercise the mute function on the audio equipment. I'll
look
unmute
at
him
him
again,
yelling.
but you are advised, sir, you need to be proper, you need to not interrupt, and you need to stay on task, which is we're discussing jury instructions.
Things are not gonna
other
go his
evidence,
way.
Not subject matter jurisdiction, not your belief that I told you to file things a certain way. We are now discussing jury instructions.
Oh, Kelly, that
So
makes
once again,
me
I'll
sad,
unmute him
though.
to see if he can follow these simple rules.
You need to tell me why I can't present evidence. How can you deny me how can you deny me my right to present evidence?
All right,
I
I'll
told
mute
you
him
before
once
you.
again because he wants to continue. And again, I understand he's upset. I understand that. But he has himself to blame for his
Right.
conduct this morning and the rulings that I've made. All right, so let's go through these jury instructions. First of all, has the state received a copy of the draft?
Yes, Your Honor.
Thank you. Mr. Brooks, do you acknowledge receipt? I believe you did by acknowledging it previously, but you acknowledge receipt of the draft of the final jury instructions.
I don't acknowledge nothing, and I don't acknowledge anything now. I have not received anything.
I would ask the bailiff to
I
pick
don't
up the
see-
documents from the floor and put them in front of him.
And I'm not presenting it to nothing I don't give my consent to. You can't deny me the right to put on the defense. How can you tell me when I done stated
I'm gonna
3 or
read it
4
once
times?
again, because again, I understand he's upset. If the bailiff could confirm, well, he put him on top, he put him on the floor, that's his right. They're not in front of him, but it's by his own conduct that he's done that. The record should reflect Mr. Brooks is muted because he wants to continue to debate with this court about my prior rulings regarding his forfeiture by conduct of his right to present further evidence on his behalf.
Oh, that's exactly what she
One of the
meant.
things I probably need to
I'm sure that's exactly what she meant, California. Because manic just sounds nicer and more medical diagnosis-y ish than just throwing a whole grown ASS toddler tantrum, right? Right.
to look at, I'm not sure if Madam Clerk did this or not, would be the language from the amendment from the amended information on count.
Yes, Margaret.
70. No, I don't want to do that.
What do you got? I changed,
Come on.
Yeah, you
70
and Brenda are spot on
6.
together.
The 76
Twins.
count. Just wanna make-
You
It
guys
says
are
near frame part,
twins.
so it is in there, but that was just one question I had.
Did you see that? He's such a little bitty man. That box is so heavy it knocked him down into his seat. He couldn't even stand up. Let's rewind and watch that. That box is so heavy for the baby.
what do you got? I changed.
Watch this. This
70
next box is so
6.
heavy.
The 76 count, just want to make. It says near frame park, so it is in there, but that was just one question I had.
Oof. One more time. One more time. Be kind and rewind. One more time for the baby.
No, I don't want to do that.
What do you got? I changed,
Come on.
He's a
70
big kid now.
6. The 76 count, just want to make. It says near frame park, so it is in there, but that was just one question I had.
Daggone it.
All right.
You know, he's like, daggone it. Now I look like such a weak man. Yeah. You are a
So,
weak
state you
man.
have any requests as it relates
You
to the
can't
jury
even be called a
instructions?
man, to
I'm
be
just going through
honest.
each one. I'm on page 50 of 107. Everything's looking great so far.
Okay. Fair enough, there's 107 pages. I certainly can give the parties some time to continue to read through them.
325, 141.
Now he's look. Look at that fool. Okay. I knew this was coming. I've seen this. I've seen this. I've seen it, but now to see it all over again, it just, oh my God. Oh my God. Oh God. Him and his little fort.
Mr. Brooks is requesting to go back to his cell. At this point, I'm going to deny that request. He
Yeah,
can
he's
remain in
wanting
the
to go
other
back to
courtroom.
his cell. He wants to go back to his cell. And you know what? I love that she denies him the right to go back to his cell. He needs to sit there, even if it's behind the box, like a big weenie pants. He needs to be right there. You don't get to go to your, I wish that the judge would have forced, what's his name? Is it Adam Montgomery? I wish that they would have forced that insect, or whatever you want to call him, to court every day. But I love that she's not letting him go back to his cell. Ooh, I don't want her to see my elbow. Let me use this box. Scoot it over. Can you imagine how mortified they are? I mean, they're already mortified, but... Right, Kelly.
I know
His
he's
little
muted, but I can
arms
certainly
got
hear
so
him from
tired.
this side. He appears to be yelling at the top of his lungs. I can't decipher what he's yelling.
Put the third one up there, dude. The one you can't lift. Is weird.
I'll advise
for
Mr. Brooks, without a specific waiver of his right to be present, even if it's from the remote courtroom, he's going to remain in that courtroom. And that would require him to have a colloquy with me.
Yeah, Tony, I think so. I'm pretty sure. His poor kids. God. Brenda, I don't like green beans. Yeah, and then him trying to make Erica look like a bad mom in front of the jury. He's a real piece of work. I'm going to kind of skip around because they're just going to work on jury instructional things, but I don't want to miss any of the good stuff. So we'll just kind of bounce around for the next little while. Yeah, Tanika is
Mr.
here,
Brooks,
California.
if you have specific instructions or categories of instructions that you believe this court should consider, I need you to write them down on a piece of paper. If you don't have,
No,
I believe I see a
Brenda.
writing utensil. I'm not sure if I see.
No, Brenda, at this point, the jury has been, they both rested, the state and the defense. Of course, the defense, he didn't on purpose rest. He forfeited his right to question anymore, you know. So he's basically, they're done. It's a done deal. So now they're just doing the jury instruction conference, getting all that stuff ready. But it's going to take forever because there are 70 some counts. Let me see. So I'm just going to kind of scooch past through.
A pad of paper, we'll make sure you have that. But given your current demeanor, which is still seems quite animated, and a loud raised voice, I'd ask that you write it down.
Yeah, you can see him like going off behind the box. Here in a little bit, she'll have the bailiff. He's taking his jacket off now. But she'll have the bailiff go move the boxes here momentarily. So everybody's kind of got their heads down, working. Yeah, I gotta take my jacket off. All that yelling makes you hot, you know, right? Yep. They got all their noses down. Getting through the stuff. I just kind of want to get to another good little argument, maybe.
Well, yeah.
Daisy looks good in yellow. You usually only see her in like navy or black.
Who can court to consider for any. Mr. Brooks, I'll advise you once again if there are any specific requests for either instructions or categories instructions that you want this court to consider, please write a note to pass to the bailiffs who can let me know.
It does look good on her, right? She looks great in yellow. Him going off back there.
I know I've.
Hey, Your Honor. Hey, Your Honor. The state has reviewed all 107 cases.
Thank you. I know I've, from my review, I noted a few spots that either in the headings, that some information or words that might need to be removed. But why don't you go through and tell me what requests you have, starting, and then we'll go page by page and just tell me what page number and what section.
So I think the first concern I have is with regard to the bail jumping. I know that we had charged, there's 2 separate felony cases. The defendant was out on bail. And I do believe it would be assistive to the jury to have the specific case number. So when we first talking about 61 of 107, we start talking about the bail jumping, and then we go specifically on page 63 of 107, and when we could talk about count 74 and 75, I think it might be helpful to put the Milwaukee case number, because they are different case numbers, so they know.
And you can tell she's still a little bit, you know, sick-ish. But earlier in the trial, Sue had a cough, so I'd say they just kind of passed it on to one another, you know. Yeah.
Know exactly what they're finding, that he was out on bail and that as conditions of his release. And those bail bonds were entered into evidence.
Let me look at the information.
And then just, because I think this was just well, I guess I'll have you, when we look at the verdict forms on page 102 to 107 for the bail jumpings, there's verdicts for the bail jumpings for 3 separate counts, 74, 75, 76. I don't think there should not be one for 76. I believe that should be the battery.
That would be true.
Oh, I didn't notice until just now. It looks like the judge had her nails done
My
over the
computer's just acting
weekend.
up a bit, so I'm gonna search. Let me see what the information says.
Well,
I'll ask
wait.
Mr. Brooks if he has a position.
Did they have an was the last day we watched, was day 12 on a Friday? I feel like it was on a Friday. Can't remember. But she got her nails done. She had a French polish, and now she's got, it looks like they're white with silver glittery accents on the ring fingers.
On that. Sometimes it's easier if we just list out, I guess, what the changes are requested. I'm gonna make some
It
notes,
was,
and we'll go
okay.
through one by one. So
And I
first
don't
is
believe it
page-
was spelled out in the amended
Thanks, Kel.
information.
Say that again?
I don't believe it was spelled out in the amended information.
Right.
So that would be page 63 of 107, whether or not we want to put the specific case numbers.
I can tell you right now. I'm
Yeah,
typically
me
like to follow
too,
the
Kel. I
information,
thought
so
so
I'm
too.
Probably not inclined to do that, and you can argue that though to the jury. but
Funny, right?
Let's go through the list, and then we'll get
Okay.
the defendant's responses if he's would like to give us those. But we'll go through the whole list. So that's the
And then-
bail jumping.
Yep, and then with the verdict forms with regard to the bail jumping, just to put on the record, page 102 of 107, I believe there's a count 76, which
Yeah,
details
she
that as
called
bail
him the
jumping, I
baby
believe
of
that
the
should be
bunch or
battery.
something like that.
I did notice on
Just window watching, window wishing. Just
the motive instruction was incorporated on page 5 of 107. And I know that intent is an element of the battery. I don't believe that was incorporated. I mean, usually it's a standalone instruction. I think the court incorporated it with the
Literally and
intentional homicide,
figuratively.
because certainly that was,
I think that's part of the pattern instruction.
oh, it is. Okay, then we'd ask for motive. I think that there's a 175 instruction that could be given as a standalone.
I'll look at that. Okay, we'll add that.
And then on page 65 of 107, which is the 70, the preliminary instruction, defendant proceeding pro se, there's the standard paragraph, which is the first paragraph listed under this instruction, and then there's an additional paragraph. We are going to object to that additional paragraph. I think it highlights the defendant's bad behavior, so I'd ask that that be taken out.
And even though she just said that, I could literally hear Darrell Brooks in the back of my head saying, "Don't do me no favor. I don't need you to do nothing for me." I could hear him say that. I
Right,
don't
a
need
minute
your
or that.
help.
Keep going.
Okay, with regard to page 106 of 107. I believe that those were add-ons at the end that the court wanted to question the parties about.
Yes.
I believe that there was 325 should be given. One of the witnesses for the state did testify. He did have one prior conviction. I believe a witness for the defendant testified that he had a number of convictions. With regard to that same page 106 of 107, instruction 141, where identification of defendant is an issue, I don't know if it is an issue. That wasn't raised during the defendant's closing arguments. His opening arguments. I would know that, or note that the defendant would sometimes cross-examine people on if they were able to see the person driving or the description of the person driving, and he would cross-examine them as to their ability to perceive that. So I guess that would really be up to the defendant if he wishes that to be given.
Wow,
On page
really,
107 of
Dogma?
107, instruction 172, circumstantial evidence, flight, escape, concealment, the state that was included in
Wonder
the initial
why.
instruction that we requested, and I would continue to request that instruction be included.
It's really just flight, though.
Correct.
What's that number again?
172.
Yeah, I know, it's just not there. I saw it, it's fine. But only as to flight. I made a correction on it, so I find it. All right.
And I'd say concealment to some extent,
Oh,
because he took
whatever,
off some
Michelle.
clothes that would have identified him.
Whatever.
But again, his running away, his trying to conceal his identity by removing some clothing that was identified by numerous witnesses as him wearing a hoodie or a light colored top.
Those are all, and do you have any requests as it relates to instructions that are not in the packet that should be?
No, Your Honor.
Right, let me turn to Mr. Brooks just to get whether he has his list. I'm not asking for a response yet, Mr. Brooks. What I'm asking you for is whether you have any requests for jury instructions, or if in your review, you think anything needs to be changed, deleted, added, etc. I know I'd ask that if you put in writing, but I'll also give you this opportunity to verbally advise the court and make your requests. Do you have any requests as it relates to the jury instructions, sir? I would note he put 2 boxes right in front of where he's seated, so I can't presently see his face. I see his jacket is off, so I can see the outline of his arms, and I can see the jacket on the back of his chair. He is unmuted. I've confirmed previously regarding the audio working, and I will just ask him a second time, sir, do you have any requests as it relates to the draft packet of jury instructions, whether that be any additions, corrections, edits, or deletions?
And Your Honor, would it be possible for the bailiffs to just move the boxes off the table so we
Yes,
can
I think
see?
that's fair. I'm going to advise the bailiff to remove the box so I can see Mr. Brooks. I don't know what he's doing behind there. He has quieted down. I haven't heard him in a while. If you could move the second one because it can interfere with the microphone as well. And the third. Mr. Brooks, I'm going to ask you for a third time. Do you have any requests as it relates to the jury instructions? Any requests for instructions that aren't included that you believe should be included? Any edits or deletions from the packet that has been provided to you?
Hey, why do you tell them to move my box?
Because I couldn't see you, sir.
Or what?
I've asked you twice now, and I'll ask you a third time. Do you have any requests as it relates to the jury instructions? Any additions, deletions, edits, or otherwise?
Hey, man, you don't gotta talk to me like that.
Do you have any requests
First of all,
related to the jury instructions, sir?
Yep.
Man, yeah, I got requests. It ain't like they gonna be honored though.
As it relates to the jury instructions, sir, what are you?
I heard what the hell you said, man.
Mr. Brooks, that was very disrespectful.
Yeah, and I've been getting disrespected since the beginning of this whole process. So welcome to the club.
Welcome to the club.
Mr. Brooks, do you have any requests?
I'm tired of my rights being trampled on here too. I'm tired of it too.
Do you have any requests as it relates to the jury instructions?
Ain't nobody understand why I'm frustrated. How you gonna sit up there and make decisions based on what you think I said when I didn't get consent for you to do any such thing?
Sir, I understand you may be upset, and I really do, but I've made my determinations.
You don't understand nothing.
Hey, Skylab. Good to see you. Yeah, we're all doing better than this guy for sure, right? Right. Good to see you, though.
You don't understand anything, Your Honor. You don't.
I'm going to mute him again because he's not answering the questions that I'm very clearly asking him, and I've given him 5 opportunities. Mr. Brooks, do you have any requests as it relates to the jury instructions? I'll unmute you for that answer.
I can't hear everything you're saying.
Wow.
Mr. Brooks, I know the audio's turned up. I believe you can hear me. You've chosen not to put the headphones on. That's your choice. My final question to you, do you have any requests as it relates to the jury instructions?
I just told you, am I muted? Am I muted?
No.
I just told you, I don't know how many times, I can't hear everything you're saying.
Then you should put the headphones
What about that
on.
don't you understand? What about that don't you understand? If you see headphones, you can see everything. You can see boxes, but then you see headphones.
Have you asked for headphones to be provided, sir?
I shouldn't have to ask him. I asked for my boxes to be moved.
I believe they took them away previously because you were so agitated, they were perhaps afraid you might break
Yeah,
them.
I'm still agitated. I ain't gonna stop being agitated. That ain't gonna stop. You sit up here and do everything you're doing and think God don't see what you're doing? You ought to be ashamed of yourself.
Mr. Brooks, do you have any requests as it relates to the jury
Yeah,
instructions?
I can hear what you're saying. I can hear what you're saying.
You just told me you didn't. So which one is
Yeah,
it?
I got the headphones on. You can't see that?
What are your requests as it relates? What are your requests as it relates to the jury instructions, sir?
Man, don't try to come with this whole little image, sir. Now it's all this, sir, and all this. I'm gonna get where I'm going.
Yeah, you will.
Try to put on this little act like you so worried about what's going
He says, I'm going to get where I'm going. Yeah, you do. You get there all right.
on with me. You don't give a damn. Never did.
Mr. Brooks, you're being disrespectful again.
You've been being disrespectful. You've been being disrespectful.
I need to know what your position is regarding the jury instructions. And I need to know it now.
What you mean? Who you talking to?
I'm talking to you. I need to know whether you have any requests as it relates to the jury instructions, sir.
Yeah, first of all, why am I charged with 2 bail jumpings when I was already charged in Milwaukee for the same bail jumping? That's double jeopardy.
It's not double jeopardy. Your objection is noted. It's overruled.
It is double jeopardy. How you gonna charge me with the same charge that I'm already charged with? You can't do that. The Fifth Amendment says that you can't place somebody in jeopardy of life and limb. Twice. I'm already charged with the same count in Milwaukee. This is for the same case. It's the same bail jumping charge. So how am I charged with that here?
Sir, I'm not going to provide a legal explanation other than to say I've reviewed that. Your objection is noted, but the jury will be instructed regarding the bail jumping.
It can't be because that's double jeopardy. Under the law, if two charges are identical in nature, you cannot place me in jeopardy of life and limb twice. You can't do that.
What's your next?
The same case number.
What's your next request, sir? I'm noting your objection.
I'm trying to talk. Can I get it out? You always want me to not interrupt you, but you always find a way to talk over me.
I understand your position. I'm saying it's overruled.
You always want respect, but don't want to give it. I'm charged with the same bail jumping charge here that I've already been charged with. That is double jeopardy. You can't charge me for the same exact bail jumping that I'm already charged with, that I was charged with before this even came about.
Sir, the bail jumping charges in Waukesha County are based upon your violating your bail while in Waukesha County by driving through the Christmas parade and allegedly killing 6 people and injuring 61 others.
Okay.
That's the distinction.
Again, there is no distinction. It's the same charge.
It's the same offense. It doesn't mean it's the same factual basis, sir.
He is not
It
charged
is.
with bail jumping with the data violation of November 21 in Milwaukee County anywhere. Further, the double jeopardy prohibition would prevent him from being convicted twice, not charged twice.
All right, so we've addressed that, sir. What other requests do you have as it relates to the jury instructions?
No, I want to know why I'm even charged twice with the same thing. You can't charge me in pursuant to a case in Milwaukee that I'm already charged with bail jumping for. I'm already charged with bail jumping for that already. So you can't essentially say, oh, well, because you were already on bail, we're going to charge you.
It's a different data violation, sir. The conduct for the bail jumping is related to the allegation that you committed a new crime in Waukesha County while out on bond from the Milwaukee County case.
Yeah, but I'm referring to the first bail jumping count, the first. I'm not referring to both of them, I'm referring to one of them.
My understanding, sir, is there's different dates of violations as it relates to that. So I've noted your objection now repeatedly. I understand it. Your request to, I guess, dismiss the bail jumping counts are denied.
I didn't say nothing about counts, I said one.
Whether it's one count or both, it's denied.
Am I not being understood? You can't charge me with the same charge twice, you can't.
It's two separate cases, sir. There's two.
Isn't that 971.23? Isn't that the statute? That refers to the double.
All right, sir, I'm not going to have an argument. This isn't fruitful. I understand what you're saying. You're saying there shouldn't be two counts of bail jumping. You believe it's double jeopardy. I disagree with that. They're separate.
I'm already charged with it, though.
This is a circular argument, sir. It doesn't change the fact that, from my perspective, the two bail jumping counts are going to proceed forward. There's been sufficient evidence presented to warrant the jury being instructed.
They can't.
What other requests do you have,
You're not
sir?
gonna talk over me. Don't talk over me. Just like you don't want me to talk over you. Just like you don't want me to talk over you. Just like you don't want
Mr. Brooks, what other requests do you have?
And I just asked you not to talk over me. You've been making your record the whole time you've been over there. You had me muted. I didn't see no requests over there. I didn't write nothing to go over there. I let you do what you was doing. No matter how egregious and biased it is, I let you do what you was doing. Because we both know that what you're doing is not right.
Mr. Brooks, I'm going to refocus your attention to the jury instructions. All of your objections are noted. I understand that. If you can't answer my question, I'm going to move on.
You can't. I haven't given you consent. Just like
All right, I'm going to mute him once again. He refuses to answer simple questions regarding if he has any requests. He just made an argument regarding the bail jumping, so clearly he has an understanding about the law as it relates to that. It may be a misunderstanding about the law and double jeopardy, but he made an argument. I've denied it. I'd like to know if he has any other requests. If he can stay on topic, I'll I will unmute him again, and he can tell me the list, just like the state went through a list. I need to get through their list. I'm asking you to list out all your requests, and then I will take each one up in turn. So here is your opportunity to give me your other requests, not debate with me about prior rulings. Go ahead, Mr. Brooks.
Don't sit up here and try to play no game talking about you giving somebody an opportunity that you haven't gave me an opportunity to properly defend myself and put evidence, put stuff into evidence, which I've asked you repeatedly to do before we even got to this trial. You told me we wasn't in the evidentiary phase.
Mr. Brooks, do you have any other requests as it relates to the jury instructions? This is probably the 10th or so time I've asked you this question.
No, it's not. No, it's not. So please stop being incorrect, Your Honor. Please stop.
Do you have any additional requests as it relates to the jury instructions?
Yes.
Oh.
That first count 74 bail jumping needs to be dismissed. You can't charge me with two things. You can't charge me with the same charge twice.
All right, I've made a note of that. What's the next issue?
Either one county gonna charge me with it or y'all, but it can't be both. It's the same, it's pursuant to the same exact thing that I was on bail for. The same exact thing, the same exact case. So why are we giving the jury instructions on two cases from another county?
I've made a note of that. What other requests do you have?
Man, this is ridiculous. So I'm not even able to adequately defend myself, present evidence, do anything, because everything I say is going to be found a reason for it not to be valid. What are we doing here, Your Honor? What is the
Mr. Brooks.
Why should I be here when
I've made a note of your request as to count 74. Do you have any other requests as it relates to the jury instructions?
Why are we even having jury instructions? Why do I have to even sit here in this courtroom at this point? Because everything you've been.
Oh my gosh, I have to stop it for just a quick second. Oh my God, I had to go grab another cup of coffee. And let the dog out for a couple minutes. But I was reading through your all's comments as I was watching. And somebody said something about a Timu Ike Turner, and I almost fell out. I can't remember who it was. Who was it? Was it Skylab? Oh, where did it go? Hold on, I have to scroll way up here. Oh, and Sharon, the Linus Wallace, super cute. I checked them out. Super cute stuff. And yeah, they do remind me too, California Dreamer, very like South Parkish. Skylab, yeah, there it is. Timu Ike Turner's got a bee in his baby bonnet. Yes. Loved it. Ooh, pretty name. Is it Evelyn? Evelyn. I love that name. That's so pretty. He's concerned about the bail jumping, not the murder counts, right? I know. Hi and welcome. Remember, guys, if you get a speeding ticket in one county, you then cannot be charged again if you get another speeding ticket in another county. Yes. Sure. Yeah. Bail jumping is the least of his problems, right? I saw someone had said okay, here it is. Evelyn says he's going on trial again this summer for another case in Milwaukee. He's a wearer downer. Yeah, he is. That's a medical diagnosis too. Thank you, Michelle. She tosses out the nerve pills and the chamomile tea, hot toddies. Oof. Along with a yoga mat. I don't know what I'll do with the yoga mat. I guess I could sit on it because God knows I can't do no yoga. Which, by the way, does anybody have any good, like, back strengthening exercises? I have gained so much weight that my back, like, I can't hardly stand up and walk around and do normal everyday housework without my back killing me anymore. And it's driving me crazy. It's like that burning. And I know it's like nerves, but still, I need some like back strengthening exercises or something to do. Hey, Rosebud, I'm glad you're back. Good to see you back, ma'am. How egregious. Egregious. Fool, it's egregious. He don't know words. Darrell Brooks is on my last good nerve. He's on my last bad nerve. Lower back, yes. Wall Pilates. I might look into that. But I know that's what it is. Like, I need... my back hurts because I'm out of shape, because I've gained so much weight. And literally just like your normal everyday, my dog's one in here. Normal everyday, just housework. Like, I have to sit down every little bit so my back will quit hurting for a minute. Need to strengthen the whole core. Your abs support your back muscles. I have the same pain. It's awful. I hate it. It's so bad that my little one, my 5-year-old, she'll walk around saying, "Oh, my back." Because she, like, mimics me all the time, right? You know how kids are. And so she'll walk around all the time, or if I ask her to do something, she'll say, "Oh, my back." Like, I will knock you into next Tuesday. Try to well, I do have, my sister bought me a couple 2 or 3 years ago for Christmas. It's, like one of those beanbag type footrests, and I keep it under my desk and I use it all day. But that does help a little bit. Brenda, I'm glad you've been able to lose some, ma'am. Skylab says, I use a gravity table. That is when it isn't being used as a hamper. A gravity table. What is that? Thanks, Tanika. It's fine when I'm just sitting, right? When I'm just sitting. It does hurt every once in a while if I sit for too long, but it's just when I'm up moving around, doing your normal everyday things. I'll go in there and clean the kitchen up and get the dishes put away out of the dishwasher, put dirty dishes in the dishwasher, clean the counters off, and after just a few minutes, I'm like, oh my God, my back is killing me. That's not normal. That's not good. I can't. Oh my goodness, I suffer from PTSD since 2022 every time I hear the word grounds. Well, you know what? You don't have to hear the word. We can see it. Look. Grounds. Grounds. But this is my new favorite. This is how Darrell Brooks makes me feel. That's how he makes me feel. I have a gravity chair. And let me tell you something, my husband and I swear by it. It's wonderful. Gravity chair. What in the name of God is it? I got to write that down. Gravity desk and gravity chair. Hold on a minute. Let me find something to write on. Gravity desk, gravity chair. When we get through these little tidbits of him temper tantruming, we're going to scooch on through to the actual, the actual rest of the meat and potatoes. Grounds in the coffee is grounds for divorce. Nothing worse, right? Laying on your tummy and alternating lifting right arm, left leg, then left arm, right leg is a good one for back and core. What is that called? There's a name for that. What is that called? Like the Superman or something? Superman. I'll write that down. Superman on belly. And then gravity desk and gravity table or chair. I've never heard of these. Maybe I haven't. I just don't know. You kind of lift your chest a bit too. Yes, Superman. Okay, that's right. Superman. I gotta check that out. Kel said every time he said grounds, Jenny flashed it on the screen. It was hilarious and took away a little bit of the irritation he was causing. Yeah. I had my finger on it too because it was when he was questioning. Every time he get to the end of a witness where he was doing do you know the plaintiff? Did you ever have coffee? Did you go to school with the plaintiff? You guys gave me those funny ha-has. And I knew that they were going to be objecting a lot, the prosecution. Then I would get that grounds picture ready to go. Technically, it's called an inversion table, maybe Latin for hamper. my God. That's funny. The Superman move is really good for your back. Mine is called an inversion table. Inversion table. Is that thing that it flips you upside down and it like stretches you out? That's what you guys are talking about. Okay. Okay, yeah, Google it. I've seen those. It looks like it would be very amazing. Nice. I need to check that out. I know I gotta check that out. My dog is dying to get in this room. Hold on a second. We'll get back to this.
You've been doing without my consent anyway.
But I'm gonna go
So
Google
you
that.
gonna find a way
Look
to
it
do
up.
this
Look
without
them
my
up.
consent. So why do I need to be here for?
Your objection for lack of consent is noted for the record.
Okay, yeah.
Any other requests,
You
sir?
talking big game. You talking big game to save yourself enough space. But everything got put up and has no merit in your court. None.
All right, I've asked him many times. I've advised him, and I'll advise him once again. If he fails to answer the question, I'm moving on. Do you have any other requests as it relates to the jury instructions, sir?
You can't move on because I haven't given you consent to.
All right, he did not answer. So I'm muting him again. The only request that he has made as it relates to the jury instructions, as he pounded his fist once again, raised his voice. I understand, I really do, that he's upset with my decision to cut off his ability to present a defense, but that decision was made based on his conduct and his conduct alone, as I've outlined already on the record. So the only request that he made was as it relates to the bail jumping counts. I'm denying those requests, whether it be to dismiss one count or to dismiss both on double jeopardy, or to just not instruct the jury. However way I interpret it, I'm denying that. All right, let me go through the state's.
Your Honor, can I add one more?
Sure.
I'm sorry. 154 summary of evidence. I believe we had a map, actually two maps that summarize the, we had three maps. I think the one was summarized his route, the path that he took. The other one summarized the victims who were struck in the specific locations. And the other one summarized the positions of the law enforcement officers at the various intersections and throughout the parade routes.
I'll make a note of that. I don't believe I saw the jury view instruction either. I mean, that was given to them at the time. I don't know that it needs to be reread, but I think we need to consider that as well. And that was my version of 152. All right, so let me go through the list from the state. Turning to page 61. So I've considered the request by the state. I am going to rely on what information they put in the charging document. I'm going to deny the request to include the specific case numbers. There's evidence, of course, that was received regarding the two separate cases out of Milwaukee County that form the basis for both of the bail jumping counts. It will be up to the jury to review the evidence and make a determination. As to the verdict forms, though, that were referenced previously, at least the description of them in the jury instructions, that obviously the third count of bail jumping is incorrect. That needs to be battery, and that change will be made. I'm also having Madam Clerk include all of the numbers for the jury instructions when they go back, so it's very clear. Some of them did not have them on, just frankly from prior cases that she and I have worked on, but in this case I want to be very clear with all of the numbers. So I think I've addressed the first two bullet points. As far as the motive instruction as a standalone, I believe that is appropriate. And I'll instruct Madam Clerk to include that. As far as where it
Big weird
goes,
bat.
I'm gonna just, any instructions that we add should just be in the numerical order. Unless there's a other request that's made. Then the state also made a request as it relates to jury instruction 70, which is found on page 65. So as it relates to this, the state is asking that I simply instruct the jury based on the pattern instruction and not include that second paragraph. I had previously advised the jury with another paragraph that I was contemplating including, even if I took out that big paragraph that just said, at times Mr. Brooks has appeared from another courtroom. This must not influence your verdict in any manner. What's the state's position on including that, but taking out the paragraph you request to be taken out?
That's fine.
Mr. Brooks, do you have any position on that? Which is, so jury instruction 70 has to do with the defendant proceeding pro se. The pattern instruction would be basically the first paragraph. I need the bailiffs to move the boxes away from his face. I need to be able to see him. He can keep them on the table, but they need to be moved off to the side. And if he does it one more time, then I will instruct the bailiffs to take the boxes away. Those are trial prep materials. If there's something in those materials related to jury instructions, he should take those out now. Otherwise, they need to be moved away from the microphones and away from blocking his face.
I'm not putting them there, I'm not putting them there, she can't see me, I'm putting them there for a reason. I'm nothing to do with her being able to see.
Mr. Brooks, do you have any position on the verbiage of jury instruction
Don't ask me-
70
don't
on
ask me
page
no question.
65?
Don't ask me no question. Are you my accuser? Are you my accuser, Your Honor?
All right, he's choosing not to answer, so I'll mute him again. It's unfortunate that he's deciding not to participate in this. I agree with the state. I don't need to highlight with that second paragraph. I will take that out, but I will include in the paragraph that reads, at times, comma, Mr. Brooks has appeared from another courtroom, period. This must not influence your verdict in any manner. Inclusion of the instructions that were put on the last couple of pages include 325 impeachment of witness. Its prior conviction, the part about juvenile adjudication, should be struck from the heading. And it should read, evidence has been received that one or more witness in this trial has been convicted of a crime. There were 2 witnesses that was applicable to. The remainder will be as is. And that was 1 witness for the state, 1 witness for the defense. I just will add that if Mr. Brooks has any position about these requests, he should, he is currently muted. He can raise his hand and I'll unmute. Otherwise, he can pass a note to the bailiff or simply tell the bailiff, who can then tell me and I can unmute him. But unless he tells me, then I'm going to assume he's made a decision not to provide further comment based upon the last statement he made to me. Then 141, I believe that's appropriate given the evidence that has been received. That's on identification of defendant is in issue. That I will instruct the jury accordingly unless there's a request from Mr. Brooks to take that out. Is there a request from you, sir, to take 141 out? I'll unmute for that purpose. It's found on page 106 because it's at the end of the instructions. This is the instruction on identification of the defendant and where it's at issue in a case. I believe it's appropriate given the testimony in this case. Do you have any position on that, sir? You are unmuted, so you can simply answer yes or no. No response. Then 172, circumstantial evidence, flight, concealment, I believe is appropriate given the evidence that has been received during this case. Yes, sir?
Am I unmuted?
You have been.
Am I unmuted?
You are.
So how long before you mute? As soon as I say something?
Depends on what you say, how you say it, and if it's responsive to what we're doing.
Why do I have to be responsive to what you guys are doing? Nothing I say even matters at this point, so what's the point of me being responsive? You can't make decisions for me.
Mr. Brooks, I'm gonna mute you unless you can participate in what we're doing, which is discussing the jury instructions.
I'm gonna tell the jury the truth. That's what I'm gonna do. I'm gonna tell them what hasn't been told to me. I haven't been able to.
Mr. Brooks, I'm gonna mute you because we're trying to discuss the jury instructions, not what you're going to say during your closing argument. I will get to that later. In terms of instruction 172, I'll instruct Madam Clerk to take out of the heading the word escape. Should just say flight concealment. And then I've reviewed 154. I believe that's appropriate. I'm going to pull it up just as a draft. I'm not sure if there's anything that needs to be. So the pattern instruction talks about a chart. Is there any request from the state as to just keep that or modify that in any way based upon the evidence that was presented?
Just pulling it up right now.
Because you actually submitted maps and things were received. I don't know that summary.
I think that there was a summary of the victims and the associated counts. I believe that that was exhibit 141.
But that was received, wasn't it?
And there were some charts of the extreme dance team, the formation, and dancing
Right.
grannies.
Do you have the exhibit list, Madam Clerk? Them. Typically, where that comes in is for use in openings and closings solely that are based upon evidence. And
Participate in none of that.
I understand, sir, your objection's noted. That covers all of the issues that were raised by the parties then.
Am I unmuted?
You are. I'll give you one final opportunity to tell me if you have any requests as it relates to the jury instructions, sir.
What you mean giving me one final thing? I didn't consent to nothing that this all been talked about. And I say God because I haven't been participating in none of that.
I understand, sir, your objection's noted. Your lack of consent is noted.
Okay, I don't see what's going on in there. So how's decisions being made without me being able to consent to it?
Sir, you forfeited your right to be present in this courtroom by your conduct, and you have not
No,
requested to
actually-
come back.
Actually, you took a break. So let's make sure the record is correct. You took a 10-minute break,
I did.
at which time I was brought back into this courtroom.
I was advised you wanted to stay, sir.
Okay, and you've been forcing me to come over here from the get-go. Why couldn't you force me to come back over here where I'm supposed to be at?
Sir, my understanding is you requested to stay in the other courtroom. I thought I put that on the record at the beginning. If I did not, I'll make that part of the record now. I was advised by the bailiffs that you were requesting to stay in that courtroom. I certainly advised you prior to that if there was a time you wanted to come back in, all you needed to do was ask. You've done that previously.
Yeah, but
And even even during this time, though, you've been incredibly disruptive
I can't say that.
during, I mean, at one point you were muted for an extended period of time and you were yelling so loud, sir. We could hear you in this courtroom. I couldn't decipher what you were saying. And I was also made aware that another branch could hear you. So you continued your disruptive behavior.
That's fine because
That camera that the person has there in the courtroom is like, whoa. Like, I'm assuming that camera could get so close up into somebody's nose to be able to count their nose hairs. I'm just...
at the end of the day, I should be heard. I have the First Amendment right to be heard. So if I'm going to be constantly muted, the only way for me to be heard is for me to raise my voice.
Mr. Brooks, one final time, do you have any requests as it relates to the jury instructions? Otherwise, I'm going to approve them. I'm going to take a break and then we'll come back in the afternoon to go over verdict forms.
I didn't answer yes or no, so how do you consent to anything without me answering the question?
Are you going to answer the question, sir?
But you can't force me to do it though. You can't just say, I'm going to do this because...
Sir, but you also can't stall the proceedings by failing to answer.
There you go.
I didn't try to start the proceedings. You the one that held me in contempt.
I never held you in contempt. All right, I'm going to mute him once again because he refuses to answer a very simple question about whether he has any requests as it relates to the jury instructions. I will work on making all the changes with Madam Clerk, finalizing the order, print them off again. She has been working on the verdict forms, which are of course separate, which need to be approved by this court. And so those will be printed off. A set will be provided to the state. A set will be provided to Mr. Brooks. We'll take I'll do a 90-minute lunch break. So it's 11:27. So we'll come back at 1 o'clock to finalize the verdicts and the jury instructions.
And Your Honor, with regard to sequestration of the jurors and the alternates and those issues, did you want to address those this afternoon?
Yes.
Okay,
Me
can
too,
do that.
Patricia.
thank you.
I can put on the record
I love that
I
a lot.
had the civilian jury bailiffs provide the parties. We have a letter regarding sequestration. There's an emergency contact form. So all of the jurors were made aware of that. They know that. Of course, once the case is, all of the instructions are read and the parties make their arguments, and then there's some final instructions at the end, and the case goes to the jury. Obviously, only 12 of the 15 will be deliberating, but we can make a more full record of that this afternoon.
Thank you.
All right, we are in recess until 1 o'clock. I'm just instructing the parties to stay until the handout of the verdict, and then you can leave for lunch. Thank you.
All right. So you guys putting the little screaming goats into the chat. You guys. Here, hold on. Let me turn the volume way down, though. Prepare your ears. Prepare your ears, because I hate being surprised with certain things. Where is it at? Here we go. All right. Prepare your ears. In 3, 2, 1. Here, let me put the volume up a little bit more. I'll put it up to like 50%, but still, it's going to be a lot louder. Prepare your ears. Prepare your ears. In 3, 2, 1. Oh my God. Hi, Northwest. Welcome. I'm glad Tanika sent you. Tanika, louder. Yeah, Tanika, right? Oh. Uh, Morgana said that sounds like me every day. So funny. All right, so we get through this 90-minute lunch break. Oh, he's back in the courtroom. Michelle, I'm that way with gifts. Like, I am like, I could have, you can ask the girls, some of the moderators in here. I could have an entire conversation with only gifs and memes. An entire conversation. Yeah. I could. Oh, he big mad. He's so mad. Oh, I didn't hit the play button. Play. Play. He's so mad. We have done that before in Discord, yes. Only in gifts, yes. I want just have an entire, like, all day long conversation with only gifts. Yeah. We have totally done that. Morgana, yep. Margaret says today's entire conversation is the hairbrush. Yeah. Yeah. Arrgh. All right, I'm going to speed it up and get to where we hear some talking. Ooh, I want to go back and look. Is that woman's, is that a jacket or a shawl? Either way, it's me. Hold on. It was sparkly. Well, she'd have it on. So I don't know if it's a jacket or a shawl. It looks like a shawl. Yeah, I think it is. Or like a, what do they call those? Wrap things. Bedazzled, yes. Pretty, pretty, pretty. Ooh, Morgana's throwing Michelle a Pepsi. I hope you guys went and got you some coffee. The voices are encouraging him to be even more stupid. A shawl. A shawl. All right, come on, come on. Looks like the dude there in the back, the poker face dude, got his hair cut this weekend. Everybody's getting all the things done on the weekends, man. Got his hair done over the weekend, and the judge got new nails. She got new nails.
As they were.
All right.
All right, we are back on the record. It is 1:01 p.m. State versus Brooks. Appearances are as they were before. I would note I have instructed, and Mr. Brooks is present in this courtroom. Prior to the, I understand your objections noted.
Pashmina.
If you would like to go back to the other courtroom, sir, you may, but that is a choice that you would be making. I am not requiring you. I'm not forcing you at this time.
So you're not holding me in contempt?
Sir, I am not requiring you or forcing you to go into the other courtroom. It is a new part of the day. I thought it.
Side note, I was looking up those inversion tables on Amazon. They're not badly priced. I mean, if anybody wants to tell me in the chat which one they got and how much it cost, I would love to hear that, because that sounds cool.
Appropriate to have you brought here,
Wow.
and only if you forfeit your right by conduct will I put you back in the other room.
So you going to address subject matter jurisdiction for the record, or are you going to state it on the record?
I'm declining to address that on the record for the reasons I've previously provided to you, not the least of which is I have addressed that by way of a written decision.
And it hasn't been proven for the record. You
Your
have to state
objection
it
is
on the
noted.
record. Can I go back in the other courtroom? Because I'm not going to do this with you. No.
Mr. Brooks, I do want to go over
We don't
the
have,
jury instructions.
I don't understand the
verdicts.
jury instructions. I don't understand anything that's in these proceedings, and I'm not going to participate in something that I don't understand.
That's your choice, sir.
May I please go back into the other courtroom?
You can, based upon your choice and your request, I'll make a finding that he's forfeiting his right to be present in this
I didn't forfeit
courtroom.
anything.
Yeah, you
I
are.
I
How do you
understand
not
that.
understand
I
that?
It's important to
anything.
also make a finding based upon your conduct.
Based upon what kind of me asking?
Are you willing to expressly waive that right on the record right now?
I'm not gonna expressively waive anything.
Are you willing to
I'm making-
engage in a colloquy regarding your right to be present and
That's
a
funny.
knowing and intelligent and voluntary waiver of that right?
I am not going to consent to anything that I don't understand, and I will not answer any questions that I don't understand.
My poker face is terrible too. Mine's horrible. I'm not good. I have no poker face at all. As a matter of fact, it's like, yeah, no. Yeah, the woman in the back, yeah, her facial expression, she's like,
I'm merely making a request to not be present in these proceedings.
And to be in the other courtroom?
Again, as I've stated numerous times now
Oh.
for the record,
one of the dancing
I will
grannies.
not answer or
Oof. I didn't
comply
realize,
with
didn't think
anything
about
I
that.
do not understand. I'm not making a voluntary waivery of anything.
Wavery.
Are you willing to be, let me rephrase that. If I have you stay in this courtroom, are you willing to follow the rules of decorum and courtesy?
I do not understand the question you are asking.
Are you willing to not interrupt the proceedings with disruptive behavior?
I do not understand the questions that you are asking.
Well, given that he won't answer the questions directly, for now, he is to remain in this courtroom.
I'm requesting to not be in this courtroom.
But you won't go through, you won't answer my questions regarding that, sir.
I did. I told you I don't understand.
That's not answering the question, sir.
You asked me a question, I answered it. I don't understand. How can I answer something that I do not understand, Your Honor?
Right, Northwest.
All right, let me start with the jury
You
instruction.
gonna
There
start
is
with,
one I
you
would
gonna start
like
with subject
to.
matter jurisdiction?
No, I've declined that already, sir. I'm not gonna address
Under
that
what
further.
law, under what lawful law?
Sir, please do not interrupt me again with the topic of subject matter jurisdiction, or you run the risk of forfeiting your right to be present in this courtroom.
Then let me go in the other courtroom then.
Are you willing to engage in a discussion about that, sir? I need to make an appropriate
I
record.
just told you that I don't understand the questions you're asking. What do you want me to do? I can't answer something I don't understand.
I believe you're choosing not to answer them,
You can
sir.
believe what you want to believe. I believe that you hiding stuff from the jury. I believe you haven't been impartial or fair. You haven't let me even enter anything into evidence, which is my right to do so.
Your
But it
rights
doesn't
are not
matter what we
unfettered,
believe,
sir.
Your Honor. I'm merely stating a request to not be present for these proceedings. I cannot answer the
Sir,
questions you are asking me
It
because I
seems to
don't
me
understand them.
You understand your right to be present in the courtroom. Are you telling me you
I don't understand
that right?
anything. Nope, I don't understand. Nope.
Then you're gonna stay here for now.
And under what lawful law? You can't force me to stay somewhere that I'm making a request not to. You can't make me understand. You can't force me to understand what I don't understand. You can't force that.
I need to address one of the jury instructions, number 315.
So, Your Honor, I'm trying to make a request to not be present in these matters without disrupting the courtroom, as you say that I do, and over talking you, as you state that I do. I'm making a request merely to not be present for these proceedings. Obviously, I'm not needed because every decision that's been made here today has been made without my consent. That's clearly telling me that I'm not needed. I have never consented to anything that's going on here today. I haven't even been allowed to present any evidence, which is something that I stated weeks ago. Weeks. You already knew, Your Honor, that I wanted things to present into evidence. I've asked numerous times for that and have been denied. And I don't understand why I'm not being able to adequately defend myself.
In your words, you're not being allowed to adequately defend yourself based upon your conduct in this courtroom and throughout these proceedings, and your unwillingness to follow the simple rules of decorum, courtesy, procedure, rules of evidence. You refused to answer a variety of questions this morning when this court went through or attempted to go through the colloquy with you regarding your right to testify and your right not to testify. And because of that, and based on the case law that I cited this morning, I made a finding that you forfeited your right to present further testimony and evidence through other witnesses, and then you forfeited your right to testify in your behalf. I'm not going to revisit those, sir.
I'm not asking you to revisit them, but they weren't correct.
I understand you will
Because
disagree with
I never
that.
consented to it and I never answered something.
I understand
And
you
I
did
just
not
stated
consent
the
to
reason
that.
why I didn't answer, because I don't understand. You cannot force me to understand what you're asking me.
Sir, I could
I
not
love
even
that,
get
Margaret.
through the advisement. You wouldn't even listen. You talked over me repeatedly.
Was that from the other courtroom or in here? Because I've been over there all morning.
To the place that you are requesting to go back to, right?
You sent me into the other courtroom.
You're right, I did.
Right. So I've been over there all morning.
With an adequate audio and visual system
I mean,
connecting the two courtrooms.
Your
The functional equivalent of
to
being
your
present in this
equivalent to
courtroom.
your equivalent is adequate, but to mine it's not. Seeing as how you always state Illinois versus Allen, you always state that, but it never refers to a fourth option that you refer to. It never
Mr.
refers
Brooks, I'm not
to
going to
that.
debate this with you. If you continue to bring up subject matter jurisdiction, Illinois
I
versus
didn't bring up
Allen,
subject
the
matter
decisions that I
jurisdiction.
made earlier,
I'm trying to figure out why I'm
then
being
you
held in
are
contempt.
frustrating the purposes of this
I'm
hearing
trying to
right
figure out
now,
why I'm being held
which
in
is to
contempt.
finalize the
And
jury
then when
instruction and the verdict forms.
Your Honor, I'm merely trying to understand why when you hold me in contempt,
I never held you in contempt, sir.
you attempted to.
Nope.
You've never attempted to hold me in contempt.
No, sir. I'm not going to revisit all of these issues.
When I asked you where you hold
Are
me in
you
contempt,
going
you
to
said civil.
respect the decisions that I've made
They're
by
not
interrupting
they're
me?
not correct decisions, Your Honor.
I understand that.
I can't answer. You asked me questions. I didn't answer them based on my understanding. How can you force me to understand what you're asking me if I don't? And then you still make a finding based on that. How is that lawful law?
Mr. Brooks, I stand behind the record that I've made today.
And that's fine. I'm not
advising you
arguing
that
with
if
you
you
about what you
continue
rude.
to talk
I'm saying,
over
how
me,
can you do that without my
If you
consent?
continue to raise issues that I've
That's
already
a violation
addressed,
of my civil rights.
if you continue to raise these issues, sir, and thwart the purpose of this court, which is to finalize the jury instruction and the verdict forms, you will forfeit your right to be present in the courtroom, and you will appear from the other courtroom.
Okay.
Absent you, I know
And
you've requested to be
I made a request the moment we walked in here to not be present for these proceedings, but yet
But you
still.
also won't have a dialogue with me about your understanding
Because
of what that
it's
means.
my Fifth Amendment right. I'm exercising my rights that I reserved from the moment we walked in here this morning. You can't force that. You can't
Oh
force
my God,
me.
I
You
would
can't
too.
force
Stop
me to do
it.
anything. Actually,
I would have flipped my wig 50,000 times by now, just today. She has the patience of Job, like we've said, but she also has a lot of self-control. A lot of self-control. Look at that woman's face back there. God love. I don't know if she's the dancing grannies or not, but man, look at her face. She's like,
No, you're right, but I can make certain findings that you forfeit rights
you
that
can't.
you have based upon your
and based on
conduct.
what lawful law you're under?
I've cited the law this morning. All right, I am moving
Illinois
on.
versus Allen, right?
I am
That I
moving
can
on.
be present from another courtroom.
I need
if I
to
forfeit
discuss
my right-
instruction 315.
Your Honor,
because
I don't
believe some language
understand.
needs to be modified based upon the court's earlier ruling today.
I don't understand. I don't understand the proceedings. And I think that should be stated for the record. If I'm telling you repeatedly, Your Honor, that I don't understand. You can't force me to understand. That's a violation of my constitutional rights to try to force something upon me. That's coercion, Your Honor.
Mr. Brooks, I completely disagree
Coercion.
with your characterization of the proceedings this morning. While it is true that you did not provide consent, you were entirely
didn't.
uncooperative with court this
That's
morning.
because I didn't
and-
understand. I'm explaining why, Your Honor. I'm
and the
not
court
trying to
gave
leave
you
it where it
ample
was at. I'm
opportunity
attempting
to
to
answer the questions.
I'm attempting to
So I'm gonna go.
explain myself of why I did not answer. It was because the way that you're making it
Right,
seem is
Margaret?
that I intentionally didn't want to answer, and that's
Mr.
not
Brooks,
fair.
I'm moving on to instruction 315.
And I still don't understand. So how can we even proceed?
Mr. Brooks,
if I'm telling you I
do
don't
you
understand?
understand what that I'm asking you to be
No, I
quiet?
don't. No.
he don't
I don't.
understand that.
Brooks, please stop
And
interrupting
for the
me.
record, I don't consent to being called that name,
You
Your Honor.
clearly hear me, sir, because if you didn't hear me,
Coercion?
then you wouldn't make that statement. So I
Hearing
know
and
you can hear
understanding
me.
is two different things.
I know you can hear me, sir. I'm asking
Hearing
you
and
to
understanding
stop
is two different
interrupting
things.
me.
I'm not trying to interrupt you, but you're gonna, at some point, you're gonna ask me my opinion of what's going on, and then when I tell you I don't understand, it's gonna be taken as me trying to delay or trying
If
to do
you
this or
stop
trying to do
talking,
that.
I will explain why I'm bringing up instruction 315.
And I'm not gonna understand your explanation.
Well, you can't say that if you haven't heard what I have to say.
Didn't you try to do this earlier, before lunch?
But I need to clarify something, because 315, which is the instruction that has it's titled, Defendant Elects Not to Testify. I had it in there. However, that instruction should really only be given if requested by the defendant. There has been no request made. And obviously this court made a finding that he forfeited his right to testify. And absent Mr. Brooks requesting that instruction to be in, I believe it would not be proper for this court to include 315 in the instructions to the jury. Does the state have any position on that?
Your Honor, I did look at the notes that are associated with instruction 315, and I would agree.
All right, Mr. Brooks, do you have any position on whether this court should include instruction 315?
That was exhausting.
In the jury instructions to the jury?
I don't even understand what 315 jury instruction is.
It's
I don't-
entitled Defendant Elects Not to Testify. I'll read it for you. It's my notes, meaning my materials, my jury instruction book says to be given only if requested by defendant, And it reads as follows. This is the actual language of the instruction. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. So my question is, do you want this instruction read or modified in any way?
You just said I got a constitutional right not to testify or to testify. I didn't make either one of those decisions, so I don't understand
The
what
jury
you're asking.
instruction is typically read when a defendant does not testify. In every other case that I've had, the decision on whether to testify was a decision made by the defendant personally. In this case, the court found that you forfeited your right to testify based upon your conduct. That is the ruling I made this morning.
How did I make that decision though? I didn't.
My question to
never say
you
yes or no.
is,
I never
do
say
you
yes or
want
no.
the jury instructed that your silence must not be considered by them in any way and must not influence their verdict in any manner?
What do you mean my silence? My Fifth Amendment right?
Correct. I'm not hearing a request from you to have the jury
Because I
given
don't.
this
I
instruction.
don't understand why you're asking me the question, Your Honor. I never decided to or not to testify. I never
understand
decided
that,
either
sir.
way.
I understand that.
So how can I answer that? I don't understand why. I don't understand.
We are now at the moment where we are discussing whether the jury should receive an instruction specifically on you not testifying, irrespective of the reason for that. I believe I could modify this instruction to simply say a defendant's silence or a defendant not testifying should not be considered by the jury in any way and must not influence their verdict in any manner. Are you making such a request for a modified instruction?
I don't understand the question because I never decided to or not to testify.
I
never
understand.
said-
I understand what you're saying, sir. I
never
really
said-
do. But in light of the court's decision that you forfeited your right to testify,
How did I
do
forfeit
you
something I
want
never
the
said?
jury to be instructed something to the effect of they cannot use your silence, meaning they cannot use you not testifying against you in any way?
I don't understand because I never made a decision not to or to testify.
I'll ask you one more time, and if you do not answer with a yes or no, I will take your answer of not answering as you are not making a request for a modified instruction.
How can you do that,
Do
Your
you
Honor?
want this court, sir, to instruct the jury in any way regarding you not testifying in this case?
I don't understand the question.
All right, then based
I don't
upon there's
understand.
not been an express request made by Mr. Brooks to give either 315 as it's in the standard or pattern jury instruction or a modification as this court has suggested, 315 is to be taken out of the jury instructions.
How are all these decisions being made without me understanding?
Then I have looked over the verdict forms, and other than really what I would describe as some consistency in how phrases, whether there's all caps, not all caps, but
All caps.
what we call the sentence
Like the name that was
capitalization
on
for
there,
the
all
charges. For example, I want to be consistent with how I spell out first degree intentional homicide or first degree recklessly endangering safety. There was just sometimes it was capitalized, sometimes it wasn't. So we're looking through all of that to be consistent. I want to make sure the word information is capitalized since that's the charging document, things of that nature. It is my practice, and you should be aware, Mr. Brooks, that I always put the not guilty verdicts on top when I hand all the verdict forms to the jury. And by that, I mean it's by charge. So they're collated, if you will. So the not guilty followed by the guilty for counts 1 through 76.
You said it's collated. What do that mean?
So I put the not guilty, then the guilty for count 1, followed by the not guilty and the guilty for count 2, and so on and so forth, all the way through the remainder of the counts that are alleged in this case, which in this case total 76.
I don't understand. So how?
I looked at the special questions
Will you
that
answer
are
that, Your
on the
Honor?
guilty verdicts only. They did appear to be proper, again, just some grammatical things, but I believe those are all accurate.
Can I
I'll
go to
turn
the other
the
courtroom?
state.
Since you don't have to answer any questions, but I have to answer all, can I just go to the other courtroom?
Not at this time.
Why not? I keep telling you I don't understand these proceedings, and you just keep running right over my rights, like you don't even hear me saying anything.
Attorney Basie, are you handling the verdict forms? Go ahead.
Can I go to the other courtroom, please?
Are you waiving your right to be present in this
I'm
courtroom?
not waiving anything.
Then the answer is no.
I'm making a request.
Then the answer is no.
Then how's it? So what? You gonna try to force me to interrupt and do all this so you
I'm
can
not
make the
forcing you,
record
sir. I'd
and
like
make
you
it
to be
seem like
here.
I forfeited something that I came in here as soon as we got on the record and made a request to not be present for these proceedings. But when I'm making a request to avoid the drama and all that,
Sir, the only one with the drama is you.
it's you too. You the big contributor to the whole thing.
Mr. Brooks, I have to preside over this case. I
Yeah,
have
and you
to
haven't
make
been
determinations.
impartial or fair yet.
Mr. Brooks, I have a question to the state. I ask that you not interrupt, and then I'll turn
It's
to
not
you
about
for
me
a response.
interrupting. It's about me attempting to understand. I've been saying that since we came in here.
Mr. Brooks, I
You
will
can't
respond
force me to
as follows
understand.
to that. You waived your right to counsel.
I didn't waive my right to no counsel. I
You
gave you the
waived your
contract.
right.
I did not. And you won't sit here and say that for the record because that is not
No,
what happened.
you are
No.
incorrect.
So we don't have do we have the
Your-
paperwork? Because I believe that I gave you the paperwork back that
Mr. Brooks, you
I
very
gave it to you, altered,
clearly
and did not waive it.
have been presenting a nuanced argument regarding
That
the
is
right
not
to
true, Your Honor.
counsel
That is not
versus
true.
the right to assistance of counsel.
That is not true.
That's a pretty sophisticated argument. That's why I believe you fully understand what's
I
going
don't.
on in this courtroom.
I don't fully
I
understand.
disagree with your
I
characterization
disagree with your
of the
characteristic.
right to counsel.
You know that you accepted
You
the way that I
waived
gave it to
the
you.
entirety-
So you shouldn't have did that if you had questions of me not understanding.
I don't have any questions
You
whatsoever.
definitely
sir.
do, because I'm telling you right now I don't understand, and you still won't even acknowledge the fact that I'm saying in open court on the record that I don't understand something. I haven't waived anything. You made decisions today that I didn't consent to, that I explained I did not answer because I didn't understand, which is my right to say that.
Right, Mr. Brooks, you
It's
are
also my Fifth
interfering
Amendment
with the
right to be
proper and
silent.
orderly administration of these proceedings. I understand that you disagree with the decisions that I have made, but you aren't respectful of the decisions. You keep wanting to debate them and argue them. That is not the proper legal recourse at this time. I have asked you if you're willing to waive your right to be present. You indicated you're not.
Because
And
of
yet
the way
you continue
put it.
to
You said
interrupt.
waive. I'm not waiving anything.
Then that's why you're here until I make a finding that you, by your conduct, are forfeiting your right to be present.
Well, make the finding and kick me out. Make the finding and hold me in contempt, which is what you waiting to do anyway. That's why that courtroom been set up the way it has for the whole time, because at some point it's anticipated that I will be over there. Which is not impartial and which is biased. It's judicial misconduct.
Hey, and welcome, Kendra. Hi, and welcome. She says, hey, all, I didn't know if I could watch any of this again, but apparently I can. His behavior just boggles the mind, right? Right. Also, like when she says decorum. I know I do too. I love when she says that. My other favorite word that she says or phrase is comfort breaks. Contempt doesn't work when someone's already in jail. Yeah. Well, this was a crazy one for sure, for sure, for sure.
I stated from the beginning, sir, that the goals of
I love when
This
she ignores
trial.
him.
So you reading from
Are
the paper, or
threefold.
are you reading, or are you just citing what you
number
know?
one, sir, is during the evidentiary phase of this was to control the presentation of evidence so as to ensure fairness and reliability
I know you are, but what am
of the
I?
criminal trial process.
And I offer
That
evidence
In the
that
Pee
you
Wee
can
Herman
allow.
voice.
developing relevant facts upon which a determination of guilt or innocence can be made. What is sometimes referred to in the case law as the ascertainment of truth. There's an equal but secondary purpose related to efficiency and effectiveness. That has been my repeated use of 906.11 is
Right,
what that
Margaret.
would fall under. There's a third goal of everything that I've done here, and that is the courtesy and decorum in this courtroom, what I've sometimes referred to as civility. Of course, there are other goals as well, including protecting your rights, protecting the record, protecting the jurors.
How have my rights been protected, Your Honor, if I can't even put evidence into
Disagreement
the...
with the
I can't
court
even make evidence.
decisions, sir.
Yeah, but how can
In
I defend myself if I can't even present evidence?
But sir, you have not been willing to follow the rules of civility
But
and
that doesn't have
decorum and
anything to do with my evidence.
It has
I could have did that
everything.
from the other courtroom too, correct?
Sir, you.
If I
by
can be
your
present from the
conduct-
other courtroom, I should be able to present evidence from the other courtroom as well.
And you, by your conduct this morning, sir, were
I'm
not
saying-
willing to
I'm
answer
saying-
the
I'm
most
saying
basic of
totality.
questions
The
about
totality, Your
whether
Honor. The
you
totality.
Totality.
Have
Have I
a
not
witness
asked?
available.
Have I not asked? In fairness, have I not asked to admit evidence? Have I not asked more than once?
Mr. Brooks, you have not asked to present any evidence.
Yes, I
in a
have.
legally
You told me we weren't at the
cognizable
evidentiary phase.
manner.
How would I know that if you didn't answer
And
answer the
you,
question?
as your own attorney, you proceed at your own peril sometimes.
That
Whether
has
you have a
nothing to do
full
with me
understanding of the
presenting
rules of
evidence.
procedure and rules of evidence or not. And
That
I
has
made that
nothing to do with me
abundantly
being able to
clear.
present evidence.
So, Mr. Brooks,
Nothing
this is your
I
final
presented have
warning.
been able.
Yeah, kids, driving down the road. What radio station we want to listen to? 906.11, Mom. 906.11 FM.
To be admitted into
I am
evidence.
turning to the state for a discussion of the verdict forms. If you interrupt me or them again, then I will make a finding that you forfeited your
Make
right
the
to be
finding.
We're
present.
smooth
Make the finding.
jazz
And you will
rocks.
appear from the neighboring courtroom.
You want me to appear from the neighboring courtroom? Let's just.
I don't.
Just let me go.
Attorney Basie, go
Just
ahead.
let me go.
I felt that all the verdict forms looked good. I did ask your
This is
clerk.
ridiculous.
All right, he's interrupted. He's forfeited his right to be here. He's chosen to do that despite the warning from the court. Will be
There
in
wasn't
recess
no
until
warning.
this
I'm the one
taken
that asked.
over.
Zach's
let's
looking
see
at
if
him
the
like,
court
Courtroom,
correct.
we
I'm
have
the one
the
that asked
audio
when we came in here, Your
and
Honor.
video working
I
appropriately.
asked when we came in here to
Madam
be
Clerk,
present
we'll
from the
have to
other
do it by
court.
Zoom because we may have to utilize the share screen in order.
We don't have to utilize no serious screen because I'm not gonna participate in no proceedings that I don't
The
understand.
documents.
I told you I don't understand
We're
a
in
million
recess until
times.
we get the courtroom set up.
No, we don't have to be in recess. I don't agree to it.
God, he is exhausting. Exhausting. Oh, I hear my husband. My husband home from work. Okay. Get this started and get an update from my husband. Hold on just a quick second.
Mr. Brooks is now appearing from the other courtroom. Appears he has headphones on. Speaking of headphones, I do need to make a correction to the record from this morning. I had made a statement that, given his demeanor, the headphones had been taken off the table by the bailiffs. I was incorrect. Mr. Brooks handed the headphones to the bailiff, saying he didn't want to break them. All right, so we are discussing the verdict forms. Go ahead, Attorney Basie, you can complete your record.
All the verdict forms look good. I did notice, and I think it was actually for the misspeed. For count 15, I have a not guilty verdict. I did not have a guilty verdict, but the way that it was on the paper made me believe that something happened, and I think you probably have it with your packet, it just didn't get printed off for me.
We'll make sure that that's there. Any misspellings of any names?
I did not see any.
All right. All right, I did, when we started up the video conference, Mr. Brooks has been muted. I am going to unmute him right now. And I should state again for the record, all of the verdict forms, or at least the drafts, were provided to him prior to the lunch break. So he would have had an opportunity to review them should he have chosen to do that. Do you have any position on the verdict form, sir?
I wasn't provided with anything, and if I was, I accepted and returned it for value. And since I'm now in another courtroom, are we gonna judge subject matter jurisdiction? You have yet to prove it for the record.
Mr. Brooks, you were provided with the verdict forms. What you did with them, I don't know.
Again, I haven't been provided with anything.
They were provided to you prior to lunch, the lunch
I
break.
haven't been provided with anything.
Teresa, you had the large packet of verdict forms. What were they, how were they given to Mr. Brooks prior to the lunch break?
By hand to the bailiff, and the bailiff they had.
To be- And the bailiffs are confirming that that the verdict forms were provided to him on his table. I will remind you once again
that's
that I do,
sweet, Dog
it is my
Mom.
practice.
That's so sweet. Dog Mom said, my sweet husband came home early from work to make me homemade chicken noodle soup. He is quite the cook. That's cool. My husband's the cook too. I like to bake. But my husband's the cook. I can cook, but I don't like to. And like, it's easy stuff that I make, you know. I do make a good meatloaf, but other than that, meh. That is very sweet, though. Yeah, how could we ever forget that? All right.
Practice to put all of the not guilty verdicts on top of the guilty verdicts in a collated fashion. Again, I saw a couple of just cleaning up, I would say, not with the words themselves, but just capitalization of various words within the verdict forms, and I'll make sure that's done. The appropriate counts had and have the appropriate special verdict questions. Those special verdict questions are only as they relate to guilty verdicts related to the use of a dangerous weapon for counts 1 through 6, the homicide counts, and then 61 through, I believe 60.
It would be 7 through.
7 through 67 have that special verdict, and then the hit and run counts have the special question related to, did each of the counts involve the death
cool.
of a person, and it names the person alleged to have been killed.
He loves
So
to bake
those look
too,
to
and
be
he
all
loves to
in
cook.
order.
There we go.
I've already addressed, going back to the jury instructions 315.
Ooh,
We
Sherry.
have done a little bit of
Sherry made chocolate chip cookies earlier. Woohoo! I'm not gonna lie, I love meatloaf. Like, I love a good meatloaf with mashed potatoes and, you know, I love meatloaf with mashed potatoes. Yum. Dog Mom said, oh my God, I make a really good meatloaf too. See, we're kindred spirit. Oh, wow. That's funny. That's funny. Very cool.
rearranging some of the order, but the content is there. It is my practice to
Yum.
read through all of the instructions up
I
until the
love Cracker
point
Barrel.
of closing arguments, and then I stop. Parties are given their opportunity to.
We had good old, okay, This is part of the crime cafe part, is the chitter chatter and the food talk, okay? This weekend, I did make, well, actually, my husband made the fried potatoes, but I made the soup beans and the cornbread. Made soup beans and cornbread, and we had fried potatoes. Oh my God, it was so good. So good. Corn on the cob and green beans. Yes. Say you're a Midwest kid without saying you're a Midwestern kid, right? Least favorite chore is definitely, Rosebud said she'd folded 7 loads of laundry. Oof. I hate that. Whenever I hear the word meatloaf, it makes me think of A Christmas Story. Meatloaf, beatloaf. I hate meatloaf. Fried potatoes, yes. Fried potatoes, yes, ma'am.
Argue the case to the jury, and then following that, there are the what I like to call the closing instructions, or which are still quite
Mine's
lengthy
on
in
the
this
couch.
case, given that they
Mine's
go
on the
through the
couch.
verdict form specifically. And then, of
Yum.
course, the alternate jurors would be selected. But given...
Mommy's little piggy.
No, you're not. You haven't been.
So I got a question about
I love that movie so much.
the enhancer for use of
Show me how the little piggies eat.
a dangerous weapon. How's that being charged? Is that under 939.632?
It is in the charging document, sir.
Warden Loaf.
How's that being charged? From my understanding that
Oh,
the
right.
statute reads the increased penalty provided in this section does not apply if possessing, using, or threatening to use a dangerous weapon is an essential element of the crime charged. Without the vehicle, there is no crime. So that would apply. So how am I charged with?
Yeah, the snort part.
State want to
Rather-
is your argument only as it relates to counts 1 through 6 or others?
Whichever
And in that
count-
part, I
whichever
swear,
count has the,
I'm sorry, I've interrupted so much today. In that part though, with the movie, where Randy is snorting while he's eating his meatloaf and got his face all shoved down into the mashed potatoes, Ralphie and the dad are looking at him like, but whenever Randy does that laugh, I swear it's this, I feel like it's the same kid who laughs and screams when they're going down the slide when they see Santa. It's like the same laughs and cries. I don't know.
the enhancement penalty for use of a dangerous weapon.
Well, that would be all of the intentional homicide charges and all of the first degree of recklessly endangering safety charges, so counts 1 through 67.
So one.
I'll make you a cup of something hot and hold it in your
Correct.
hands, Margaret.
I can have the state respond to that.
Yeah. How is the alleged defendant being charged?
So are you asking how are you making a specific
Me
request as
too.
it
I
relates to
binge
the
watched that
special
all
verdict
Christmas.
question?
Like Christmas Eve and Christmas Day, yes.
I would say both.
We had to buy the stupid I forget what app we had to find it on this Christmas, but used to, when we had regular TV, they would do the like 24-hour marathon of A Christmas Story on like TBS or TNT or one of those. But yeah, I would watch it. I would turn it on Christmas Eve and watch it all like for 2 days straight.
Seeing as how I don't understand how. That's why there's the question. Reading the statute.
Oh,
And which
cute,
part of this-
Patricia.
I'm sorry, which part of the statute are you referring to again?
I love that.
I
It's my
believe
favorite movie.
939.632.
And your specific argument is what again?
How is that enhancement, how is the alleged defendant charged with that enhancement when reading the statute, it says it, well, I just read it, so.
I believe you're referring to sub 2, which states the increased penalty provided in this section does not apply if possessing, using, or threatening to use a dangerous weapon is an essential element of the crime charge.
Right, that's what I just read, Your Honor.
On the record. Yeah, the kid with the goggles. He's the
Well, what's the
weirdo.
state's response?
Using, possessing, or threatening.
Oh, your
a dangerous
husband's name
weapon
is
not
Randy.
an essential element of either first-degree intentional homicide or first-degree recklessly endangering safety. If it were, it would be one of the elements in the standard jury instructions, and the defendant see it is not. This is different from a situation like armed robbery, which does require the use or threatened use of a dangerous weapon. So the penalty enhancer is correctly
I'm swooning right now
charged
too,
for those
Michelle.
two types of crimes.
Any final argument on that, sir?
Yes, that's not what the statute is clearly saying. It's clearly stated it does not apply if possessing, using, or threatening to use a dangerous weapon is an essential element of the crime charge. If there's no vehicle involved, where is the crime? It has to be an essential part of it to even be a crime. The alleged defendant is charged with
Alleged defendant.
using a vehicle to commit these crimes. If there's no vehicle, where's the crime? So it has to be an essential element of the crime. Otherwise, there's no crime. I think it's the essential element. If you read in the statute, it's the essential element. You can't just walk up to someone and quote unquote run them over. There has to be something used in order for this.
It's funny because this weekend I was cleaning house and I turned on some Christmas music. My husband comes in and he's like, "What are you doing?" I'm like, "We have snow. I want to hear Christmas music." He's like, "But Christmas is over." And I'm like, "Yeah, I know, but we didn't have snow on Christmas." We didn't have snow on Christmas. We had a muddy Christmas. So now that we have lots and lots of snow, now I listen to Christmas music then too, but I'm like, now I really want to listen to some Christmas music.
Alleged crime to transpire, and that would essentially mean the quote unquote dangerous weapon. So without the quote unquote dangerous weapon, where's the crime? So how can it be charged when it is the essential element of the crime charge?
Double beat.
So, sir, I've listened to your
I hate
argument.
meatloaf.
I've read the statute. I've looked at the elements for intentional homicide and first-degree recklessly endangering safety. Neither one of those crimes have as an element in it use of a vehicle. There are certainly many different ways that both of those statutes can be violated. While it's true that in this particular case, the use of a vehicle is the mechanism or instrumentality that's being alleged to have been used, but it's not the same as being an essential element of the crime. I think the armed robbery crime is a good example of when you could not face an enhancer for use of a dangerous weapon because you can't have the crime of armed robbery without the threat or use of a dangerous weapon.
Put the tree back
so-
up. Put it up. Put it
You
up.
can't have this alleged crime without the use of the vehicle. It's the same.
I haven't
It's
taken
not
it
an essential
down.
element of either first-degree intentional homicide or first-degree recklessly endangering safety. So I'll deny the request to strike the enhancer for those reasons and find that it is properly before the jury for their determination.
Yep.
I respectfully object to that, Your Honor.
I'll play
Understood. Do you have
Christmas
any
music in
other
July. I don't care.
Challenges to the verdicts you'd like to raise at this time?
Yeah, would that be, would my objection to that be
I
noted for
love
the
that.
It is.
record? And I request a legal reconsideration of your ruling, Your Honor.
Denied.
Da-da-da-da-da-da. Da-da-da-da-da-da.
May I request a written finding of fact for your ruling, Your Honor?
Denied. Just for the record, it's my understanding that the verdict forms were put in the garbage by Mr. Brooks and they remain in there. That was provided to me by the bailiffs.
May I respectfully request a written judicial finding of facts and conclusion of law for this issue, Your Honor?
You may request it. The request is denied.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter?
This is not the proper
Oh,
court
that
to
is the
grant
Waltons,
such
isn't it? Wait.
For the
Okay.
record, may I move to
Wait.
stay these proceedings until this instant matter is adjudicated
Okay.
by a court of
Hold
competent.
on. Now I'm trying to think. How Little House goes. I need the music for Little House on the Prairie. Love that, matter of fact. Denied. Oh, wow. That's cool, Rosebud. She says, my autistic son listens to Christmas music all year round. I have an autistic son, too. And he loves anything holiday related, all the holidays. It doesn't have to just be Christmas. Although Christmas is his favorite, obviously, because presents. But, yeah. Mentally tries to beam it to you. Yeah. I started humming that and I was like, is this right? But it was the Waltons. The only other thing that's coming in my head is the Brady Bunch music. Why? I've watched plenty of Little House on the Prairie in my day.
Jurisdiction,
Your request is denied.
based on what law or fact?
Lore and
Your
fact.
request is not based in law or fact, sir.
I just read a statute that it came from. My argument was based on a statute, a Wisconsin statute.
I think so
request
too,
is noted.
Glenn.
Your objection to the court's finding and determination is noted. I decline to issue any type of written decision or stay pending appeal, noting there is no appeal that has been filed.
May I let the record show that this court will not allow the accused to adequately defend themselves in this matter?
The court's already made its findings regarding the forfeiture of right to testify and the forfeiture of the right to present additional evidence and testimony. I'm not going to revisit the same.
Which was not consented to. I never stated that I did or
Jill's
did not.
helping now
Understand.
too.
I understand.
So how can that decision be made on my behalf when I didn't say either way? What I stated was I didn't understand the questions being answered.
Sir, do you have any other questions or issues regarding the verdict forms?
Your Honor, are you making a judicial determination that you don't have to answer any questions?
Chill
I'm
and
not
dreamer.
answering those questions,
You
sir,
guys crack me
other than
up.
how I've already answered them.
Is that a judicial determination?
Sir, every decision I make is a determination by this court.
Is it a judicial
And my sister,
determination?
Mickey Jo,
Sir, I
she's
will ask you once more. Do you have any
massive Waltons fan too.
other issues
And I will
to
tell you
raise?
once more, I
with-
don't understand the questions that you are asking.
Hold on, I'm gonna have to go listen
Sir,
to
do you
Little
have
House
any
on the
other
Prairie
issues
music.
to raise with respect to the verdict forms?
I do not understand the questions that you are asking.
He has now
I don't
twice
understand.
not answered the question. I'll ask one last time and specifically advise him that his failure to answer the question will be taken by this court as a no. Sir, do you have any
what law of
additional?
fact- under what law of fact can you say no? When I
Sir,
tell
do you
I
have
don't
any
understand?
additional issues to raise with respect to the verdict forms?
I do not understand the questions that you are asking.
All right, he
I
has
don't
chosen
understand.
not to answer other than by saying he does not understand the questions. He did not specifically answer with a yes or no. Therefore, this court takes that as he does not have any additional issues
That
to
is-
raise with
that is
respect
incorrect.
to the
That is
verdict
incorrect.
forms.
That is incorrect. I stated I don't understand. You can't force me to understand something, Your Honor.
All right, did the state have any
It is-
other?
it is my
I'm
my
going to mute him
constitutional right.
momentarily.
It's
Mr.
my
Brooks, I'm muting you
constitutional
because
right.
I'm moving on to.
Do 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 do. There we go. Da 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 da. Oh, look at me! Look at my monitor. Dog mom said, I thought that was the wall. Yeah, I was behind. I got messed up. Sorry. Oh, wow, Rosebud. Both my sons are autistic in their early 20s. They're wonderful. Well, mine's 18. Mine's 18. And he's wonderful too. He's a pretty cool dude. Pretty cool dude. Yeah, I have an 18-year-old and a 5-year-old. I used to love the books. I can still see the cover of the Little House book.
To another topic, I understand you disagree with the court's rulings,
Oh,
but you need
wow,
to respect
Dreamer.
the rulings with proper etiquette in this courtroom.
That's pretty cool. California Dreamer says I'm on the spectrum as well. Nice. I love whenever we have people join us like that. Very, very cool. Rosebud, when I was younger, I had a friend that I grew up with that was autistic. And I protected her with my life. And we're still friends to this day. That's cool. I have a daughter who's going to be 45 this year, and a grandson will be 10 as well. Oh, wow. Strong sense of justice. There you go. There you go.
Which you are demonstrating once again you're not willing to follow, so I exercised my ability
Thanks,
to
Brenda.
press mute. Does the state have any other requests as it relates to the jury instructions? I want to kind of full circle back to that because I do need to approve of them.
Yes, we do not.
All right, Mr. Brooks, I'll ask you the same question. I will unmute. Do you have any additional requests as it relates
crazy,
to the jury
right?
instructions?
Yeah, I have questions related to all of them because I don't understand any of it.
There's
My
13
question
years
was not,
difference
do you have questions, but do
And
you
my
have any
answer
requests?
Between my
and my
kids.
answer was I don't understand. And I've made several requests.
The requests are not related to the jury instructions, which is the phase of this hearing that this court is attempting to conduct with you and give you the opportunity to fully participate. Mr. Brooks is
You did
choosing
not.
not to answer my questions.
You did not.
I'm going to mute him momentarily, sir. I will ask you one more time if you have any requests as it relates to the jury instructions. I then will ask you if you approve of the jury instructions. If you do not answer those questions as it relates to the question, do you have any requests as it relates to jury instructions, I will interpret that as a no. And if you do not specifically answer the question about the jury instructions, I will interpret that as your approval. So first question to you is, do you have any, and you're unmuted, do you have any requests at this point as it relates to the jury instructions?
And I just said before, I said I do. I said I don't understand the questions. Of course I have questions if I don't understand.
So do you have any
That's common
requests
sense.
for
He
any
is
additional
panicking,
instructions
yeah.
that are
Yeah.
not included, or to remove any that are included?
Yeah, remove them all until I understand. Or add the jury instructions that I have myself.
What jury instructions do you have, sir?
So now you don't know I had jury instructions and I told you this weeks ago.
What filing are you referring to, sir? If I've overlooked that, I will certainly reconsider, but I'm not
You
aware of a
overlook-
specific jury instruction.
It seems like you overlook a lot, Your Honor.
Can you point me to a specific filing?
So you have all my filings on file? Are you saying that you have my filings and they haven't been admitted into evidence?
Oh, my computer's not working.
Oh, now the computer's not working.
Oh, God.
Sir, please direct me to the specific filing that you're referring to that has a request related to jury instructions.
Yes.
You just
The
said,
average
you
age
just said you was
of the
referring to the
Congress
filings, right? You just
person.
said it?
That's not what I said.
Did you just say what filings are referring to jury instructions? Did you or did you not just say that?
I said, do you have a specific filing you can refer the court to that relates to jury instructions?
So is your computer working or is it not?
He won't answer a question directly to Nika because then things would be on course. He wants to delay and he just delay. Like I forget who in the chat says it. He's like he wants to like on Thomas the tank engine, you know, when Sir Topham Hatt says that we cannot, we don't want to cause confusion and delay.
Not working.
It's being a little temperamental, but I just can't use my search function. So if you can direct me to a filing, that would be great.
It would also be great for those filings to be admitted into evidence.
God.
Sir, simply filing something with the court does not make it evidence during the evidentiary phase of a trial. There are rules of procedure and rules of evidence that govern that.
And you told me to make all my filings in writing.
Sir, I said if you had a motion, it needed to be put in writing.
All those were motions.
Sir, what filing are you referring the court to?
Look through all my motions.
Sir, it's not my job to advocate on your behalf. If you have something in particular, sir,
I asked you to do your job.
Sir, if you have a specific request, now is the time to make it.
Well, how about this? I don't accept none of those jury instructions. I don't accept any of them. Any of them. And again, I'll tell you, I don't understand. Why do I have to keep saying this when it's clear that I don't understand?
Your Honor, I can inform the court that jury instructions were due, I believe, on August 30th. The state submitted their proposed jury instructions as well as the substantive instructions, and the defense indicated that they agreed with our filing. So I don't believe that there's ever been a request for any different jury instructions than what have been filed with the court.
So what jury instructions are you referring to, or what document is being referred to on the alleged defendant's behalf? Because as we all know, I didn't obtain the discovery in full until the end of September. So there was documents that I didn't even know that existed.
Mr. Brooks, one final time. Do you have any specific requests as it relates to the jury instructions other than your request that they all be struck?
And I'm telling you, Your Honor, I don't understand the question. I can't.
All right, then I will take his response that he does not understand, that he does not have any additional requests.
I didn't say that.
And they will be
I said I don't
approved.
Understand.
They will be approved and are,
No.
I'm gonna have to mute him. They are approved as
I'm gonna have
been
to mute
drafted by
him.
the court and modified during the jury instruction conference on the record this morning and this afternoon. I will once again review all of them just for grammar, just to make sure all of that is correct, and provide a written printout of the final draft for the parties before we break for the day today. I am also approving of the verdict forms
I love that.
that have been previously submitted to the parties, just noting there's just a few grammatical things that need to be corrected, but the content and substance are there, and I've already addressed on the record any requests by the parties this afternoon.
No, Your Honor, I believe that the final copy that we've been working off of is appropriate.
Any comment about that, Mr. Brooks, or any statement?
I don't consider being called that name, and I've just told you I don't understand these jury questions. I'm not going to know how they allowed to pass just because you feel that they should. When I'm telling you I don't understand them.
I would note that
One of those jury instructions came from me, not one. How's that fair?
Mr. Brooks, this court gave you the draft of the jury instructions. I need to mute you because, once again, he's debating about things that I think are very clear on the record. This court provided both the state and Mr. Brooks with a written printout, 107 pages long, of the jury instructions it was considering in this case. We had a discussion this morning. We continued that discussion this afternoon. Prior to breaking for the lunch hour, all of the verdict forms were printed off and provided to both the state and to Mr. Brooks. It is also true that when he was previously represented by counsel, the court had some specific deadlines related to jury instruction proposals, and the state reminded me that there essentially was not an objection raised regarding the proposal and the filing from the state. I had a brief opportunity to look through the record of the inmate communication forms that have been sent during this trial that are on file. I haven't seen anything that references jury instructions. I'm well aware that he has other filings, but I could not find anything related to jury instructions and any specific requests that he is making or made during this case.
Skylab, he was talking to a bailiff.
So for the record, I am approving of the verdicts, I am approving of the jury instructions, and once again, before we break for the day, I will make sure to provide the parties with written printouts of both of the documents as they now stand. Then there are a few other issues we need to go through. Attorney Basie, I think you brought these up prior to the break. Maybe it was Attorney Opper, in terms of scheduling and what I would consider other housekeeping issues, but go ahead and remind me once again of the issues you wanted to bring up. I think it was the alternates, sequestration, and there might have been a third.
Yes, Your Honor. The question is to the sequestration of the jurors once they are excused for deliberations, and should the timing require that, an overnight stay or something along those lines. We wanted to discuss that. We wanted to discuss what the court intended to do with the 3 alternates once they have been selected. It would be our request, the position that they should remain in a secure location, separate and apart from anyone else, unless and until full deliberations are complete by the 12 selected to decide the case, so that if needed, and in light of the brief COVID history we have on this record, if needed, one of the alternates could slide into position of one of the 12 who are deliberating, if that became necessary. So we wanted to address that, and then we just wanted to address timing generally for closing arguments, verdict returned by the jury, and then the court's intentions as to the rest of the week, should there be guilty verdicts returned.
Sure. Before I address all of those, are there any of those final type of issues, sir, that you would want the court to address? You have been unmuted, so you can answer that. Mr. Brooks, do you have any of those final type of questions or issues that you want the court to address? You are unmuted. I am.
I just told you, since nothing I say even matters at this point, I'm just gonna tell the jury what they need to know. I'm just gonna tell them the truth.
Mr. Brooks, you are aware that your closing arguments have to be based on law and fact, correct?
They're gonna be based on whatever I'll base them on.
Well, I trust the
Skylab.
state will object when appropriate,
Well,
if
It's gonna
appropriate.
be a whole lot of objection here because I'm gonna tell the truth. You haven't allowed, you just been making all the decisions for me. Even though I told you repeatedly that I don't understand, and you still make decisions based on my behalf without my consent, without me. I'm telling you I don't understand, and you still make a decision determining my life.
Are you telling me, sir, that you will refuse to follow the simple rules of decorum, courtesy, civility, the rules of evidence, and
don't try to come with
rules
those
of
slick
procedure?
words. Don't try to come with your slick words, and don't put words in my mouth.
Sir, I am not being slick. I'm trying to
You've
preserve the
been
integrity.
slick. You've been slick.
All right, I'm going to mute you, sir, since what you are saying is not productive. It is not courteous. It is disrespectful.
I don't care.
I need to go
I don't
over
care
these.
what you say.
All right, I'm muting him because I need to go over these important issues that have been raised by the state. So as far as the alternates, I do think it is important to keep the alternates who in a secure location, even if that means an overnight, unless and until verdicts are reached in this matter, and I will so instruct the clerk of courts to make those arrangements. We have been doing that all along in any event. As far as selecting the alternates, obviously each of our jurors have a number. I intend to have pieces of equal size pieces of paper made, folded up with each of their numbers, put them in the same turnstile bin that we utilized for the selection of jury preemptory strikes by lot, and to simply pull out 3 names. Those will be the alternates, and then or I should say not names, the numbers, and then the numbers that are remaining would be those 12 who will deliberate. And so I'll make sure that that's out here. for the appropriate time. As I indicated this morning, all of the jurors were provided with some information regarding sequestration. It is the practice of that I've approved in this case that the jurors provide us with certain emergency contact information so that we are able to get a hold of families should there be the need. They're given information regarding sequestration, the purpose of it. If I have not made...
Hi Holly, welcome. Welcome. Glad to have you join us. She says, just saw this streaming. This was my very first YouTube trial I ever watched. I was highly entertained. Entertaining is one word, right? Definitely entertained. So when this is over, do you guys want to scooch on over to the following day, which would be day 14, and listen to their closing arguments and watch the verdict? Trying to remember. Let me see real quick. Hold on, I'm looking. Yeah, let me know what you guys think. Okay. Right, California Dreamer. Will spoil you from other trials. They're much less action-packed in comparison, right? True. Okay, you guys are up for it. Oh, God, right? Yes. Lots of yelling. There was lots of yelling and me like saying, are you kidding me right now? Is this for real? Michelle says yes, but I don't think I can take the victim impact statements before sentencing. Yeah. Well, we'll have to do the victim impact statements and the sentencing on a separate day because that does take some time, you know. But we'll do that tomorrow. But I wanted to get through the others today if we can. Thankfully, I can skip through all that wait time, right? All right.
Made that a part of the record. I will make sure to get a copy of that filed in this case so that both sides know what was provided to the jurors today before they left. And then I'll also make sure that when the 12 are deliberating, that the 3 who are not are taken to a different jury room with a bailiff, and again, kept in a secure location, but separate from the other 12. In the event one would be needed, we would then take up that issue at that time, but I think it's good practice to have them available if that becomes an issue. As far as timing, I'll first address, I have instructed the jurors to be back at 9 a.m. That's because typically we have a few things to finalize in the morning, so we'll start at 8:30 tomorrow morning. It will also give the parties one final opportunity to read through the many, many pages of jury instructions and verdict forms to just make sure there aren't any other issues that jump off the page or that need to be addressed first thing tomorrow morning. But then I do intend to start with instructing the jury. This case will require a very lengthy time of the court reading off the jury instructions. I do believe it will require me to take some regular breaks, probably every 2 hours, until the jury instructions are read with perhaps a longer break at the lunch hour. And my best guess is that it'll take between 5 and 6 hours to fully instruct the jury. That's based on the 107 pages. Now, some of those pages, though, are after argument. And so that really kind of begs the question is, will the parties get to their closing arguments tomorrow, or will that be done Wednesday morning? I certainly would like to have the parties make their arguments. Now, clerk, can I see the instructions that we have thus far? The packet? I just,
It should be done.
okay, thank you.
And again, the reason why it takes so long for her to get through the close or the jury instructions is because there were 77 counts. So she has to read through each of those. You know, and if you find them guilty of this, then for count 35. You know, I mean, she has to go through that whole thing with each and every count. Yeah, the pain is raw. Yeah. Ooh, sourdough bread. Yum. That sounds so good. Yum, yum. I love bread, though.
So the instructions that I read prior to the parties giving their closing arguments finishes on page 73. So
Yeah, no, we'll be skipping through all that, Ms. King.
I believe that the parties will be able to give their closing arguments tomorrow. It just may be, depending on where that takes us, whether the final
skip through all of
instructions
that.
are given the following morning.
I'm just waiting to see.
Because that's another 30 pages. I'd like to be able to do it. It just really depends on how late of an evening. I'm not opposed to going late.
I just want to see if there's any more fussing and fighting between him and anybody else before
Letting the
this
jurors
day
go to the
ends.
hotel and then starting their deliberations in the morning if that's what needs to be done.
Understood, and we'll be ready. I think from our recollection, it took you about 2.5 hours to read the preliminary instructions, which is 69 pages in length. So if that holds, I think, we reasonably could do closings in the afternoon, and it'd probably take you about an hour, hour and a half to read those remaining 30 pages. And we may still be able to wrap up by 4 or 5 o'clock in the courtroom.
I think that's a reasonable time frame. Do you have any estimation on the length of your closing? I'm contemplating maybe putting a time restriction for both parties. I mean, we had a solid 15 days of testimony, so I'm mindful that this is not a 30-minute closing.
Well, actually, I'm trying to keep it in the 30 to 45-minute range, just out of courtesy to the jury, and to highlight the important points.
Do you think it would be reasonable to give the parties each an hour total? That would reserve whatever's left from your initial for your any rebuttal.
Yes.
All right, Mr. Brooks, do you have any position on that? I am unmuting you. I would note he takes the headphones on and off throughout. He doesn't have them on. He's looking at a book.
I wish you would stop saying, look, I'm looking at the Bible. Thank you. It's not just a book, it's the book.
Can't disagree with you there, sir.
Yeah. How many people actually live like that? Anyway.
Sir, I'm contemplating putting an hour time limit on closing arguments.
I ain't doing no closing
Wow.
argument tomorrow.
Did he
The closing
literally
arguments
just
will most likely
say
be
how many
tomorrow.
people
Yeah.
live by it? Is that what he just said? Did he just say how many people live by it? I can't with him. What? I gotta rewind that and listen to this in normal speed. Sorry, I can't with this.
Oh, he takes the headphones on and off throughout. He doesn't have them on. He's looking at a book.
Yes.
I wish you would stop saying, look, I'm looking at the Bible. Thank you. It's not just a book, it's the book.
Can't disagree with you there, sir.
Yeah. How many people actually live like that? Anyway.
Wow. Like he does, right, Kel? I know. Yeah.
Sir, I'm contemplating putting an hour time limit on closing arguments.
I ain't doing no closing argument tomorrow.
The closing arguments will most likely be tomorrow.
I'm
Given,
not doing it tomorrow.
then you'll forfeit your right to give one, sir, because as we have,
You can't force me not. What type of court is this where you can say you're gonna force somebody not to be able to give a closing argument? How is that lawful
sir,
law?
if you choose
How
not
is
to
that
give
lawful law?
one,
How is that lawful law?
sir, if you choose not to give
Good.
one you're not letting me finish and you're mocking me right now, which is incredibly disrespectful once again.
Okay.
You didn't even let me get my sentence out.
You always want to make an incorrect record. Go ahead. Make your incorrect record. Go ahead.
I'll mute him once again because clearly he just wants to be disruptive this afternoon. But as we have been talking about over the course of the last, 10, 15 minutes, talking about the timing of everything tomorrow, even though I have 107 pages of jury instructions,
I guess so,
the
because she
first
said
73, I think, deal with what is
overnight.
read prior to closing
Opera did a while
arguments.
ago.
That means the parties should be prepared to give their closing arguments tomorrow afternoon. I will do my very best with just one mid-morning break to get through all of these, the first part of the instructions. Then the state will give its closing argument. I'm giving the parties 1 hour each. I think that's reasonable under the circumstances. Whatever the state doesn't use in its initial time of closing arguments, it can reserve for rebuttal. But then following the state, we may need to take a break of some sorts, probably before the defendant goes, just for the jury's sake and the party's sake. We will need a comfort break. But you should be prepared to go tomorrow afternoon. Then the state, if they have any rebuttal, will get up within that time limit. I will myself, and I'll have my clerk make sure we accurately time that. I will read the final instructions, and I'll really leave it in the jury's hands. If they want to start deliberating, that's fine. If it's 7 o'clock at night, I'll probably tell them we're going to break for the night. They'll be sequestered, but they will come back and begin deliberations in the morning. That'll be Wednesday morning. But now that I really kind of laid that out and thought about the break I will have for closing arguments with even my 107 pages, we can get this done tomorrow. And so that's my expectation. So, Mr. Brooks, I'll unmute you, but that is the expectation of the court, that closing arguments will be done tomorrow.
You can't rush me to judgment, or you can't practice law from the bench and tell me when I can do something and when I can't.
Mr. Brooks, I actually can, under all of the rules of procedure. It is my job to make sure there's effective and efficient administration of this trial.
So then I should be allowed to, then if that's the case, then I should be allowed to tell the jury what they need to know, which is the truth, that they have the power. They have the power to nullify laws if they don't agree.
You are absolutely not allowed to tell the jury that. There's a jury instruction that I will have ready to go if you even attempt to raise the issue of jury nullification, sir. You have absolutely...
They have the power. They have the power.
No right to raise that. That is clear under the law.
I can raise what I want to raise.
Power.
And you can't, so you added these jury instructions at the last minute, then you should have never approved them from the get-go because I never approved them. I told you I didn't understand them at all whatsoever, and you still passed it.
Sir, if you understand jury nullification, you understand jury instructions. It's clear to me you've done your homework.
What you talking about? I don't care what you're talking about. I'm going to let them know that they can nullify any law they don't agree with, which is my right.
It is not your right to do that.
Say that it's not.
It is not your right to raise jury nullification.
Show me lawful law then.
God.
Show me.
All right, I'm going to mute him once again. He's starting to raise his voice. He's starting to hit his hands on the table. It's very clear to this court that it's going to be a challenge tomorrow during his closing arguments. He does not have an unfettered right to say whatever he wants or how he wants. If he is going to be adamant about defying the court's rules, which I will tell him in part what they are today, and I will work on that as we break and have a very clear advisement for him tomorrow morning. He may run the risk of being put in the other courtroom because he'll forfeit by his conduct his right to be present here, and I will be able then to exercise the mute function. I have
remember
to
that,
balance,
Holly.
frankly, the fact that he's in custody, that it takes time for this jury to be excused. They have to walk an entire hallway behind me. I frankly don't want him to look worse than what he's looked, frankly, in front of this court when they haven't been in this courtroom. I need to preserve how he looks to this jury. And I will need a very clear pledge by him that he will follow the rulings that I make as it relates to the closing arguments. He cannot raise jury nullification. He cannot raise facts that are not part of the record. He cannot raise subject matter jurisdiction. He needs to argue the facts based upon his theory, based upon the evidence that's been presented, and those are the bounds. If he's going to, I can only imagine there may be some objections by the state. If there is an objection, I expect that he will stop and wait for this court to rule on the objection. I expect that if I sustain an objection, that he will honor it. And if he can't pledge to follow these very simple rules of courtesy and decorum that are consistent with the rules of procedure and the rules of evidence, then he will be in that other courtroom for his closing argument, so that I can exercise mute, frankly, to protect how he looks to that jury. Because that is the balancing that I am tasked with tomorrow, is to ensure that this jury makes a determination based upon the evidence and the law. You do not have a right to talk about sympathy. That's very clear in the case law, whether it's evidence or arguments. The juries, if you read through the jury instructions, sir, you will see they are specifically told they will not be swayed by sympathy, by prejudice, or passion. They are not to be concerned themselves with any penalties. You can't argue penalties. You can't argue jury nullification. You can't argue legal issues that aren't relevant to the elements and the other law that's in these jury instructions. And those are the very clear rules that you will need to follow. And like any other time in this trial, if you don't do that, you will forfeit your right to argue your case to the
Jill.
jury, or forfeit your right to be present.
Well, first of all, I'm so sorry. I'm so sorry, Jill. That's awful. Wow. I'm so sorry. And it would take me a lot longer than 15 minutes to dig a 3-foot hole, I'm just saying. But I am very sorry. Very, very sorry.
For in this courtroom and appear from the other courtroom. And you are squarely put on notice of that here today, sir. With that, I think I've addressed all of the issues the state has asked me to address. Oh,
17.
one other issue, verdict timing. I know we have some time on this. I realize that there are many, many victims who may still be watching the proceedings remotely. There may be news media, in fact, that may want to cover the verdicts, and that this jury will take some time due to the sheer volume of counts in this case. When this court is advised that verdicts have been reached, I'm contemplating between 30 and 60 minutes before bringing everyone back into the courtroom for the verdicts to be read in open court. And if parties believe I need to wait longer, then let me know. But I think I think some of it will depend on is it late at night? Is it during the day? You know, are we dealing with any kind of traffic issues? I realize Mr. Brooks has family in Milwaukee area that may want to be here as well. Even if I consider kind of, you know, the outlying areas of Waukesha, you could be as much as 30 minutes away. So that's my initial thought on that. Any statement from the state on that?
Not on that issue directly, sir. I'm sorry, Your Honor.
It's okay.
I apologize.
Any other issues?
Yes, my other issue as to verdicts was seating, if you intended to maintain the designated benches for the reasons you just said.
I would intend to keep the seating as is.
Okay, and the other side,
Public.
reserved over there.
Wait minutes, victims occur.
I don't, how can you deprive me of my constitutional right? How can you trample on my constitutional right? How?
Sir, you can forfeit a number of constitutional rights by misconduct on your part.
Not if I reserve my rights. You can't let me reserve my rights and then take them from you.
Sir, I direct your attention to Chambers versus Mississippi,
I'm not
Rock
gonna
versus
hear none of that.
Arkansas, State
Because-
versus Anthony,
I
Illinois versus
remember
Allen,
that, he
Did
says.
they reserve their rights?
the
Did
Beneby
any of those
decision. There's a host of case law, sir.
Did they reserve their rights?
All right, sir, you are simply mistaken on that. So I'm muting him once again. He's not giving me any other issues to
That does sound peaceful, Tanika.
address. We are in recess.
Oh, I'm sorry, I had a few
Go
other.
ahead.
I'm
You
sorry.
do. I'm
Yeah.
sorry, go ahead.
I just wanted the record to reflect that at about 2:04 PM, your clerk had provided the final version of jury instructions to both the state and to the defense. I watched on video as Deputy Wittig left this courtroom, went over to the other courtroom, handed the final jury instructions to Mr. Brooks, and he immediately turned and dropped them to his left off the side of the table. I can't tell from the video if that's where the trash can is located or not, but I did see that immediate response after he was handed the final jury instructions. Another
Did that
thing.
include the verdicts or just the jury
Just
instructions?
the jury instructions, I'm still doing verdicts.
Okay, it's just the jury instructions, but thank you, because I didn't see that given some of the things I was looking at up here, so I appreciate that.
You slick.
Were all jurors, or will all jurors then be told to report with an overnight bag?
That's part of the instructions that
Okay,
they were
and you're
given.
gonna make that available to us?
Yes,
Okay.
I'll get Lauren down here right away, and I'll make sure that before Mr. Brooks is taken back to the cell.
So
I
they
see your
were
arms waving,
to
I'll
be
get you in a second,
sequestered then.
that he's provided with that as well.
All right.
And you as well.
And then one final thing as to timing, and again, I don't mean to be disrespectful to Mr. Brooks or anyone involved in this matter, but should there be any guilty verdicts in this case, would you be intending to proceed to
Should there
sentencing
be?
yet this week or at a future time?
You know, that's an interesting question because I don't know how many victims will want to speak. If we have time, I would certainly consider that. I mean, I have this entire week set aside yet.
I don't know what happened to it, Northwest. He had it
and
earlier.
I have
in
Monday
the
morning, but I have some
trial.
other things Monday afternoon, and then I am not available the rest of next week. So it really just depends on the timing. I would need to know from both the parties whether they anticipate anyone speaking other than the parties themselves. Any family members?
Yes,
I don't
we-
think I need a PSI. This is a trial. This is not like a guilty plea, so. Mr. Brooks, I'll get you. I'm unmuting you. Go ahead. Go ahead. You're unmuted.
And since we're all making records to make me look bad, I think we should say for the record that one of the rights I have is to demand that the court places in evidence any unrevealed contract, statute, laws, rules, or information being used against me under the Sixth Amendment. So how come that hasn't been placed in the evidence?
What law are you referring to, sir?
I'm referring to my rights under the Sixth Amendment.
And what
My
case law
constitutional
says you
right
have a
under the-
right to do exactly what you just said you have a right to do?
The Constitution, Amendment 6.
Sir, that is very general, your statement. It's vague. There's
Very
nothing specific
exclusive,
that you
right?
have referenced.
You want paragraph 2 or something like that? Is that what you want?
No, that's not what I'm saying, sir. You're making general arguments
also-
that aren't based in fact
Yeah.
and are overgeneralizations of what the law requires as well.
I accept for value and return for value any documents in this matter. Since, it might be another record of what I'm doing, since it's always a record of what I'm doing. And I also have the right to ask, is this common law or admiralty law? Because judging by the gold eagle on top of the flag, it's some explaining that needs to be done. And that is a military symbol. So is this a common law court or admiralty law court?
Mr. Brooks, I'm frankly not going to address these nonsense legal theories of yours. I'm muting you. They have been debunked. They are typical sovereign tactics that have no place in our judicial system. We are in recess. I'll see everyone tomorrow morning at 8:30. I'll just direct the bailiffs to wait until we have the verdict forms to give. And if it takes us longer than 30 minutes, we'll make sure they're delivered to him in his jail today. Thank you, everyone.
Thank you.
Ooh, 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 ooh. What did he say? By law. Oh my God. He's something else, man. Sheesh. All right. I'm scooching over to day 14. Yes, I am. Yes, I am. All right. Share this tab. Make it big for y'all. Let's X out of that. And then scooch. We got his boxes back. Lord have mercy. Right. Intentionally. There's a presser, dude. Press. I wonder if he ever has anybody walk up to him and just like poke him in the chest. The guy wearing the press shirt. Sorry. Press. So there's no audio. We don't have any audio yet. Ooh, when did that happen, Northwest? DB got hurt in prison. Anyone know what happened? I haven't.
And my 14th Amendment due process rights. I make a reservation for those rights, especially, but all rights at this time.
The record to reflect that the individual known to this court as Darrell Brooks is present in person in custody. He is appearing today in street clothes. He has a dress shirt and a tie on. He's also wearing a mask.
And I don't consent to being called that name for the record. As this paperwork I accept for value and return for value, as it does not state the correct name. It states the name of my client, the straw man. I am not this name in all capital letters. I do not identify by that name, nor do I know that individual.
Your objection is noted, it's baseless in law and fact, and that is simply a caption on a pleading
That
on
is not my
the
name.
final jury instructions.
That is not my name, for the record.
All right,
I
the
don't
record should
recognize that
reflect,
name or-
Mr. Brooks, I'm talking. The record should
don't.
reflect that at 3:23 p.m. yesterday, all of the verdict forms were printed off and provided to Mr. Brooks. I also provided him with an excerpt from the bench book on closing arguments. I left a copy on the state's table as well, and a second copy on the defense table today as well, so that I thought that would be helpful information as we are about that time in the proceeding for the parties to give their closing arguments. Of course, prior to that, the court will be reading through the final jury instructions. The parties were also given the updated version following the jury instruction conference yesterday as well. The total number of pages for that is 107. The court will be reading from the first 73 pages this morning. I do anticipate having to take one or two breaks before I complete all of that. My plan is to do that and then take the lunch break. And then when we come back from lunch, to have the parties provide they're not opening, their closing arguments. And then following the closing arguments, the court has the final jury instructions, which go through the closing instruction, instructions 460, 484, and all of the verdicts, and then the instruction to the jury 515 about their verdicts needing to be unanimous, and then selection of a presiding juror. The very last page, 107, actually is not read until the close of the case and only following receipt of verdicts or some other type of disposition that would result in the conclusion of the case. It's the instruction after the verdict is received. So page 107 is not something that will be read today. As indicated yesterday, I will be selecting the alternates by random selection. We'll use the tumbler and select 3 numbers out of that, but that will be done after all of the instructions are read and the parties have an opportunity to give their closing arguments.
Your Honor, set for value and return for value any documents that you just alluded to. I have not seen them.
Mr. Brooks, if you haven't seen them, that is by your choice. They were provided to you. I know on multiple occasions yesterday you threw items into the garbage can. The court retrieved the final jury instructions. I personally didn't. I had someone do it, had them placed on the table this morning, and any other items you threw in the garbage.
So is that the paperwork that I had to stay here for over an hour for?
Sir, I'm not going to discuss any further what we did during the jury instruction conference. The jury's going to be brought out a little bit later.
There was a conference. We talking about the proceedings from yesterday, or after you had told us we recessed?
Mr. Brooks?
I'm referring to after you called recess for the
Lord.
night yesterday. That's what I'm referring to.
Those
I was put in the
documents.
holding cell for over an hour because they said it was some paperwork that needed to
That
be.
is correct, sir. You were kept there in order for my clerk, who had to finalize 76 verdicts, 2 each, 1 not guilty, 1 guilty, and provide those to the parties. So that's why you were kept there, so those could be handed to you. My understanding is they were. I would need a bailiff to confirm for me whether he took those back to his cell or if they were put on his desk because he left them in the holding cell.
Left them in what holding cell? In here?
I have to look through his paperwork to see if they're on here.
What holding cell are you referring to, Your Honor?
Behind the door.
I didn't leave anything in that holding cell. I was just trying to figure out why I was in there so long.
Are those the verdicts?
Yeah.
All right, he has those. Thank you.
Is this the paperwork that was just put on my? It was the paperwork on the desk when I came in. That was on top of my folders.
Mr. Brooks, I know that you were given the opportunity to take them to your cell because that is what I was advised. Whether you did that or not, I don't know.
That's
But they
not
are
what
also on your desk now.
I accept for value and return for value any documents.
We did discuss all of the jury instructions and the verdicts yesterday.
So what was discussed when I was in the cell for over
There
an hour?
was no discussion, sir. The court was in recess. Madam Clerk was simply finalizing the paperwork based upon the discussion that was held on the record in open court yesterday.
I was told that I had to stay there per you.
Yes, so that we could provide them to you and you would have an opportunity to take them back to yourself.
But
should you wish
can
to
they have
review
been
them.
delivered to the jail?
Yes,
All
Jill.
right. I don't believe there's any other.
Yes, Jill. We are on day 14 now. Today is closing argument day. Closing argument day. We are going to skip through all of the closing or the jury instructions.
There are preliminary issues we
There are.
need to address other than an advisement, and I will have for Mr. Brooks. But let me turn to the parties and ask if there's anything preliminary to this phase of the trial, which is the jury instructions, the verdicts, and closing arguments from the state.
No, Your Honor, thank you.
All right, anything else from you, sir?
Yes, there is. Yesterday, I stressed to the court numerous times about me not understanding the proceedings, and essentially how decisions were being made on my behalf without my understanding or giving consent.
The court made various rulings yesterday. I made findings and ultimately made some determinations. I stand behind the record that was made. I'm not going to explain it further.
So a lot of those decisions were made when I was not present in the courtroom. I was in the other courtroom, correct?
That's true, sir.
Is that correct?
The record will indicate when those were made and where you were.
I can't see the record though. How am I supposed to know what the record will reflect?
Sir, the decisions were made yesterday. I'm not revisiting them today.
They need to be revisited, and it also needs to be talked about. Subject matter jurisdiction that has yet to be proven for the record. I'm still trying to understand, Your Honor, how you made a judicial determination on my behalf, which I did not give consent to, as you say, I forfeited my right to testify, which I never did. I never said I wanted to. I never said I didn't want to, but that decision was made for me. Also, the decision for the defense to rest its case was made for me, which I did not consent to, nor did I say I was ready to rest, or nor did I say I was ready to rest. I'm trying to understand how all these decisions are being made without my consent, without me waiving any rights. I'm not understanding how, because none of my answers were unresponsive. I just didn't answer the way that Your Honor wanted me to answer, but I stressed yesterday, if I don't understand something, how am I supposed to answer a question that I don't understand fundamentally? It's not me saying yes or no, and it's not me saying, okay, I want to waive this or that right. And I'm not trying to make an argument with you in any way. I'm just seeking to understand how these decisions are made. If I'm letting the court know and I'm putting the court on notice, hey, I don't understand this or I don't understand that.
Any other things? Otherwise, I'm prepared to address each one of those.
Yeah. There was a mention of if there is a conviction in this matter, there is a mention of sentencing, which I'm assuming there'll be some type of people may want to speak. I know if there is a conviction on my half, people would definitely want to address the court. There'll be a lot of affairs that need to be put in order, obviously on my side. If it pleases the court, if there is a conviction in this matter, I would like the sentencing to not be so quick. I'm asking if it pleases the court for the sentencing to be held off into a later time, not a day or two or a week, just so that affairs can be put in order properly, and so that the people that want to come in and speak will have the opportunity to address the court.
I think that's a fair request, sir.
If that pleases.
I think that's a fair request. I thought about that and some more overnight, that in the event there is a conviction, that I would like to give the parties an opportunity to do that. I have no idea how many people would want to speak. My inclination would be, again, and this is not set in stone, if there is a conviction on any of these counts, I may ask the parties to just come back in on Monday, October 31st with kind of a proposed plan of how many people do you think will speak on your behalf, how long do you think it will take, so that I can look at my calendar and then set aside the appropriate amount of time. I certainly don't want to rush anything, and I think that's a fair request that you're making.
Thank you.
All right. So with all of that then, sir, subject matter jurisdiction, I decline to address that further. I stand by the written decision that I've made previously. As far as the rulings made yesterday regarding your ability or inability to present further testimony and witnesses and to testify yourself, the court did make various rulings and findings that you had forfeited your right to do so by conduct. I'm not going to further explain the law or these prior rulings to you. I stand behind them, and I believe I made a very, very clear record. So to the extent that you are asking me to reconsider any of that, that's how I would interpret your statements here today. I decline to do so.
So, Your Honor, would that be, that's still not, I have no understanding to why I wasn't given the opportunity to place certain things into evidence. I have virtually nothing, zero evidence that I was able to place into evidence, nothing.
I disagree with that, sir. You called, I think, 9 witnesses on your behalf on various issues, including the honking of the horn, the window tinting. You cross-examined many of the state's witnesses about police barricades and the presence of police. So you did present evidence.
I'm speaking to the terms of everything that Your Honor asked me to do. You told me to put everything that I needed to present to the courts in writing. You made that ruling. You told me that's what I needed to do. I did that.
Mr. Brooks, you may have interpreted that. I did not require you to do that. As far as evidence in the case, I very expressly told you there are rules of procedure and rules of evidence that govern exhibits, testimony, witnesses, etc. What I told you is that any requests that you have related to the case, if it's a motion, be put in writing. I specifically referenced the statute 80201 regarding how a motion is made and what it should contain, meaning it has a very express request for relief and states the law and the facts upon which the request is being made. Again, I'm not going to revisit the prior rulings. I stand behind them, and to the extent that the record does not have, meaning the record before the jury and the evidence does not have certain pieces of information, evidence, or testimony that you wanted to present, you forfeited that opportunity yesterday based upon your conduct.
How did I forfeit the opportunity?
Again, I'm not going to revisit that. So what I will tell you is this.
How did I forfeit
this
the
jury
opportunity
is here
to be able to place into evidence?
Mr. Brooks, I'm not going to debate this further.
I'm not trying to debate. I'm trying to understand.
To respect the fact that I've made rulings.
Your Honor, that's you
it's
made
not
a
my
judicial
job to
determination.
explain them
You made
to
it.
you.
I'm not asking you to explain anything. You're misinterpreting what I'm trying to ask you and trying to tell you. You're misinterpreting it. With all due respect, Your Honor. When you tell me this is what you need to do, I'm going to take it by what you're telling me that I need to do. If I needed to make anything request-wise or anything that I needed to present to the court, it has to be in writing. You told me to do that. I did it. You also brought up when I asked numerous times before when would I have a chance to present things into evidence, you told me we were not at the evidentiary phase of the trial yet. So I took that as saying, okay, well, at some point I will have the opportunity to place things into evidence that need to be put in evidence for the record. So I'm not understanding how a decision can be made for me to actually forfeit being able to put things into the record that need to be placed into the record. All these things are things that, quite frankly, allow me to put on a defense. Things that need to be known, things that should be in the record, as far as filings, as far as ICFs that I was told to by you to address certain ICFs either to you or to the clerk of courts, which I did, and received copies for all of them except until last week. There's a few of them that I didn't receive copies for that I'm still wondering why I haven't received those copies when I received the copies of all the ones before that. But in terms of that, I did what Your Honor asked me to do. And these are things that were part of my defense that needed to be placed into the record. So where my confusion comes in is not being able to place those things into the record. Things that clearly help my defense.
I stand by my ruling. I'm not revisiting it. To the extent that you claim lack of understanding or your lack of consent, it's been made abundantly clear on this record your position on that. I'm not revisiting it. I'm further advising you that when this jury comes out, I expect that you will honor the decisions that were made, not agree, but you will honor them and not interrupt the court or these proceedings as I instruct the jury.
So how am I supposed to put these things in the record that need to be in the
Mr.
record?
Brooks, I'm well aware of the effect my ruling had, and I'm not going to debate it with you further.
I just want to know, how am I supposed to get these things on the record? How am I supposed to, because the filings that I gave, you actually filed and gave me the copies back. So are those in the record?
Mr. Brooks, I'm no longer going to talk about this.
I'm just seeking to understand.
Mr. Brooks, I cannot explain procedure or evidence
The filings that
or
I
the
filed.
rulings or
I'm
the
asking the
law
question,
to
Your Honor.
you.
I'm merely asking the question. The filings that I presented to Your Honor.
Any filings
For
with
the
this
court.
court are in the court record. That does not mean they're evidence, sir. And I told you that
That's not what I'm
previously.
asking. I'm asking, are the filings part of the record? The filings that were filed and timestamped, that were notarized, that I presented to the court, all the filings, the appearance bonds, the statement of particulars, the notice of special appearance, the court docket sheet, your oath of office, everything that I tried to present into the record. How am I not able to make them part of the record?
Sir, they were filed because you presented them to the court during the course of this case. Anything that was not offered as an exhibit and received during the evidentiary phase is not evidence in this trial.
That's what I attempted to do, and you told me that I couldn't. You told me,
Mr. Brooks, I am bringing this jury
Your Honor,
out.
with
Listen
all
to me.
respect, you told me that we were not at the evidence. When I said I have exhibits as well, I have stuff that I want to put into the record. I even asked, I said,
Mr.
may I
Brooks,
give an offer into evidence?
I'm going to stop you
things.
once again. I'm not going to have this discussion and debate. The evidentiary phase of this trial is closed.
It should
We are
not
now
be, though,
at the
Your
jury.
Honor.
I understand your lack of consent. Your
So
objection
when would I
is
be able to
noted
put?
for the
When
record.
would I be able to put vital information into the record, which I haven't had the opportunity to do?
That opportunity has closed for you, sir.
So you saying basically you're prejudicing my defense by me not being able to present things into evidence, offer into evidence, filings and important paperwork and documents.
Mr. Brooks, and you
How am I
forfeited
not-
your right to do that by your conduct yesterday, and I stand behind that decision.
I asked-
I'm
I
going to
asked
do the
before
following,
yesterday,
sir.
Your Honor.
I'm
I
going to
asked
do the
this before
following.
yesterday.
You have not honored my request to you that you cease debating me on prior rulings
I'm not trying to
of the
debate.
court.
I'm trying to understand why my due process is being violated.
Mr. Brooks, the record speaks for itself.
No, the record
I am
does
going
not.
to take
It
a
does not.
5-minute recess. When I come back out, the jury will also be coming out. I'm advising you, there will be no multiple opportunities where I give you to conform your conduct to the rules of decorum
Well, then
and courtesy.
just hold me in contempt then, Your Honor.
You are
Hold me in
hereby
contempt, 'cause I didn't even- I'm trying
that
to seek to
If
understand-
you start talking about subject matter jurisdiction or any of these other
It
issues,
needs to be addressed,
or
Your Honor.
in any way
We're not talking
interrupt
about subject matter jurisdiction.
the
We're
reading of
talking
the jury
about
instructions,
why my due process
I
has
will
been violated.
excuse the jury and you will be removed
Your
to
Honor,
the other courtroom.
We're talking about the 14th Amendment,
Right,
Section
I'm
1.
taking a 5-minute break. We are
Your
in
Honor, I
recess.
don't
When
agree
come
to a
back out, the
estoppel.
jury
I
will
don't
be
agree
coming
to a
as well.
estoppel. Your Honor, as a
Lord, Lord, Lord. Okay. Thankfully, we can skip through.
It has yet to be proven for the record.
Did
And
you
upon
see
your
her
refusal, that
roll
will be
her
looked at
eyes?
as this has yet to be proven
Watch.
for.
As soon as he starts talking,
Your Honor.
watch her.
It has yet to be proven for the record. And upon your refusal, that would be looked at as dishonor.
I'm not addressing it. The jury's coming out.
So is that a tacit agreement that you don't have to answer any
Oh,
questions? as a
did he
public
say
servant,
it
Your Honor?
right that time?
I'm not addressing it. The jury's coming out.
So is that a tacit agreement that you don't have to answer any questions as a public servant, Your Honor?
Yeah, I heard him
Therefore,
say a
being-
stopple.
that's dishonor.
I'm like, did I hear
Are you
him
gonna
right?
honor
I'm
your
like,
oath
it's
of
a
office?
stopple.
Understand, I'm not addressing it
Are you
further.
going to honor your oath of office?
All rise.
So I'll take that as a tacit agreement that you're not going to honor your
All
oath
right,
of
I'm going to
office?
have to excuse the jury.
Gonna have to excuse the jury. So it's like a 1 step forward and 2 steps back, Patricia. See, he comes in with the tacit instead of tacket. And he said it right twice so far in the last 30 seconds. But then we had the stopple. I don't know what a stopple is. I ain't never heard of a stopple. But, you know, we get 2 tacits, but we have to, you know, take a stopple. Subtle, right? God.
Mr. Brooks, I warned you that if you made any interruptions when they came out, you would be removed to the courtroom. That's what I'm doing right now. You are forfeiting your right to be present in this courtroom unless you can promise me
Well, there
right
we go.
now you'll respect.
There we go. Estoppel. The principle which precludes a person from asserting something contrary to what is implied by a previous action or statement of that person or by previous pertinent judicial determination. Patricia said estoppel is apparently a plug. Estoppel.
Prior rulings of this court and not interrupt this next phase of the trial, which is the court reading the jury instructions without interruption from you. Can you do that?
Have I acted in dishonor, Your Honor?
Mr. Brooks,
yeah.
I very expressly warned you.
Have I acted in dishonor?
You have disobeyed a direct order from this court.
Have I acted in dishonor?
You have disrupted these proceedings.
I have not disrupted these proceedings.
Sir, can you pledge to me that when this jury comes back out, that you will remain silent and not reference things like subject matter jurisdiction, the court's oath of office, tacit agreements, or anything? Can you pledge that you will respect these proceedings and this jury by not interrupting?
Have I acted in dishonor, Your Honor?
I will ask you one more time. Can you pledge to be quiet, sir?
Why should I have to make a pledge, Your Honor? Have I acted in dishonor?
Because under Illinois versus Allen, I believe you've already forfeited your right to be here, but you can reclaim that.
Can you
as soon as
pledge
you
to
are
be
willing
quiet?
To conduct yourself consistently with the decorum and respect inherent in these proceedings, which at this point in the proceedings, sir, all I am doing is reading through the final jury instructions. And I do not want that process interrupted by statements by you that are frankly misstatements of the law.
If they're misstatements of the law, Your Honor, how come they haven't been proven for the record? And I'm asking, have
All
I
right,
acted
he
in
refuses
dishonor?
to answer the
Have I
questions.
acted in
I have
dishonor,
given
Your
him
Honor?
an ample opportunity to do so. He has forfeited his right to be present for the reading of the jury instructions, and he is to be removed to the neighboring courtroom. We will be in recess until that takes place.
Your Honor,
Thank you.
have I acted in dishonor?
The Lemon Pledge of Allegiance by Chad Daybell. That's so funny. I got a coffee ground. Oh my God. I got a coffee ground. Mm-mm. Ooh. Can't handle coffee grounds. Grounds. Can you pledge to act minimally as a kindergartner? I don't think he can do it. I don't think he can do it. I don't think he can. I'm skipping through till we get some more audio. Hold on.
This court certainly doesn't take pleasure in removing, ask Madam, and in the other courtroom.
Okay.
Everyone, please be seated. The record should reflect that Mr. Brooks has been placed in the other courtroom. He is presently on mute so that I can make a record. I do need to confirm that the audio and visual equipment and system is working. I am getting a thumbs up from the bailiff. I'll just ask Madam Clerk to confirm with the clerk that's over there as well. I would note Mr. Brooks has the headphones on. This court certainly doesn't take pleasure in removing Mr. Brooks from this courtroom once again.
Don't
We are at
lie,
an important
Judge.
stage of this proceeding where the
You know
court
you do. I
needs to
would.
instruct the
Be
jury
like, let's just keep
concerning
him over there.
all of the law that will guide them in their deliberations. As I've put on the record previously, the total pages comes to 107. I will be reading this morning through page 73 prior to the parties given the opportunity to make closing arguments, and then reading from pages 74 to 106.
Bum ba da da dum. Dun da 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 da. Ba da ba da.
following that. It is very important that the court do this without interruption. Yesterday, this court held a jury instruction conference where both parties had a full and fair opportunity to raise objections regarding any of the proposed jury instructions, to make requests regarding inclusion of any jury instructions that the court did not include, as well as review all of the verdict forms. There's absolutely no reason for there to be an interruption or an objection to this process at this time. The court spent the better part of 25 minutes this morning with Mr. Brooks raising issues and prior rulings that this court has spent an abundant amount of time on, including subject matter jurisdiction. He continues to claim he did not consent. That's been noted for the record. He continues to claim that he has a limited or no understanding of prior rulings and decisions of this court. I repeatedly advised him I would not be revisiting these issues, that I wanted to go forward with the jury instructions, and repeatedly warned him that any interruption once the jury came out would result in his removal from the courtroom. Again, I take no pleasure in doing that. I prefer that he be here, but frankly, the decision I made here today, with the speed at which I made the decision here today, is not only to preserve the dignity of these proceedings, but to do so in a way that avoided the court admonishing Mr. Brooks in front of the jury. This, of course, comes on the history in this case with the repeated removals that this court has had to undertake with Mr. Brooks, given his conduct and his behavior in this case. I am currently being advised that he would like to come back. That, of course, is always something that I will give him. As soon as I make my full findings, I will pause, and he will be brought back into this courtroom so that he can be in attendance when the jury is brought out. Of course, my decision that I made this morning to remove him is based on the authority from Illinois versus Allen. I'd also note that State versus Anthony talks about the Allen decision.
I love how she says that. Illinois versus Allen. Illinois versus Allen.
And along with State versus Vaughn, those are two state court decisions. Clearly, even though Mr. Brooks was using a mild-mannered tone of voice, he directly disobeyed the court order that he not interrupt once the jury was brought out. He did that immediately upon the first juror walking in. I believe only a few of the jurors even walked in. He was continuing to talk. I immediately removed them from the courtroom to minimize the impact of his disruption. It was clearly disruptive, but again, he is asking to come back, and I will honor that request. I will further advise him, though, that should he interrupt during the jury instruction phase of this trial by either objecting or raising.
Yeah, I can't stand her. I can't stand her. Y'all did know that she tried to blame that on Tylee, right? That Tylee did that to JJ. You know that, right?
Issues
she's vile.
That have no bearing on the advisement to the jury by this court of all of the jury instructions. I will consider admonishing him in the presence of the jury, or simply removing the jury so that then I can admonish him and then making the appropriate record. All right, with that, since he's asking to come back,
Northwest,
we will take a pause. We'll recess. We'll come back in when he is set up in this courtroom. Thank you,
Sharon, that's been in the chat earlier today, I had never heard of that Linus Wallace person, but they do a really good job. Their animations remind me of like South Park, very South Parkish, very South Parkish. All right, he's back.
Thank you, everyone. Please be seated. I'll have the jury brought out then. Record to reflect we are all back in this courtroom.
Before the jury's brought out, can we address subject matter jurisdiction, Your Honor? Before the jury's brought out?
Absolutely not.
Is that a tacit agreement that you don't have to
Good
answer
for
those
him,
questions as a
Michelle.
public
Good
servant,
for
Your Honor?
him.
So are you going to act in dishonor?
Mr. Brooks,
Are you going to act in
I've already
dishonor?
addressed your requests.
It hasn't been proven for the record, Your Honor.
The jury is on its way,
They're not out yet, though.
but they're on the
You
way.
held me in
I'm
contempt.
not
You held me in
addressing these
contempt
matters,
before.
sir.
Have I acted in dishonor, Your Honor? You held me in contempt without me being in dishonor. How have I dishonored the court? Have I acted in dishonor? Have I rose my voice or argued with Your Honor?
So fash.
Have I disrupted the
Mr.
courtroom
Brooks,
in
you're
any
back
way?
in this courtroom at your request. The jury is coming.
I never should have
Please
been.
be respectful of their time.
I
and this
have
process
been. They weren't even
and the
out
dignity
before.
of the proceedings.
They weren't even out before when I was trying to address what needed to be.
The dog mom talks a lot about how, you know, the judge gets on her nerves because of the way that she, you know, lets him rule the roost, so to speak. And I get it. I feel that. But it's this here that gets on my nerves more than anything. Is I feel like it's wasting so much time doing the whole back and forth and back and forth and back and forth. Like, I think there should have been a rule set in place for once you're over there for the day, you're over there at least until break time or lunchtime. Like, you're there until the first morning break, or you're there till after lunch, or you're there till the last break. And that's it. The back and forth and back and forth. I think that is what was ridiculous.
Be addressed
Brooks.
before they came out.
Because he's wanting this. He's wanting. See, he wants over there, and then when he gets over there, then he argues that he's there. I should have never been brought over there in the first place. And then he gets over there, and he's like, I never should have been brought over here in the first place. And then he's back over here, and that's the part that drives me crazy.
Dishonor. So that's a tacit
All
agreement
right,
that you
for the
don't.
jury, please.
It's a tacit agreement that you don't have to answer questions as a public servant,
All
right?
right, the jury.
No
is
jury's
not
out.
Mr. Brooks,
No jury's
close the
out.
door.
I was trying to
Mr.
address
Brooks,
this before they
right
came
outside
out.
this door. I am not going to do this with you this morning. You either
I'm not
abide by
doing-
these rules
Am I
and
acting in
stay
dishonor?
quiet,
Am
or
I
you will
acting
be
in
in the other
dishonor?
courtroom.
Am I acting in dishonor?
Yes, you are acting
How?
in dishonor.
How?
You are disobeying the direct order of this court to respect the decorum and the dignity of these proceedings. You are merely attempting to delay.
I don't care what you think. That's not accurate.
Mr. Brooks, I am having this jury out.
And-
And if you
and you're
say
making-
one word when that door
You're
opens,
making a tacit
then
agreement.
you will forfeit your right to be present.
So you're acting in dishonor, then, Your Honor.
All right, the jury may come in.
You're acting in dishonor by making a tacit agreement that you don't have to answer any questions as a public servant. You're not holding up to your oath to protect the
All right, the
Constitution.
door's open and he's talking.
Okay, so you
Oops, she gonna take her flip-flop off. She gonna take off her flip-flop. You better run, boy.
gonna hold me in
All right,
contempt?
the jury cannot come in. Never mind.
Are you gonna hold
All
me in
right,
contempt?
Mr. Brooks is going to be removed. We're in recess until that.
How
can
am
be
I acting in dishonor?
She took her flip-flop off, and she went whack. Whacked him right in the head. Whack. Both her flip-flops, right? She's like, you're going to make me take my flip-flop off. You run over my heel with that shopping cart one more time, and it is on. God, my mom hated that more than anything. When you would run over her heel in the grocery store with the shopping cart. Oh, she would get so mad. That's what it reminds me of. Chancla time.
Need for the court to advise all situations. We think
Oh, God. Hold on.
as well.
All right. Chancla. Chancleta. Is it chancla or chancleta? I don't know. I've had 15 people try to tell me how to pronounce that right, and I never can get it right.
Thank you, everyone. Please be seated. We are back on. The record appearances are as they were before. The record to reflect that Mr. Brooks is now in the other courtroom. I currently have
He
him
is
muted so that I
panicking,
can
Kel.
add to the record.
It's getting down to the wire.
I have confirmed he can hear and see as well. I would note he does have the headphones on while
Chancla.
in that courtroom. He just lifted them up as well, or at least part of them. This court has previously relied upon
many chanclas
the
are
U.S. Supreme Court case of Illinois versus
chancletas.
Allen,
I
wherein
don't know how to say
the United States Supreme
I
Court
try to act
indicated
like
it is
it.
essential to the proper administration of criminal justice, that dignity, order, and decorum be the hallmarks of all court proceedings in our country. The flagrant disregard in the courtroom of elementary standards of proper conduct should not and cannot be tolerated. We believe trial judges confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. We think there are at least 3 constitutionally permissible ways for a trial judge to handle such a defendant, including 1, bind and gag him, thereby keeping him present; 2, cite him for contempt; or 3, take him out of the courtroom until he promises to conduct himself properly.
Or
I understand
4,
Mr. Brooks is
take
waiting
your
for the court.
flip-flop
We'll
off and
address that
hit him with
momentarily.
it.
But the bottom line is there is a history of repeated disruptive behavior by Mr. Brooks. I warned him after he came back in. The first thing he wanted to do was address subject matter jurisdiction. That is, from my perspective, simply a tactic on his part to delay these proceedings, to disrupt these proceedings. I've issued a written decision. He has yet to appeal that written decision. He has that right to file an interlocutory appeal. I would also note, at no time during this case has jurisdiction ever been challenged when he was represented by an attorney. So I warned him. Given the importance of the proceedings and the need for the court to advise this jury without interruption, he was removed once again. I will not bring him back into this courtroom unless he is willing and pledges to conform his conduct and pledge to not interrupt by making any statements when this jury is present and during the court reading all of the jury instructions.
He don't even know what
I will
the
unmute
word
him so that he
pledge
can
means.
indicate what he would like to say to the court. You are unmuted, sir. Go ahead.
Oh God, I would love to know.
Can y'all
Kel.
hear me?
We can.
First of all, at 9:25, I would like the record to reflect that the prosecution was making dispiriting remarks and gestures in pursuant to what just happened. I don't appreciate it, and I think that is very disrespectful.
Oh, wow.
For the record. And again, I'm trying to figure out, how did I act in dishonor to be removed from the courtroom? How have I acted in dishonor? This is a whole nother. How have I acted in dishonor?
All right, I'm going to mute Mr. Brooks. I'm not going to answer that question. I've made my ruling as far as anything that was done by the prosecution. I was not in the courtroom. The jury was not present. Whatever happened, if anything at all, was done outside the presence of the jury. If there is anything the state wants to put on the record right now, I'll give you that opportunity. Otherwise, I am
sure
going
they
to bring the
figured
jury
it
out,
out.
Mr. Brooks. If you want to
I mean, I'm sure that multiple times a day when they would go back to the jury room, they're probably all like rolling their eyes like, oh my God, this guy is, you know.
come back into this courtroom, you need to write your request down on a piece of paper, and when you do that, pledge to this court that you will not interrupt these proceedings. Without that, I will not bring you back into this courtroom. Anything the state wants to put on the record?
I have a question, Your Honor. I don't have anything directly in response to Mr. Brooks' last statement.
All right, go ahead.
Yesterday afternoon, when we had the 4-screen up, there was a wider view of the courtroom so that the jury box could be seen. Is that possible to do again?
Yes, it is. We can take the witness stand camera and pull it out so that he has a view of the jury box as well. I can't angle it, but I can do that.
And for the record, when you do that, then he can see the jury box. So I would ask that that be done before we.
Please do that, Madam Clerk.
I can't court TV stand too, and I thought we weren't supposed to show the jury. That's why I leaned it back in.
Well,
Unless they turn it
it's not on Zoom, and so the court TV would be able to fix the camera on me and not on the screen, so that they don't capture any of the jurors, and they're directed to honor that and do that. Same thing, obviously, with our still photographer. If there are any images captured of Mr. Brooks, and you can see the cameras being zoomed out, you would need to avoid capturing members of the jury.
Thank you, Your Honor. The record should reflect you have zoomed out the camera, and it looks
Right.
like about 90% of the jury box can now be seen in the view if Mr. Brooks chooses to do
Right.
that.
Mr. Brooks, I'll unmute. What is it you would like the court to address?
How can you rule that I don't have the right to be present in the courtroom?
All right. I've answered that previously. I've made my findings under Illinois versus Allen. He continues to interrupt, even if it is by asking questions. I've made my ruling. The record stands. It speaks for itself. And I intend to have the jury brought out. I need one moment before I do that. And so I'm going to just take about a 2-minute recess.
God. Recess, schmeesus. Lord, Lord, Lord. I might take a brief intermission because I need to take a comfort break myself. Come on, let's get there. Let's get there. There we go.
Mr. Brooks sent a note that says, we are back on the record. Appearances are as they were before at 9:45. Mr. Brooks sent a note that says, under Illinois v. Allen, I request for the second to be present at my trial. I never consented to not being present, nor did I act in dishonor, because he has not made a pledge to conform his conduct as is required under Illinois versus Allen. He has not reclaimed his right to be present, and we will continue with him in the other room. I will also make a finding today, and I didn't do this previously, although he's forfeited his right to be present, given the technology, the audio and visual equipment that we have, the fact that we've also backed out the one camera so he can see the jurors. I'll make a finding, even without that, though, that it's the functional equivalent of being present in this courtroom. All right, with that, then the jury will be brought out. I'll remind Mr. Brooks, while he can reclaim the right to come back into the courtroom and make a request, I am going to be adamant that his request include a statement that he's willing to conduct himself consistently with the decorum and respect inherent in the concept of courts and judicial proceedings, and specifically pledge to not interrupt the reading of the jury instructions until such time he will remain in that courtroom. All right, go ahead.
Good for you, Judge. Good for you. Yeah. Hey, Skylab, thank you for the super chat. Thank you for that. Or the super sticker. I appreciate it. Thank you very much. Thank you, thank you. Here, let me give you a little sparkle. You ready for your sparkle? A little sparkle man. Here we go. And then I'm also going to give you this. Just because it's fun. Just because it's fun. I just love her so much. I look forward to watching your channel grow. Well, thank you. I appreciate that. That means a lot to me. It's grown quite a bit, though, since the weekend. Man, it really has. Thanks to Miss Tanika. She's something else. Let's see. Jill, I'm in the Midwest. Kelly says, taking down my Christmas decorations. I collect skinny Santas. Really? Years and years and years ago, my mom and a friend of ours, like a friend of the family's, collected the little, like, pencil tall, well, not tall, but like the little tchotchkes, like the little, like, skinny pencil Santas. Super cute. Super cute. I love that. Yeah, I know. Only to disrupt. That's it. Speaking out of turn. Your tree is on the neighbor's lawn? Can't bring myself to reclaim it. How did it get to your neighbor's on your neighbor's lawn? Apparently that rose petal murder trial is going to be delayed. I think I read earlier something about February, but that was early today. I don't know if they've made changes or something. I think I read that they couldn't seat a jury.
Okay.
All rise. All rise for the jury.
Okay.
Always base your verdict on the law I give you in these
Now,
instructions.
This is the part where she begins her reading of the instructions, which we're going to skip through. I just don't know if...
As to each count, the defendant act is committed. The act need not be brooded over.
I'm going to sort of slowly slide through here, see if I can find any spots where there's like an argument or anything. Like right here, he just raised his hand.
Disregard for
I don't
human
know
life.
what for.
On or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha. The 42nd November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, was
Just take here because literally she's been reading
out.
forever.
I'm going to take a quick stand break. Please stand, everyone. First degree recklessly endangering safety, as defined in section 941.30 sub 1 of the Criminal Code of Wisconsin, is committed by one who recklessly endangers the safety of another human being under circumstances that show utter disregard. Are satisfied beyond a reason, you should be satisfied, you must find the defendant not guilty as to count 40. If you find the defendant guilty of count...
Let's take a short break here.
All right, we are back on the record. The jury has not been brought out just yet. I indicated I would address a note that was passed by Mr. Brooks to the court. In it, he indicates the following: I have reclaimed my rights, parenthesis, that I never gave up or consented to give up, parenthesis, to be present, and you have not honored your oath of office to protect my constitutional rights, specifically my 14th Amendment, Section 1, which references equal protection of the laws. Would you like to explain this on the record, or should I? I will if you won't. I would like to make an offer of proof for my appeal on the record. I indicated previously that should Mr. Brooks want to come back into this courtroom pursuant to Illinois versus Allen, he could certainly reclaim the right to be present, but he would need to be willing to conduct himself consistently with the decorum and respect inherent in the concept of court and judicial proceedings. I specifically advised that he would need to pledge to not interrupt the proceedings. He has not done that.
Yeah, I love that.
Meaning he has not
We watched that.
indicated he wants to come back, or
That was
that
really
he
good,
will
Northwest.
pledge to be courteous and follow the...
Yeah, and he's like, I bet what was he said? I bet you know she didn't tell me she was 18. You know that? Did you know that?
rules of decorum, and
Know
specifically pledge to not interrupt as I read through the jury instructions. And his letters or notes that he passed will of course be made part of the record, but I'm going to deny his request to make a further record for appeal, as I need to continue advising the jury of the jury instructions. So with that, Mr. Brooks will remain where he is at. Anything further he wants to address, he will need to do that in writing.
Good for
as
her.
he has done with a note, but I don't feel the need to give him any additional opportunity to explain that. What I will ask is he going to make a request to come back into this courtroom? And if that is true, he can give me a thumbs up sign, and then I will address that. All right, I will unmute him. Mr. Brooks, what is your request as it relates to coming back into this courtroom?
I've requested to come back into the courtroom with the first writings that you said I had to write.
I put that on the record already, sir. You did not pledge to respect the rules of courtesy and decorum and pledge to not interrupt the court. Are you willing to pledge that at this time?
Your Honor, with all due respect, I've never had to do that before to reclaim my right. I've always asked, when you've given me the opportunity, when I felt that the time was right, I've always asked to come back, have I not?
Mr. Brooks, given your conduct this morning and your blatant violation of my direct order to you to not interrupt when the jury was being brought out, I felt it important to strictly enforce the language of Illinois versus Allen, and only bring you back if you are willing to conduct yourself consistently with the decorum and respect inherent in the concept of courts and judicial proceedings, and specifically pledge to not interrupt as I go through all of these jury instructions. If you're willing to do that, I will bring you back in.
Your Honor, with all due respect, can we at least be fair and say today hasn't been as volatile as other days, or as the back and forth between you and I hasn't been what it has been previously?
Mr. Brooks, we started the advisement to the jury an hour later than I anticipated, so I would thoroughly disagree with you that it might not have been volatile or loud, but it was nonetheless disruptive. So I will ask you these questions, sir. If you come back into this courtroom, are you willing to honor my request and order to you that you not interrupt as I read through the jury instructions?
Your Honor, I don't understand the question that you're asking.
Sir, are you willing to refrain from raising the issue of subject matter jurisdiction if you come back into this courtroom?
Your Honor, with all due respect to your ruling on Illinois versus Allen, that was not part of Illinois versus Allen. I don't understand why that's being
Mr. Brooks, I'm not going to debate the meaning of Illinois versus Illinois v. Allen with you. I'm simply trying to get you back into this courtroom. You seem to want to be here, but you don't want to pledge to follow the rules of courtesy and decorum. So that's on you.
Your Honor, this has never been done before. It's never been done before, and I've always been able to reclaim my right to be able to be present.
Are you willing?
Which is what I stated when I first came over here. I've been stating the same thing. I've actually told the bailiff numerous times.
Mr. Brooks, I am strictly enforcing the language of Illinois versus Allen, which says the following. I will repeat myself again. Once lost, the right to be present can, of course, be reclaimed as soon as the defendant is willing to conduct himself consistently with the decorum and respect inherent in the concept of courts and judicial proceedings. I have not required the pledge previously. I've allowed you to come back, but given the interruptions this morning and your immediate discussion of things like subject matter jurisdiction and my oath the minute one juror walked through that door, I cannot take that. I will not bring you back in without that pledge.
So where does it say anything about a pledge, Your Honor?
Sir, I'm not going to debate the language with you. I am establishing what I believe is a reasonable restriction on your right to come back into this courtroom based upon the history in this case of your repeated violations of the simple rules of courtesy and decorum and your failure to follow my very clear and direct requirement this morning that you not interrupt the reading of the jury instructions and you be silent once the jury entered the courtroom. I did that in part because it not only preserves the dignity and decorum of this trial, it also frankly protects your rights and it minimizes your bad behavior in front of the jury.
Your Honor, now, I didn't interrupt you while you were talking. I let you make your record without talking over you or interrupting you.
Thank you. I would agree with you just now.
The way that I'm interpreting, when you reference to me, with the Illinois versus Allen, where your ruling is coming from, the way that I interpret that is not the way that you're saying it to me now. That's why I don't understand what you're asking. I'm interpreting that in a totally different way.
I'd refer you to the third section of Illinois versus Allen, where the U.S. Supreme Court was discussing what the trial court did in that case. And it said the following: the trial court in this case decided under the circumstances to remove the defendant from the courtroom and to continue his trial in his absence until and unless he promised to conduct himself in a manner befitting an American courtroom. As we have said earlier, we find nothing unconstitutional about this procedure. So that is the authority, sir, in addition to the other quotation. I'll tell you this. I'll give you one more opportunity, sir. You can come back into this courtroom, but I do not want you to address or attempt to address subject matter jurisdiction or any of the other rulings that I've previously made. I need to continue with the advisement to this jury about the rules that govern their deliberations. That is the stage we are at. And if you violate that in any way, by raising any of those legal issues in their presence, that will be in direct violation of the requirement for you to reclaim your right, and you will be removed back to the other courtroom. Did you hear me say that, sir?
I'm informed, but Your Honor, now you just stated on the record if I raise these issues in their presence, but if they're not in the courtroom, it's not in their presence, correct?
Sir, I can't bring them into the courtroom until you're here. I expect you during that short interval not to raise these legal issues that I've already addressed multiple times. So yes, I'm telling you, if you come back into this courtroom, I don't even want to have you raise any of those issues. I want to bring the jury right out without interruption. That is my clear expectation, whether the jury's in the courtroom or not.
Your Honor, I'm confused because you just said don't raise any issues in their presence, and now I'm confused.
Because you're indicating to me by your statement that you intend to raise them once you get back into this courtroom. And so I'm making that another restriction, and you need to pledge to me that you will not do that.
Your Honor, the way that I'm interpreting what you just read to me from the other section that you just read from Illinois v. Allen, it does not have that language. So I'm
Mr. Brooks, I'm not going to debate the language. Do you want to come back in here or not?
I've stated numerous times that I shouldn't even have been brought over here anyway, and that I wanted to come back. But now what I don't understand about it, Your Honor, is that there's being rules enforced.
Mr. Brooks, do you want to come back in here or not? It's a very simple question.
I said yes already.
All right, then I'm going,
to say the same thing?
because then you go on and make other statements, and then I can't even effectuate your request.
But I'm trying to tell you how I'm interpreting what you're saying to me. If you want
Mr. Brooks, I'm going to mute you. We're going to go in recess. He can be brought back over, but I will advise you that if you start back in, even outside the presence of this jury, with any of the legal issues I've already ruled on, you will go back to the other courtroom. It's that simple. So we'll be in recess. He'll be brought back over, and then we'll start back up.
My God.
Here, he's courtroom as they were before. The record should reflect that Mr. Brooks remains in the other courtroom, despite what I thought was he made clear he wanted to be here. My understanding is he is now saying he doesn't understand what this court wants. I've made it very clear. I believe what this court's expectation is that I continue with the jury instructions without interruption, that Mr. Brooks follow the rules of courtesy and decorum.
This is ridiculous.
He's had those for quite some time, and that he conduct himself consistently with the dignity and decorum that these proceedings deserve, and that includes not interrupting or bringing up legal matters that this court has previously ruled on.
More than
have
enough.
lost a significant amount of time now addressing, or not even addressing, but Mr. Brooks really interrupting the flow and the proceedings based upon his responses, and then he attempts to engage with this court on the meaning, for example, of Illinois versus Allen. He needs to make a very clear statement to this court, not an ambiguous one, but a very clear one, that he wants to come back into this courtroom and that he's willing to conduct himself appropriately. And until he does that, he will continue to forfeit his right to be present. If you are not so satisfied, you must find the defendant not guilty as to count 47. If you find the defendant guilty of count 47, of first degree recklessly endangering safety by using a dangerous weapon. If you are satisfied beyond a reasonable doubt that all three elements of first degree accident involved, you are not 73. Charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, having been charged with a felony and having been released from custody, and certainly within those he did not pledge to follow the and then that at this then the opinion based on those facts should not be given any weight. At this time, I will reserve the instruction on closing arguments because we are going to take our lunch break and then come back after the lunch hour for closing arguments. All rise for the jury. All right, thank you. Be seated. As soon as the doors close, I just need to put a couple things on the record. As I read, the doors closed, right? There we go. As I read through the bail jumping, it dawned on me that the battery should not be referenced because the battery was not on Main Street. And so I took it out. because the way that the charge and the information reads, and we had that discussion preliminarily, which is why later on it doesn't reference the instruction for battery. So I cleaned that up by rereading it and taking that out. So I wanted to make a record of that. Obviously, I will need to have a new set made that has that correction. And I apologize for not catching that previously. But obviously I caught that as I read it. There was one other heading that said preliminary on, I think it was instruction 70. I need to cross that out. And I think I found the word a or depending on how you say it, missing from one thing. I'm going to add that in, and I'll have that for the parties. And then I did note that at approximately 12:19, it may have been a little bit earlier than that, but I noticed Mr. Brooks was waving his hands. At one point, I did indicate I would address that at a later point in time. I am aware of a number of filings. I addressed 2 of them previously, but there are 2 additional. I am going to have copies made of all of these filings for the state so that they have an opportunity to review them. From my perspective, just briefly, he's making some objections to what I am doing, but at no time in those did he ask to be brought back to the courtroom, and certainly within those he did not pledge to follow the basic tenets of courtesy and decorum. Given where I was at in the proceedings with the reading of the preliminary instructions, and given the court's prior finding that he had forfeited his right to be present, I thought it important to get through the reading of the instructions up until the point of the closing argument instruction, which I reserve because I'll review that with the jury when they come back prior to the parties being given their opportunity to give closing arguments. I will also be advising Mr. Brooks that given that I'm moving on to a second part of this, that being the closing arguments, he will be invited back into the courtroom here for those closing arguments, of course, subject to his conduct. I expect that he will follow the rules of courtesy and decorum and also not raise legal issues in front of the jury when they are here. With that, we will take our lunch recess. It's 12:47. We'll take an hour and 15 minutes. Thank you, everyone.
Okay, so let's get through this. Their lunch break. He's back in. Once I get started with the prosecution's closing arguments, I'm going to run and take a brief comfort break. Zoom, zoom. Zoom, zoom. Zoom, 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 and boom, boom. Okay. You sleeping, praying? What are you doing there, buddy? All right.
It's from yesterday, too. You got to scan that in, too. Okay. And, do you have the sheets for me? From the yellows? The yellow. His yellow sheets. Yes.
Right, Cherie? Yeah. Rosebud said, and this is now when Opper puts him to shame. Yes.
There's one on your, how about on your? Yeah.
I'm excited to hear this closing again. I'm excited to hear this again, to be honest. Oh, yay, Dog Mom. Look at that. It's been a great month. Love you all. Yay. I love that. The memberstone. The membership milestone chats, I think, are the coolest. The coolest thing ever. It's been great having you with us for a whole month. Has it been a month? Wow. Thank you. Thank you, thank you, thank you. Here, I'm going to give you a little sparkle. I love it. Love it, love it. Thank you so much, Dog Mom. We love having you here.
All right, it's 2 o'clock. I'll call the case. State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. May I have the appearances, please?
BR 549.
Judge Sue Author, Leslie Daisy, and Zach Witch, appearing for the state.
I'm here without prejudice by special appearance. Beneficiary, I'm here under fraud, menace, duress, and extortion. Judiciary, Jennifer R. Darrell. This is a social security, SESTQ, trust action which you are a real party and interest to. As sui juris and propria persona, this is a military admiralty tribunal and maritime law. Title 4 of the United States Code, Section 1, which you can see, which states placing a fringe on the national flag is within discretion of president acting as commander-in-chief of the Army and Navy. Is this a common law court or an admiralty court?
The records reflect that the individual known to this court as Darrell Brooks is present in person in custody. He is wearing a dress shirt. I know he has a suit coat, but it's not on. He's also wearing a mask. The court is not going to address any of the issues that he is raising, as they are meritless. I would also say the same as to the notes that he passed while he was in the other courtroom. For the record, I did provide a copy of all of those to the state as well. They are also uploaded into the file and are made part of the record. To the extent that he raises objections or lack of consent, it is noted for the record.
I was about to do that and say that I don't consent to being called that name or identity. That is the trust name, and it is not me myself. I don't recognize that name, nor do I consent to being called by that name. With all respect, Your Honor. And we still have yet to address subject matter jurisdiction, which has yet to be proven on the record. May I receive those original copies time-stamped?
Okay. All right, I need to make a record of one part of a jury instruction that I do need to advise the jury. It will also be corrected in the packet. I believe within the last year, the jury instruction on credibility of witnesses was modified by the jury instruction committee, and it was just an oversight on the court's part to not include, it's really just one paragraph. It was read to the jury at the beginning of the case with the preliminary instructions, but it is a paragraph regarding implicit bias, and so I do think it's important to advise the jury of that. I intend to do that when they come out, and then again, the full instruction will be amended so that it's in the packet that goes to the jury. And Madam Clerk, if you haven't already, if you could print off page 72. It's the, it adds a paragraph before the last paragraph that starts with, "There is no magic way for you to evaluate the testimony." And again, I wanted to be consistent with the most recent version of the jury instructions and consistent with what was instructed or provided to the jurors at the beginning of the case. And so I will make sure that they have that and so advise them when they come out. Also, I will read instruction 160, closing arguments. Madam Clerk, if you could just make the change so that it's of parties. We've missed that correction as well. So it's the closing arguments of the parties, not the attorneys. And so I will just make that correction and make sure it's...
I accept for value and return for value this document. And Your Honor, I requested that I have copies of my filings from earlier, time-stamped.
Mr. Brooks, I'll provide you with the copies later on. I need to continue with the instructing of the jury and have the parties make their closing arguments.
Your Honor, with all respect, the state received copies. How come I can't receive the copies of my filings?
Ah, okay, that makes sense, Dog Mom.
I can give you
that makes sense.
Print-offs, but I can't give you the originals right now. That's what I'm referring to, and you will absolutely get those back. I guess I was mistaken.
And thank you for renewing it. I appreciate that.
Mistaken that you wrote copy on it. I thought you retained a copy for your records. So with that, Madam Clerk will print off from the record. It won't be the yellow copies just yet. I'll take that up later outside the presence of the jury after the case has been given to them. Now, in terms of the closing arguments, I did set a time limit for the parties yesterday. Each side will have a total of 1 hour. Mr. Brooks, so that you are fully aware, the party with the burden of proof, which is the state of Wisconsin, goes first. Then you, as the opposing party, will have an opportunity to respond and argue. And then, time limit willing, the state also has the opportunity to present rebuttal because they have the burden of proof. And that is provided with the excerpt from the bench book that was provided to you yesterday. It has the purpose of the closing arguments is to summarize the facts, marshal arguments, focus the issues for the jury. I just talked about the order of the arguments. The scope of the arguments, or the content, duration, and form of argument are within the court's discretion. That's why I set a time limit of 1 hour for the parties. And Mr. Brooks, I will advise you that I certainly will wait and see how you present your argument today. I will certainly wait to see if there are any objections raised, but I also want you to be aware that if I feel the arguments are improper, I may simply, without an objection, say, please move on, as a clear indication from this court that what you are stating is not proper under the various rules and case law that govern closing arguments.
Again, Your Honor, without prejudice, I'm here by special appearance. I don't consent to being called that name for the record.
It's noted, sir. All right, then with that, I will have the jury. Oh, go ahead. Looks like Attorney Opper has some issues she wants to raise.
Yes, I just have one question, Your Honor. Would I have permission to put the easel up?
Here by special appearance. That cracks me up. Like, what does he think, that it's the Tonight Show with Johnny Carson? Or Jimmy Fallon? Or Conan O'Brien? I loved Conan O'Brien. I miss his show.
Up and display some of the poster boards. I did confer with Captain Dussault as far as security is concerned, and he agreed to it if the court would give me that authority.
Where would it be displayed?
He's going to put it like right here, and then you want me standing at this table during
I do.
Yes, so I would just position it like right here. And I don't have to leave it up through the whole thing. I realize it blocks the view of people in the courtroom. Detective Casey would be willing to assist me in removing them when I'm done with them, if that's okay with you.
I trust it won't block Mr. Brooks' view of the jury, and
That's
as long
right.
as,
Yeah, I was going to put it like right about here so that he could still see me and the jury.
with that caveat, yes, I will allow that.
All right.
Objection, what is that? What is supposed to be put up?
They were previously admitted, Your Honor. It's Exhibit 15 and 130, I believe.
So are they exhibits? I'm confused to what they are.
Mr. Brooks, I made
Dale and I loved watching him, Patricia. We loved Conan O'Brien. Like, loved him. Special appearance. So in his mind, he is not appearing before the court and agreeing to jurisdiction. Yeah. Yeah, they don't work for me either. I mean, I love Jimmy Fallon, though. Love Jimmy Fallon. I just love him. He's so funny. But I do miss Conan O'Brien. Miss him. Do y'all remember whenever, oh, hold on a minute. Shoot. Don't y'all kill me. What was her name? The blonde that would come on and do the, like, for Johnny Carson every once in a while. Oh my God. And she clapped like this. What was her name? Oh my God. Joan Rivers. That's it. Joan Rivers. Yes. I used to love when she would, like, pop in and do his shows every once in a while. Yes, Joan Rivers. And she would always clap like that. Killed me. Cracked me up. I love Joan Rivers. Okay. All right. I'm going to start this back, and I don't think I can wait for my comfort break anymore. I have to go take a comfort break. So I will miss her. Yeah. Dog Mom says not a fan of Kimmel or Fallon. I just love Jimmy Fallon. I think he's hilarious. I'm not a big fan of Jimmy Kimmel, though.
Made a ruling, the state has made a request, I've granted it.
Yeah, but
In
I'm
terms
saying,
of-
I don't understand what's being shown. Should not have the right to ask, to object and ask what it is that's actually gonna be shown?
The state's put on the record what it is. They are exhibits that have previously been received by the court during the course of this trial. That is proper for a party to do that during its closing arguments.
So can I put up exhibits?
Mr. Brooks, I don't know what you have planned for your closing argument, so.
I'm making a request, the same request. May I be able to put up,
Well, I guess it
exhibits?
depends on what it is, sir. So I'm not gonna take up any more time, because what I intend to do is, once the state goes through its closing, I may take just a short comfort break, depending on how long it is. And if there's something in particular, you will need to tell me what it is. As long as it's an exhibit from this case, then I wouldn't have an issue with it.
They would be from this case, obviously. It's just not nothing that the state has.
I'm not aware of exhibits that the state wouldn't have, that you would have. Everything that's been received, we have a list. So if it's not something that was received during this trial as an exhibit by the court, unless you tell me what it is so that I can make a ruling, I can't see how it would be relevant or appropriate for your closing argument.
They're part of my filings that you filed.
The filings have no relevance to the issues that are before the jury. The closing arguments are to direct the jury so that they have your arguments, so that when they go back to determine the issues in this case, which are related to whether you're guilty or not guilty of the 76 charges, things like subject matter jurisdiction or like that would not be something that would be proper before this jury. Those are legal issues that the court would decide. The jury is the judge of the facts. The court is the judge of the law. That's why I have all of these jury instructions to give to the jury.
I'm not referring to subject matter jurisdiction.
What are you referring to then? Be very specific so I can make a finding and ruling.
I was specific, my other filings that
That's
was
not
filed.
specific enough, sir. What are you
My
referring
court
to?
docket
Which
sheet,
filing?
let me know when you're done, Your Honor.
Which filing, sir? Not generally, but specifically.
Are you done? Are you done?
Sir, that's very rude and
No,
disrespectful.
I didn't know if you was finna say something.
I
That's why I'm
paused.
asking, are you done?
What filing
Your Honor,
are
how
you
come
referring
every
to?
time I try, even when I try to err on the side of caution, you find some way to make it to be something that it's not? I didn't know if you was gonna say something else.
I've asked a question, sir, so when I do that, I would hope it would convey to you I'm looking for an answer. So which filing are you referring to?
All my
Specifics.
filings, my notice of appearance, my statement of particulars, my bond, the court docket sheet, all of those filings.
The request to display those to the jury is denied. It's not relevant.
How is it not relevant? Not even your
That's my
oath of office?
determination, sir, so I am going to start this.
Not even your oath of office can be shown?
No, that is not relevant to these proceedings, sir.
It is.
It's not relevant in front of the jury.
Why is it not relevant? Can you
Mr. Brooks,
Can you
you are
explain why
not
that's not
going to be
relevant?
able to raise those types of issues and present a closing argument based upon my oath of office, whether I'm licensed to practice law in the state of Wisconsin.
I said your oath
whether
of
there's
office. I didn't
subject
say
matter
anything.
jurisdiction, whether you consent to this appearance or not. None of those things help the jury determine the issues in this case, which are related to whether you are guilty or not guilty of the 76 charges that have
The
been
jury
filed
should
in
know
this
that
case.
they should know the truth in their duties, in their rights. They should know that at least.
Mr. Brooks, I'm putting you on notice that if you continue with this insistence upon presenting information that's not properly before the jury as evidence in this case, that I will instruct you during your closing argument to move on and potentially ask the jury, have the jury leave so that I can admonish you. And if you keep insisting on that, sir, that will be in direct violation of the court's direction to
So
you.
they can't even know that I got a shock device on my ankles?
They absolutely do not need to know that.
Why
So it's
not?
not relevant to the determinations of guilt or innocence in this
It's the
case.
truth.
Mr. Brooks, your custodial status is not on trial here.
I would argue that it
Your
is.
conduct from November 21st of 2021 is
That
what's
hasn't
on
been
trial.
proven.
You may not bring up the way that you've been shackled. It's not relevant, sir.
It's
And if
the
you
truth.
do so, you do it at your peril, but here's the
There
thing,
is
the
no
jury
peril.
is specific.
It's my right,
No,
though.
let me go. Okay,
It's my constitutional
is-
right. Just like
There are
under the
certain
First
things
Amendment,
that
which
you're-
I preserved my First Amendment right when I came in this morning, I also preserved my
Right.
Sixth
Mr. Brooks,
Amendment right.
Please stop. You do not have an unfettered First Amendment right. That is very clear based upon
What do you
all
mean
the
by
case law.
unfettered? What do you mean by unfettered?
It
I
means
don't.
it is not absolute. It can be restricted.
So the Constitution of the United States can be constricted.
All right, Mr. Brooks, I'm putting you on notice that if you continue with your insistence on raising issues that are
I'm going to
clearly a
raise issues that the
distraction,
jury needs
that
to
are-
know,
They're not
regardless,
issues.
because they're under the rights of the United States Constitution, which
Mr.
is the
Brooks,
law
I
of the
direct your
land.
attention to closing instruction 460.
I'm
which will be
going
read
to let the
at some
jury
point.
know the truth, their duty and their rights. Under the First Amendment and under the Sixth Amendment, I have the right to inform them of their rights, of the truth, and of their duties. Under the First Amendment and under the Sixth Amendment of the Constitution of these United States. You can't, no state law can override that.
Mr.
Any
Brooks,
law,
do you intend
any
to
law
keep this up when the
repugnant.
jury comes out?
Your Honor,
Because I need to
no, I
have
do
the
not. That's
state-
why I'm addressing this before
not-
they come out. That's why I'm trying to address this before they come out, so it doesn't become an issue once they're in here. But under the First Amendment and under the Sixth Amendment of the Constitution, which are rights that I preserved the moment we stepped in here this morning when this proceedings started, I preserved those rights for the record. And now you're telling me that those rights are not, would you say unfettered or I don't know what you say. I don't even know what that means. I don't even understand that. But any law repugnant of the United States Constitution is null and void.
Mr. Brooks, I'm putting you on notice that you can also forfeit by your conduct the right to present a closing argument. In appropriate circumstances, the right to present a closing argument, no different than the right to testify, may be subject to forfeiture where your conduct is incompatible with the assertion of the right at issue. The goals that this court has attempted to follow throughout this proceeding are multifaceted and multifold. Number one, I do have an obligation and have done my best to ensure that this is a fair trial. However, a fair trial does not mean a defendant has unfettered rights to state whatever he wants, when he wants. This court, not only through the course of the trial, is deemed with the responsibility to control the presentation of evidence so as to ensure fairness and reliability of the criminal trial process. It also includes ensuring that the closing arguments are relevant, are appropriate. This court must also be concerned with efficiency and effectiveness, and of course, last but not least, courtesy and decorum in this courtroom, what I would generally refer to as civility in the courtroom. You do not have unfettered First Amendment rights or an unfettered Sixth Amendment right, sir. You must conform your conduct to the rules of decorum, the rules of evidence, and the rules of procedure. While you have a right to present relevant and probative arguments to this jury, you may not present arguments related to such things as jury nullification, subject matter jurisdiction, the court's oath or lack thereof, if that's what you believe, whether this court is a court of common law, admiralty, all of those things relate to your claim as being a sovereign, which are frankly baseless, they're meritless, they've been debunked by many courts, including the court in the Beneby decision that's been referenced by this court previously. I will give you a fair opportunity to present a closing argument, but again, it is not unfettered. The simple fact is, sir, this court can restrict your right to present a closing argument. This court has the authority under 906.11, under the various cases, including Illinois versus Allen, including Rock versus Arkansas, although Rock versus Arkansas and Chambers versus Mississippi dealt with the right to testify. There is a decision, I looked it up earlier, and I'll just pull it up and tell you the case site so that you have it. I would direct your attention to Herring versus New York, found at 422 U.S. 853, a 1975 case, although in a footnote, it does stand for the proposition that a defendant who has exercised the right to conduct his own defense has, of course, the same right to make a closing argument. That's quoting Ferretta versus California, or following the same logic from Rock and Anthony and Chambers, a right, even a constitutional right that a defendant has may be forfeited by conduct. This court, just like it attempted to do with regard to your right to testify and set up reasonable restrictions so as to meet all of the goals that the court needs to meet, will be as follows, and that is, again, sir, you may not bring up matters that are not relevant to the determination of guilt or innocence. That means evidence that was not presented and not received in this courtroom is not relevant to your closing arguments. It's not, the arguments must be based on the law, not as you interpret the law, but as the law is. You must base your closing arguments on the facts that have been established during this case, meaning the evidence, the testimony. As I indicated earlier, the purpose of a closing argument is to summarize the facts, marshal arguments, and focus the issues for the jury. It is fair that you comment on evidence, including arguing evidence to the conclusion or inference. It is your ability or your opportunity to convince the jury that you are not guilty of these offenses. You may not convey any idea that you have undisclosed information. Neither party may vouch for a witness or otherwise express personal belief or opinion regarding truth or falsity of any testimony or evidence. It would be improper to ask a jury to draw inferences that the parties know are not true. And your comments on evidence is limited to evidence in the case. You may not comment on facts outside the record or peculiarly within your own knowledge. And that is just some of the guidelines for determining the proprietary of arguments that I am guided by from my judicial bench book and all of the cases that are referenced therein. So you are put on notice, sir, that even without an objection, this court may, in an effort to preserve the dignity, the decorum, and to keep the issues properly before the jury, may advise you during your closing argument to move on. If you do not honor the court's rulings, then you will run the risk of forfeiting your right to be present and potentially forfeiting your right to further present your closing argument. With that, I am bringing this jury out to complete the instructions that I need to complete, to add to the credibility instruction, the paragraph on implicit bias, and to let them know the full instructions that they received will have it, to read 160 closing arguments of the parties, and then to have the state go first as they bear the burden of proof.
Now, Your Honor, I'll just let you make your record. I didn't overtalk you. I didn't interrupt you. Is that fair to say? I'll let you make the record. With all due respect, when will I be able to make the record? As I've tried to do numerous times by saying I wanted to present an offer of proof for my appeal. That's the chance for me to be able to make the record.
I'm denying your request to make an offer of proof regarding your appeal. It's
So,
not, I am
I'm
not
not allowed to
required
make the
to give you
record
that
at all, Your
opportunity,
Honor?
sir.
I'm not allowed
Sir.
to make the record at all? As I just let you did, because some of the
Sir,
issues
I
has
have,
been, some
you
of the
have
issues
told me
has
what
been,
you want to do. I
Your
told
Honor.
you you can't. I've addressed the
Your Honor,
request.
some of the issues have been me over talking you and interrupting you. I did not do that. Even though everything that you said, you have not proven for the record, and it's unlawful law. You haven't shown one time that that's lawful for you to do what you've been doing as
Mr.
far as
Brooks,
your rulings.
once again, I'm not going to debate with you the prior rulings of this court. There's absolutely no need at this point for you to
Your
make an
Honor.
offer of proof regarding my prior rulings or decisions that you disagree with.
Your Honor,
you
I'm
will have
going
an
to
opportunity,
inform,
if
I'm going to
convicted, to
inform the
raise
jury.
every issue.
Contempt. Hold me in contempt. I have constitutional rights that are being trampled on, and you're coming up with ways to make a lawful law where it doesn't say in Illinois versus Allen anywhere about utilizing the
Record
mute
to
button.
reflect that the jury bailiff is in here. However, the jury is still in the hallway. I'm going to give Mr. Brooks one more opportunity to be respectful of the court's rulings, whether
Your
he
Honor,
agrees with them
I
or
haven't
not.
dishonored the court. I'm merely exercising my rights under the Constitution, under the First Amendment, and under the Sixth Amendment.
Mr. Brooks, your rights do not include you disrupting these proceedings
I'm
the
not,
way
I'm
that
not
you have
disrupting
through
the
the course
proceedings. You
of
just
3
told me
weeks.
you don't have to honor my constitutional rights in so many words. You're using the mute button.
Mr.
That's
Brooks,
not
the
even in your
jury is
decision.
outside this door. They're not brought in
I'm
yet.
informed that the jury- I'm
asking
informed
you
that the jury
to
is
be
outside the
respectful
door.
of their time.
They're not in the courtroom.
I'm
They're not
asking you to
present.
be respectful of the court's ruling,
They're
whether
not
you agree
present.
with
These
it
are
or
issues
not.
that need to be resolved before they're
Mr.
present.
Brooks, they will not be resolved to your satisfaction.
It's not about my
The record
satisfaction. It's
has
about the
been made.
Constitution. It's about what's right.
Are you going to
Are you going to
follow the
answer
court's
questions as a public
ruling?
servant on why you're making up laws that are not in the Illinois versus Allen and never utilized
the
the
jury
mute button?
can go
Never
back
said
to the
anything
jury.
about a
Thank
mute
you.
button.
It is clear
Why
that
am I
Mr.
being
Brooks has
muted?
absolutely no intention of following the simple rules of decorum and courtesy. He has repeatedly talked over me. He's repeatedly interrupted. Even though I've made rulings, he's not respectful of the fact that I made a ruling, even though he disagrees with it.
How can you
I
make
attempted
it-
to bring the jury out,
How can you
and
utilize a mute
he
button?
continued to talk.
That's
So, Mr. Brooks, you
Your
have
Honor,
forfeited your right to
is
be
that-
present for the state's
is that
closing
not-
argument.
Your Honor,
You will
can
be
you answer
taken
this
to
question?
the courtroom next
As a
door, and I
public
will
servant,
invite you back over when it's time for your
you
closing
can't invite me
arguments.
back over. I can reclaim my right. So how can you invite me
All
to
right,
do
the courtroom
anything?
is to be cleared so that Mr. Brooks can be removed to the next courtroom, and I'll make appropriate findings when he's in the other
Yeah,
courtroom when I can
and
do
you'll
so
mute me, which you
without
can't lawfully do.
interruption.
You can't lawfully mute me.
So now you're trampling over my First Amendment right.
Okay, now we're gonna scroll. Sorry, I have a cheese sandwich and some pretzels. This is my pre-dinner dinner. This is my what do you call it? Hors d'oeuvre. I got hungry because I didn't have lunch. Rolling through.
We came, Mr. Brooks has been. So I need a quiet in the courtroom, please. We are back on the record. Appearances are as they were before, except that Mr. Brooks has been removed to the other courtroom. The court did that because we came out on the record at 2 o'clock following the lunch break. Mr. Brooks was brought to the main courtroom. And during that almost 35 minutes or so, he was insistent on raising a variety of legal issues with which this court has either previously addressed or which are meritless and do not warrant any further response. He is insistent on making a record and an offer of proof. This would not be the appropriate procedural mechanism, meaning an offer of proof at this time. We are not in the midst of a trial where the court's made an evidentiary ruling that would require the preservation of the record by making an offer of proof. This court has been attempting, frankly, all day to get through the reading of jury instructions, to get to the point where the parties make their closing arguments, and ultimately to put this case in the jury's hands. It has been challenging. It has been met by resistance from Mr. Brooks. I would once again describe it as being stubbornly defiant, although at times he may wait for me to make my ruling. He continues to not respect the fact that a ruling has been made, and he wants to argue and re-argue and re-argue points that this court has already gone over. And in an effort to simply put him on notice regarding his behavior, given the history of this case, the court was attempting to set some parameters regarding closing arguments so that they are focused, so that they are proper, and that they follow the law. That was met with a considerable amount of resistance and repeated statements by Mr. Brooks.
Oh, thank you, Sam, for the gifted membership. I appreciate that. It looks like Caroline. I don't know how to pronounce the last name. She got that membership. Yay! Congratulations, and thank you so much, Sam. That's very sweet. Here, let me throw a little sparkle. It'll break it up too. Break the up, right? There we go. Thank you so much. Sam says, in celebration, oh, wrong one. In celebration of your 1.25K subscription. Well done and good night. Thank you so much, Sam. That's very sweet. And thank you for coming and hanging out, letting us know that you're here. And I hope that you come back tomorrow. We'll be here again tomorrow. Right, Patricia? That was very nice. Thank you so much. Okay, let's get back to it.
Brooks, that he has First Amendment rights, Sixth Amendment rights, 14th Amendment rights. He has all of those rights. That is not in dispute. But those rights do not come in a vacuum when we're in a court proceeding, in a trial such as this. The rules of evidence, the rules of procedure, the rules of courtesy and decorum all apply. And this case has demonstrated that a stubbornly defiant defendant can forfeit even important constitutional rights by conduct. That includes the right to be present. It included the right to present further witnesses and testimony, and it included the right of the defendant to testify on his own behalf. I hope that I do not have to go through a decision that forfeits his right or that makes a finding that he's forfeited his right to make a closing argument. I will certainly wait and see how that goes. I would note he was very respectful when he did his opening statement. It was clear. He made a variety of points. He did so in a way that I would say was very conscientious of people's time. It was cogent. It was concise. It was probably about 35 minutes. I may be off a little bit, but that's what my memory is. It wasn't overly lengthy. I would hope that he follows some of those same things here when he does his closing argument. But he has been removed from this courtroom because of his stubborn defiance and disrespect of this court, of courtesy and decorum. And what I truly believe is an effort on his part to continue to delay and lengthen these proceedings. I've said it before, I'll state it again. It is essential to the proper administration of criminal justice that dignity, order, and decorum be the hallmarks of all court proceedings in our country. The flagrant disregard in the courtroom of elementary standards of proper conduct should not and cannot be tolerated. And trial courts and trial judges that are confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. They noted 3 constitutionally permissible ways to handle such a stubbornly defiant defendant. But they also indicated that no one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. I've noted this before. This is a case from 1970. The technology that we now have in this brand new courtroom was not available then. I have the ability to have Mr. Brooks appear from the other courtroom by way of audio and visual means. We can see him, he can see us. I've confirmed prior to calling the case that the audio was working, that the video is working. The one camera, there's 4 cameras in my courtroom, there's 4 cameras in his courtroom. However, it is set to 1 camera since he's the only individual there, other than the bailiffs, but I'm talking about as a party to the litigation. So the courtroom, the cameras in my courtroom include one that would normally be on the witness stand that has been zoomed out so as to capture the large majority of the jury box. I even adjusted the camera that's on the state's table so that the exhibit that's currently up to my left, her right, Attorney Opper, is viewable in the camera angle, and she is still present within, meaning viewable within that as well. And although I've made a finding that he has forfeited his right to be present for the state's closing argument, I'll find that the technology that I have available, it is that his appearance from the other courtroom is the functional equivalent of appearing in this courtroom and being present due to the technology that is available. I do have him on mute for the time being because I needed to make a record, and there is a very lengthy history with Mr. Brooks during this case of him talking over me and my inability to make an adequate record if I am in a constant back and forth with him and trying to talk over him. And so I, yes, made the decision to utilize the mute function on the incoming audio. I know he disagrees with my ability to do that, but I believe it is consistent with ensuring dignity, order, and decorum, that when appropriate, he be muted. I will advise Mr. Brooks once again that although he has lost his right to be present in this courtroom, he can reclaim the right to be present as soon as he is willing to conduct himself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. That includes not interrupting the court. That includes respecting when the court renders a decision by way of an oral ruling, even if he disagrees with it. So with that, I will advise him that once the jury is brought out, I will unmute him. I expect that he will be respectful of them, and I expect that he will not interrupt as the court goes through the couple of final jury instructions I need to go through, including the reading of jury instruction 160, closing arguments of the parties.
Hey, sweet Caroline. Bum, bum, bum. Sorry. I had to. Hey, Caroline. Sorry, pretzel flew out of my mouth. Happy gifted membership Yeah, you were gifted a membership. You were gifted a membership. Bum, bum, bum. Face the judge. I know, right? Skylab, yeah. That was very gross, I will say. I love that song. All right, we'll get back to it, but congratulations, Caroline, you did. You got a membership. You just got a membership. You just got a membership. Da 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 da.
And then I will turn it over to the
you've been
state, but I will
listening all
unmute him
day?
at that point. So should he have an objection, he will be able to state objection. I will be able to rule on it. And again, I expect him to honor whatever the ruling that is made. And if he does not do that, then I will
Nice.
utilize the mute function. If he doesn't have it, we'll make sure he has the objection sign. And if I see that, I will unmute him to hear what it is and then make a ruling accordingly. Attorney Hopper.
Your Honor, 2 quick things. Please, could you confirm that the audio and video are working in the next courtroom? And the clerk's shaking your head, they've done that. Thank you. I don't know if you want to do it now or at a later time, but I think we should make a record, as I will be displaying a PowerPoint during my closing argument, throughout my closing argument, and I'm not
That's
sure
being
how
teased.
that
Oh
is
my
projected
God.
in the next room or how it affects what we see in this room, Your Honor, but we should make a record of that at some point.
Thank you. My understanding is Madam Clerk has the ability, so that is displayed not only here, but in the neighboring courtroom. If you would be so kind as when you start displaying it, just make some type of record, excuse me, so that the bailiff who's over there, if it's not being properly viewable, if it's not viewable, that we can stop and adjust
Sure.
accordingly.
Okay. Thank you.
If you would like, before the jury comes out, we could do a test,
Yes, could we please?
please. Madam Clerk, would you confirm with the clerk over there that the PowerPoint is also viewable?
They can see it.
All right, and it should be similarly to what we see. So the monitors will display the camera that Mr. Brooks is appearing, that is on Mr. Brooks on the left-hand side of the TV, and then the 4 cameras for this courtroom are on the right-hand side, but it's probably maybe a quarter to a third of the screen, and then the remainder of the screen is the PowerPoint. The monitors in the courtroom that Mr. Brooks is in are no different than what they are here. He would have one at the table, but there would also be the very, very large TV monitor above the clerk over there. Well, it's smaller, and then the very large one over the witness stand. So it would be very similar to what is here if he were present in this courtroom. And again, I know that the diagram, it's probably not the most easily seen from a camera, but it's really no different than what I'm looking at the moment. So I appreciate you asking that I make a record of that. I would further make a record that there are headphones on the table where Mr. Brooks is currently standing. He has not put them on, but they are available should he want them. All right, then are you turning off all right, PowerPoint? Let us know when you need that function, and then Madam Clerk will be able to make that viewable in both courtrooms.
Very good, thank you.
All right, with that, the jury is to be brought out.
No, Gail, I can't help myself. I really cannot help myself. And you know, the funny thing is I do that all day, even when I'm not on, like, here with you guys. I'll be just, I don't know, walking out to the mailbox to get the mail. Open the mailbox up and be like, I just got a letter. I just got a letter. I mean, that just, it never fails. It always, I don't know. Opper the Chopper is about to bring down the hammer. She getting ready to, and I'm here for it. I'm ready to hear this again. I really am.
Okay.
Oh, that's sweet dog, Mom. 25 years. Happy early anniversary.
All rise for the jury, please.
I do too, Caroline. I do too. Skylab, who is badass? Sue Opper or the judge?
Thank you, everyone. Please be seated. Ladies and gentlemen of the jury, when I read the jury instruction to you previously regarding credibility, I had a prior version of the jury instruction. Now, what I read to you in the very beginning, at the very beginning of this case, was the most recent. I am going to read a short paragraph, but also tell you that in the packet that will be sent with the jurors to the jury deliberation room.
Sorry. I don't mean to talk with a mouthful of food. But you notice that he wasn't waving his hands until the jury comes in and sits down. And then when she starts, that's when he's...
It will have the complete instruction, and it's instruction number 300, excuse me. And this is what I want you to know about credibility.
That's sweet.
In your determination of credibility, you must avoid any and all bias based on the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. Consider carefully the closing arguments of the parties, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given you by the court. With that, I will ask Attorney Opper to start with her closing argument. Go ahead.
And then, clerk, if you would please turn on the PowerPoint.
Yes. Hold on one second. Mr. Brooks, do you have an objection?
I thought I was supposed to be unmuted.
You are now. All right. Attorney Opper, you may start.
Thank you, Judge. Good afternoon, everybody. It's kind of nice to stand here in the middle of the courtroom. You know, all week or the last 3 weeks, they shoved me at the end of the table because I'm the lefty in the group. It's nice to be able to look at you all and say thank you. Truly thank you. Each and every one of you. I want to express our sincere gratitude from the prosecution team, myself, Deputy District Attorney Leslie Basie, Assistant District Attorney Zach Witchow. There's no one in this courtroom that does not realize the sacrifice that you've made serving your community in this very important task. You've put your lives on hold. I don't even want to hear from your bosses. Thank you. You've watched these proceedings and you've noticed as we sit at our prosecution table, we don't have a client at our table. But rest assured, we do represent someone. We represent the people of the state of Wisconsin. It's an entity. I can't bring it to the courtroom. People enact laws. People want to feel safe. People have representatives in Madison or Washington, D.C. that set standards, rules that we all are expected to live by. And when those rules are violated, prosecutors step in and enforce the law. Darrell Brooks does not represent anybody. He does not have a client. Darrell Brooks is the client. Darrell Brooks is the defendant. The state of Wisconsin is the plaintiff. It's really that simple. And it's consistent with any other criminal case you've ever heard about at any other time in any other jurisdiction. It runs the same, no matter what state or federal. I'm going to ask you for your guilty vote at the end of my comments. It's up to you. I can't tell you to do anything, except I'm going to say one thing to you that I wholeheartedly ask you to obey.
Attorney Opper, I'm sorry for the interruption. Your objection, sir?
Mischaracterization of who I am and the way it was said. I feel like it was talking down.
All right, your objection's noted. It's overruled. The statement continue.
You must not consider anything about Darrell Brooks other than his conduct in downtown Waukesha on the evening of November 21, 2021. Nothing he's done before that, nothing he's done since that. When you go back to that deliberation room, please obey Judge Darrell. Confine your comments to his conduct on November 21 of 21. Is he guilty of the 76 counts that he's been charged with? That and solely that should be your topic of discussion. So, what are the charges against Darrell Brooks? Thank you for your patience in listening to the jury instructions. They must be read for each and every count. But sadly, they can be summarized very quickly like this, as far as the actual counts. Counts 1 through 6 are first-degree intentional homicide while armed with a dangerous weapon. Counts 7 through 67, first-degree recklessly endangering safety while armed with a dangerous weapon. Counts 68 through 74, hit and run causing death. Counts 75 and 76, bail jumping, and count 77, battery.
Whoa, whoa, whoa.
Mr. Brooks, what is your objection?
I have 76 charges, not 77. It's a mischaracterization of the charges.
That is correct. It is sustained. It should be count 68 through 73, I believe, and then 74 through 75, and then 76.
Thank you, Your Honor. I do apologize for my math skills. 68 through 73, 74 and 75 are bail jumping, and 76 is battery. I apologize for that misstatement. We're going to talk about counts 1 through 67 in detail. Counts 68 through 73, hit and run causing death, in my opinion, are easily summarized as this. He never stopped. Never. Bail jumping, he was out on bail for 2 files in Milwaukee County, facing felony charges there. He was ordered to not commit any further crimes. If you believe he was involved in any of the conduct charging counts 1 through 67, you should find him guilty of bail jumping. Battery, that relates to the split lip and black eye suffered by Erica Peterson. We told the story kind of backwards. We started with the battery for background. First degree intentional homicide. You've seen this in our opening statement. You've heard it from Judge Darrell. Did Darrell Brooks cause the death of the victim, a victim? Did he act with intent to kill, meaning either the mental purpose to take the life of another or was aware that his conduct was practically certain to cause the death of another human being? Count 1, Ginny Sorensen. Count 2, Lee Owen. Count 3, Tamara Durand.
Oh, I got
Count 4, Jane Kulik. Count 5, Bill Hospital. Count 6, Jackson Sparks. Those are the individuals who lost their lives because of the conduct of Darrell Brooks. From there we go to reckless endangering safety. What is that? In this case, it means that through his reckless driving, he endangered the safety of other people. And he did so demonstrating utter disregard for human life. Now, behind me is State's Exhibit 15. It's also on the PowerPoint. If you choose, you may have this chart with you in the deliberation room to help you walk through each of these counts if you find it helpful. It's up to you. If you don't want it, you don't have to have it. But it will be available for you if you ask for it. And it'll take you, as we did in our presentation of the case, right down Main Street and address all the counts that were involved, all the counts that were charged. To prove reckless endangering safety, and I'm just going to go back one slide, nowhere do you see there that we have to prove any degree of injury to anyone. Never once did Judge Darrell instruct you that somebody has to be physically injured. Now, Detective Casey told you that was the standard we use in deciding of all these hundreds of thousands of people who is included in these charges. And the decision was made by the prosecution team to include people who were physically injured to be efficient in our prosecution. And so everybody up and down the street, I would argue, had their safety endangered that day. I didn't charge 5,000 counts. We selected 61 counts of people that we can identify by name in Exhibit 15 that were injured by the conduct of Mr. Brooks. Those are the people in green. People in red are the fatalities. And we presented this case to you in much the same fashion that is presented here on Exhibit 15 as to how the injuries occurred going down that street. So we are absolutely held to our burden of proof and the elements for each offense that Judge Doro instructed you on, but we are not required to prove any injury to anybody. The question is, was their safety endangered by his reckless conduct, his reckless driving? Now, some of the groups, it's pretty easy. They walked in a formation, and you can get a photograph or a diagram, and you can kind of see pretty easily who was located where, right? And you can think back to the videos that you've seen for each of these groups and remember, and you'll see them again, the path of the vehicle as it went through each of these groups. This is South Band, of course. All of these names that are being displayed on the PowerPoint Exhibit 21 are on Exhibit 15 in green for Waukesha South Band. Pretty much the whole left half of the formation was endangered by the safety of Darrell Brooks driving up the side of that band. The extreme dance team, it's a little difficult to read, but again, this chart was marked as an exhibit. It's exhibit number 33. If you want it, you can have it in the jury room. The names on this chart will match the names for the extreme dance team on State's Exhibit 15. All of the girls that were struck and injured as they marched with the extreme dance team, plus some people on the back that were handing out candy or serving in support roles as the unit made its way down the street. The dancing grannies, State's Exhibit 54, the formation that they marched in, who was located where, and your recollection of how that SUV zigzagged through that group. And you can just see the names and match it up to who was injured and killed versus who wasn't. Now, one of the big things in this case has always been, why did this happen? What was he thinking? Why did he do this? Again, those are things I don't necessarily have to prove to you. His intent, I do have to prove, and I submit without any doubt there's overwhelming evidence that this was an intentional act by Darrell Brooks and an act of utter disregard for human life. I say that for these reasons, folks. Number one, first and foremost, just stop driving. That's it. It's really that simple. Not one person had to be hurt that day if he would have just stopped driving.
Excuse me, Attorney Alford, your objection, sir?
You specifically, I'm sorry, can I be heard?
Your objection, sir?
I didn't know if I was on mute or not.
You're not?
You specifically said in your jury instructions that intent cannot be, you can't look into someone's mind, I think is what it says, define intent. So how could that be characterized as someone knowing for sure intent or not knowing for sure intent?
You're making an argument. You'll have an opportunity to do that later. Your objection's noted. It's overruled. The state may continue.
I apologize.
We showed you at the very beginning, remember our first witness was Sergeant Warner, the man who was the incident commander for the parade. We put up another map. I think it states Exhibit 1. You can have that if you want it. Shows all the positions of all the police officers and the reserve officers, the barricades, the squad cars. How do I know it was intentional? Because even Darrell Brooks told Detective Carpenter, I could tell something was going on downtown. No reasonable person would drive upon this area, see the squads with their red and blues on, see the officers in the street with their bright yellow vests, see all the people milling around, see the floats lining up and the participants getting ready, and not know to drive safely, slowly, and obey officers. The barricades help us prove it was intentional. The police presence help us prove it's intentional. The parade participants help us prove it's intentional. And the parade spectators help us prove it's intentional.
Excuse me, Attorney Alford, your objection, sir?
Speculation as to what the alleged defendant said he saw. It
Sir,
was never.
Your objection's noted, it's overruled. This is closing arguments, not the evidentiary phase. Go ahead,
So
Attorney
how
Alford.
can speculation be made to what was saw? if
Your
that was never
objection's
testified
noted,
to?
it's overruled. Continue, Attorney Alford.
Honking the horn. Quite interesting that Mr. Brooks asked so many witnesses if they heard the horn honking. Some of them said they did at the beginning of the parade. Yeah, I heard a horn honk. Most of them said they didn't. The horn honking cuts both ways, folks. If he's honking his horn, that means he can see something's in front of him. That means he knows there's an object in the road. You can rely on your common experience in your affairs of everyday life. If you see something in the road and you want to alert the other person to your presence, you will honk. But you do not have the green light to then just keep going if they don't move. He knew they were there. Intent. I've skipped one, I'm sorry. Going back to my street, number 15, I failed to include the Catholic community. That's just one of the photographs showing the people that will match up to Exhibit 15 from the Catholic community of Waukesha. There's a lot of photographs identifying the people that were marching with that group. The parade started. This is the starting point, or at least near the beginning, right? This is the area. We showed some videos of the groups passing by in this area. We heard testimony from 4 different police officers standing in 4 different spots near here, telling of their 4 different efforts to stop him. Intentional. Sergeant Wander's back here testified that this red SUV blew by me. I waved both arms over my head. I'm in a police uniform. I have an unmarked squad, but I have my red and blues on. And he blew past me. He gets down here to the corner where Detective Casey is standing. Detective Casey runs out into the street, gets close enough to put his hand on the hood of the car. He keeps going. He comes down, turns onto Main Street, gets in this area of East Avenue to the south and Buckley Street to the north. This is where he encounters Officer Schneider and Officer Buttrin. They each make a separate effort to stop him, and he keeps going. 4 police officers. It's intentional. He had plenty of opportunity to just stop anywhere along the way. One of the officers testified to it. I think it was Officer Schneider. This was an accident, and he mistakenly wandered onto the parade route after passing all this, and he mistakenly wandered onto the parade route. At any point, all he had to do was stop. They could have paused the parade. They could have moved the barricades and escorted him out. He didn't. It was intentional. He went on for 4 blocks. 4 blocks. It was intentional. He reached speeds of approximately 30 miles an hour. That's intentional. He plowed through 68 different people. 68. How can you hit 1 and keep going? How can you hit 2 and keep going? How can you hit 3 and keep going? Didn't faze him a bit. He kept going until he got to the end, and there was no more bodies to hit. It's intentional.
Mischaracterization of the evidence.
Noted, overruled.
His conduct when he left the parade route, we'll get into this. His flight, his hiding, his panic, his desperation to run. Get the hell out of town as fast as he could before the cops came. That shows his intent. His interview with Detective Carpenter, we spent several hours playing you snippets of that interview. How telling was that? Never once did he say any of these things. Never once did he say, like he told you in his opening statement, it was an accident. It wasn't intentional. Never said that to Detective Carpenter. No, he came up with some convoluted story about, I got a ride out here from a buddy in a tan Kia, and then I left to go meet Erica, and we got into a fight, and then I went back, and the other guy got into a fight, and he was leaving, so I took off on foot. absolutely nonsensical story. Does not match up with the known evidence in this case.
Overruled.
He never
I didn't
stopped.
even state the objection.
This is closing argument. She may continue.
I'm going to play this slide, which is a snippet from State's Exhibit number 53. Go ahead and play with sound, please.
Sorry, I can't help but I can't help but I feel like in honor of the victims that I can't let the video of that accident go at any other speed than normal. I know that's weird. Maybe it's not weird. I don't know. I just feel like I have to play it in normal speed.
That was just a snippet that I selected because I thought it really captured the environment that so many witnesses tried to explain to you, right? It's a Christmas parade. People are there with their families, their little kids, their grandkids, their neighbors, their friends, strangers, standing next to strangers. That's what's going on Main Street. While that's going on Main Street, this is going on. Remember this? This is the gas station on the corner of Barstow and North Street. While the units are marching down Main Street, entertaining the crowd, Darrell Brooks is driving recklessly. He's enraged, and he's arguing with Erica Patterson. Why is this important? This is important because before he even gets to the parade route, this is how he's driving. He drives the wrong way down North Street and then acts like it's everybody else's fault in the world.
Your objection is noted. It's overruled. You may continue, Attorney Opera.
When he finally pulls into the gas station, he rolls down his window and yells at the driver who's properly stopped at the stoplight that it's somehow that guy's fault that Darrell Brooks is trying to drive the wrong way down North Street. And from there, the rage continues. We get to this point, State's Exhibit number 3. Please play. The video's playing. You can see the pushing match between Darrell Brooks, Corey Runkle, Erica Patterson, and Nick Kirby. Watch this. He turns to get in the car, flips up his hood, and goes and gets in the passenger seat. I'm sorry, driver's seat.
How long we gonna mischaracterize testimony?
Sir's argument. I've heard nothing improper. Your objection's noted. It's overruled. You may continue, Attorney Opera.
Thank you.
They need to know they can nullify.
That's it. He drives off onto the parade route. From this moment, right here on Exhibit 15, you're watching it. He's enraged. He's angry. Flips up that hood, and he zooms past Sergeant Warner, past Officer Casey, onto the parade route. Now, there's no doubt, for the first 2 blocks, he does not strike anyone. And as we've discussed, some even said he was driving at a reasonable speed. initially. By the time he gets past Officer Buttrin and Officer Schneider in this area here of East Avenue, past East Avenue, and clearly once he gets past Barstow, that's where it starts, right? That's where it starts. Nicole White, our first victim, walking with Remax and a hot air balloon. Knocks her over, keeps going, runs up and over the backs of Waukesha South Band, hits the green children spectating on the sidewalk, keeps going, runs over Kelly Grabo and her daughter Adelia, walking with Burris Logistics, keeps going, plows through the entire extreme dance team just before the 5 points, keeps going, hits Deborah Ramirez and her son Isaac spectating on the south side of the street, keeps going, clears the 5 points area, hits Jane Kulik square on, causing her to go up on the hood of the car, and then fall off and drives over her body. He doesn't stop. He keeps going. Runs through the kids over by the steaming cup. We heard the parents testify about little Brinley and Kelsey and Owen that were standing there outside the steaming cup. They were struck by the red SUV driven by Darrell Brooks. Keeps going. Plows through the grannies in that zigzag fashion, striking most of them, injuring them, killing them, keeps going, gets down here to the end and goes through the Catholic community. The witness, remember Holly Berg, she testified about that mobile gas station incident. She said she was standing down here in this area. She said, I saw 15 to 20 people fly in the air. They look like bowling pins. And when she saw the video, she's absolutely right. It's a terrible description when you think these are human beings, but that's exactly what it looked like. When does the intent exist? Doesn't have to be even for a second. I'm not telling you who set out that morning to cause this carnage. But when he became enraged back here, he didn't give a damn who or what was in his way. He intentionally went on. I'll show you. Motive. I don't know why he did this. Folks, I don't know why. Other than the rage. He's right. You cannot read minds, neither can I. But the law doesn't require you to. The law gives you a way to reach a conclusion as to what is somebody thinking, and it's right here. Decide it based on his acts, words, and statements, and from all of the facts and circumstances. I've already been through many of them. I want to show you what I mean. Look at this. Was there room for him to get out? This is way back at the beginning. This is Officer Buttrin's squad video. Way back at the beginning. That's Buckley Street here that you're looking at. Look at those barricades. Look at the sparse crowd. And there's Officer Schneider in her yellow fluorescent vest on the left side of the picture, about to run into the street and stop him. Intent. I'm going to play this video for you because, folks, for me, this is where it becomes crystal clear. You watch this video, the first thing you're going to see if you direct your attention to the left side of the screen is you're going to see him hit Nicole White. Knock her to the ground and keep going. Now, if that was the end of the story, you may sit here and say, Madam DA, I don't know how you conclude intent from that. Maybe it was an accident. Maybe he didn't mean to do it. But watch what happens in this video after he knocks Nicole White down and tell me this does not prove intent. Please play. Keep watching the left side of your screen.
Oh my God. Oh my fucking God.
That's intent, folks. No reasonable person is going to come across a group of teenagers playing band instruments, drive over them, and keep going. That's a still shot of the same thing. That's intent.
I'm sorry to interrupt your objection, sir.
How can you tell the jury what they supposed to think?
It's proper argument. Your objection's noted. It's overruled. You may
Yes,
continue.
I would argue that it's,
Attorney Hopper.
I would say that it's improper, and I move
Mr.
for a
Brooks, I've made
mistrial.
my ruling. I'm going to mute you if you don't follow the rules.
Exhibit
I move for a
1,
mistrial.
Exhibit 152. Clearly intentional conduct.
52.
Clearly intentional conduct. States Exhibit 93. We asked the court to take time to have you go look at this car in person because it's remarkably amazing that this damage was caused by human beings. That's intent. This is an excerpt from States Exhibit 154. Maybe a little hard to see. A lot of that laying in the front part of this photo are shoes. Remember what Dr.
Oh, the shoes part. All the shoes. You okay down there, Pop? My dog down here stretching. Kelly says, I missed it, but I freaking hate when he says no children were hurt when he hit the marching band. Both my kids were band kids. They were children. Just because he doesn't see teens as children is BS, yeah. God. Her closing is amazing. Yeah, 100%. I love it. I love it. The, Patricia, you know she wants to just go over there and poke him right in the eyeballs.
Bidritsky said about the shoes and the feet, the scuff marks on the toes and the ankles. Look at all the shoes laying in the street. This is the area at the end when he ran through the Catholic community. All the shoes laying there because of the velocity. Remember, the medical examiner talked about the velocity. It's not just the speed, it's the velocity. The power that these people were knocked right out of their shoes. That's intent. The flight, the hiding, changing his appearance. He had to go through some effort, right? Crawled up in this playhouse, ditched his sweatshirt and his sandal. The other sandal seems pretty reasonable. He dropped it when he was jumping over a fence. Changed his appearance. Please play.
Excuse me.
Intent. What's he running from? What's he running from if he's just a lost guy with no ride back to Milwaukee? What's he running from as there's cops, sirens wailing in the background? Whoops, that was me. So, State's Exhibit number 130. Put that up here quickly. Take this one. Thank you. I'm not going to go through this whole thing, folks. Suffice it to say, after Officer Skolton tried to stop the threat at that intersection at the top, Wisconsin Avenue, and he blew through the barricades there and drove south on West Avenue over to Prospect Court, cutting through the yards and ditching the vehicle on Maple. Heard all the testimony about the commotion on Maple. The eyewitness testimony from Officer Sailors, off-duty police officer who saw this, saw the defendant, Darrell Brooks. He identified him for you in this court. Get out and run from this car. And how we tracked him through the neighborhood. And again, the desperation, whether he had to ask or use veiled threats like, I won't hurt you, but I need your phone. He was absolutely desperate to get out of there until he took refuge in the home of Daniel Ryder. Now remember the interesting thing, folks, none of these witnesses in this area knew anything about what happened at the parade. None of them were there. None of them were there. So some of them tried to help, some of them didn't. Daniel Ryder did, and it's actually probably a really good thing that he took him in, because it stalled, right? It stalled them from keep running, kept them in one place until the cops could close in and get there. Now, Mr. Brooks repeatedly asked witnesses who had just watched their loved ones get struck by this SUV if they happen to catch a license plate. State's Exhibit 150, there's the front license plate. Definitely a little blurry, but definitely you can make it out. State's Exhibit 151, there's the rear plate. State's Exhibit 175, there's Darrell Brooks in his music video with the same car and the same license plate. There's the key to the Ford that was found in Darrell Brooks' pocket. There's no doubt Darrell Brooks is the person responsible for this, because this man in this picture is the same as this man in this picture wearing this sweatshirt. And again, it's a little hard to see, but you can ask for these exhibits in the jury room if you want. The photograph, you can see this design on the front of the sweatshirt if you look close enough. This is a sweatshirt from the playset that has Darrell Brooks' DNA on it, according to the crime lab. That's him right there. That's Darrell Brooks driving off into the parade. That's Darrell Brooks driving in the parade. That's Darrell Brooks driving in the parade. That is also Darrell Brooks driving in the parade. And so is that. And he kept asking people about the tints on the window. Well, guess what, folks? You don't need to see the tints on the window when the windows are rolled down. And there's clearly one person in that vehicle in every one of these photos. And it's that man. And it's that man. And it's that man. Darrell Edward Brooks Jr., date of birth 2/21/1982, on his identification card issued by the state of Wisconsin. In all capital letters, Darrell Edward Brooks Jr. This was in his pocket when they arrested him.
In all capital letters, mind you.
So this entire shenanigans that he's presented to you through his questioning of witnesses about, I'm not Darrell Brooks and that's my name and I don't know who that is and I don't consent to being called that name. It's just nothing but a distraction. It's Darrell Brooks. It's the man who drove through the Waukesha Christmas parade and killed people, injured people, endangered the safety of people.
I'm sorry, your objection, sir?
Your Honor, with all due respect, I would appreciate the quote unquote language what does she mean by shenanigans and this and that and the third?
Sir, your objection's noted. It's overruled. The state may continue.
Well, can she tone that back? Because if that was me, if I would have said
Mr.
something
Brooks,
like
your
that, it would have been a
objection
problem.
is noted. It's overruled. These are closing arguments. There's nothing improper. It's noted. It's overruled. She may continue.
I just wanted to be fair.
You'll have an
Your Honor, that's it.
opportunity to respond, sir. Please let her finish.
So I can rebuttal?
Go ahead, Attorney Opper.
Thank you. I'm going to conclude my comments with this, folks. I'm going to show you the video,
My heart is
a
like
stitched together
pounding.
video of all the carnage caused by Darrell Brooks, and I apologize.
It's together.
This is important that you know what he
Mute
did.
him.
It's important that you think about the women like Nicole White and Kelly Grabo and her daughter and Jane Kulik, who were just there with friends and co-workers supporting a local business. The teenagers marching in the band, wearing their school colors.
Oh, I love that dog,
It's
Mom.
important.
That's awesome.
The boys and girls with the Blazers baseball team and their coaches doing nothing more than handing out baseball cards. The young girls in the extreme dance team. Can you imagine how many hours they spent practicing that routine? He drove right through them without a care in the world.
Opera the chopper.
The grannies dancing their way down the street, perfect step, every one of them. The Catholic community there, as Father Matt said, spreading the light of Christ in the weeks before Christmas. He snuffed it out. It's time for Darrell Brooks to stop running. It's time for him to stop lying. It's time for him to be held accountable for his actions. Darrell Brooks cowardly rammed his way through this parade, violently killing and injuring so many people. I'm going to stop talking and play this video, but please, I ask you to add up the evidence, use the map, 15. You can check off the names. We've covered them all. Walk down that street like we did with you. Return guilty verdicts on all counts. Please. Please.
Screen back up.
No, I need one more. Yes, please.
She's amazing.
Go ahead.
I don't know what video they're watching or what. Is it all of the videos of him running through the crowd, like from different angles, all the different footage that was caught that she said she stitched together? Must be. Yeah.
Thank you. Before we continue with Mr. Brooks's closing arguments, I'm going to take a short break. All rise for the jury, please.
Am I muted?
No.
The jury should know that they can nullify.
You are muted now.
Sorry if I just bursted everyone's eardrums, but after she watched what she just watched, and him to even say that.
Thank you. We'll be in recess for about 10 minutes.
She's like, you're muted now. Ugh. I mean, even him, let me just say, even he was, pretending, I'm assuming, to be emotionally affected by that, right? The first thing you're going to say is, can I let the jury know that they can be nullified, blah, 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 blah. Really? Really? Didn't skip a beat. Man. He's got a lot of nerve.
Courtroom prior to reopening following the break. I did invite him back into the courtroom, and he is here. I trust you are ready with your closing argument, sir.
I'm ready to address subject matter jurisdiction as well, too.
That request is denied.
Just for the record, I was addressing it for both courtrooms, here and courtroom number, I think it's 20.
Mr. Brooks, I'm going to bring the jury out. Are you prepared
Oh, yeah.
to present
He cries
your
through the
closing
whole
argument?
thing.
I would like for you to prove subject matter jurisdiction on the record, Your Honor.
I'm not addressing that any further than I've addressed already, sir. There's a written decision. I'd remind you of that.
In that written decision, did I receive, well, actually, I didn't receive anything. Was there copies made?
Mr. Brooks, I'm going to ask you one more time. Are you prepared with your closing argument? I'm going to have the jury brought out. There is no other legal arguments I need to address from you at this time.
I'm informed of what you're saying. I was merely asking, was there copies made of your, you said written decision?
Sir, my written decision has been filed into the record. That is done electronically. You were provided with a written copy previously. Are you asking for another copy of that, sir?
Yeah, 'cause I don't have it.
As a courtesy, I'll have my clerk print off a copy and provide that to you.
Is it proven subject matter jurisdiction?
Your objection to the lack of jurisdiction has been noted repeatedly on the record. It is a meritless argument. I've indicated that in my written decision as to why there is subject matter jurisdiction, and I will continue forward with the final stages of this trial, which I hope include your closing argument and then the final instructions to the jury.
I would hope it proves subject matter jurisdiction on the record too.
All right, I will instruct the jury to come out. For the record, the written decision is once again being provided to the
I
defendant.
accept for value and return for value this document as it is not based in lawful law. And it does not prove subject matter jurisdiction whatsoever. Refers to some complaint that was filed in the name of a trust, not my name. Were you aware of that, Your Honor?
Mr. Brooks, the jury has been asked to be brought out. I mean, I've requested that they be brought out. They're on their way.
Were you aware of
Please be
that?
prepared with your closing argument.
Were you aware of that, Your Honor? Or is that a tacit agreement that you don't have to answer any questions as a public servant?
All rise.
So that is a tacit agreement.
Record to reflect the jury is coming out. Thank you, everyone. Please be seated. Go ahead, sir. You may begin your closing argument.
I'm not ready to begin closing arguments.
So this is your opportunity to provide your closing argument to the jury. Please start. I've started the timer of 1 hour.
I'm informed of that, Your Honor, but I'm not ready to proceed as I don't understand the reason why the questions asked before the jury was present were not answered. There are issues that needed to be addressed outside of the jury, as you always say, which I don't understand why. The jury deserves to
Mr.
need
Brooks,
to know.
this is your opportunity to present your closing argument to the jury. Please do so.
I'm informed of that, but the jury needs to understand the truth, their rights, and their duties, as they have not been informed of their truth, their rights, and their duties.
Mr. Brooks, the court has begun the instruction process. I read 73 pages this morning, and into the early afternoon, I have another 30-plus pages to read.
Did you inform
They will
the
be
jury?
informed of the law.
Did you inform them that they can
Mr.
nullify
Brooks?
the law?
Mr. Brooks, you do not have that right to request that. And
Were
I'm
they
advising
informed?
you, one more time, this is your opportunity to provide your closing argument. Please begin.
I intend to when ready. I just want to know if the jury was informed that they can nullify the law.
Mr.
they
Brooks,
are-
you
that
have
they
no
have
right
the
to
power.
make that argument to the jury.
It's true. They have the power.
All right, I'm going to excuse the jury.
They should know that they have the power.
please rise for the jury.
Lord, Lord, Lord. Oh, Caroline, I don't remember what, but I don't think that he was under the influence of anything. And as far as competency,
Thank
he
you.
was
Please be
found
seated.
competent.
Mr. Brooks, you do not have
stand trial,
a
yeah.
right to request jury nullification directly from this jury. I direct your attention to the Bjerkas case, BJERKASS, that's State versus 163 Wisconsin 2nd 549. While you are not incorrect that the jury has the power to nullify, they don't have the right to do so, and no party has the right to instruct or to request an instruction or to argue jury nullification.
Oh, what was I gonna say? I was gonna say something. Oh, what I was gonna say though, Caroline, is that he does. I think he has been diagnosed with like personality disorders or whatever, but nothing, to make him be incompetent, He just raged out that day, all because him and his girlfriend, or ex, got in a situation, and he flipped out.
You may talk in terms of fairness, in general terms, but you may not go further. You may not argue that the jury should discard the instructions in the law and find you not guilty for that reason. You may not use the phrase jury nullification. You've done that now at least 3 times in earshot of the jury. Twice while you were in the other courtroom, I was able to mute half of what you said the second time, and then of course you raised that once again while in front of the jury just now. You also indicated you weren't ready to give your closing argument. Sir, the time has come for you to give your closing argument. If you choose not to do so at this time, then you will forfeit your right to present a closing argument by your conduct.
I haven't made any such choice, so you can't coerce me into a constitutional right waiver when I have not waived the constitutional right, and I will not allow you as a public servant to do that. I have not made a choice.
Sir, the time has come for you to present your closing argument.
Are you making a judicial determination that you're denying me a constitutional right in
I have
open
not
court
made such a
on record?
determination as of yet, but you can forfeit your constitutional rights
Under
by
what
conduct.
lawful law?
Illinois versus Allen, State versus Anthony.
Illinois versus Allen does not reference anything pertaining to rights when talking about
In
closing
State versus
statements.
Anthony,
Illinois
the Supreme
versus
Court
Allen.
of Wisconsin referenced both that decision when it essentially extended the reasoning or adopted the reasoning of Illinois versus Allen to then find that a defendant could forfeit an important constitutional right by conduct. In State versus Anthony, it was not the right to be present in the courtroom, it was the right to testify.
Okay, so none
And
of those
the
that you just
reasoning-
named have anything to do with the closing arguments, Your Honor. You've used Illinois versus Allen repeatedly to when it comes to me being removed from the courtroom. Not one time did it bring up anything dealing with a closing statement or a closing argument. So how's that same statute being used for something that it doesn't even refer to or pertain to?
Mr. Brooks, the Allen decision, Illinois versus Allen, and the Anthony decision, which is State versus Anthony, are 2 examples of cases where a defendant lost a very important constitutional right because that right was forfeited by the conduct of that particular defendant.
And that was to be present in trial, correct?
The right to present a closing argument is no different. Because it is not evidence, it could be said that it doesn't even rank as high as the right to testify, which is guaranteed by the constitutions.
Which I was denied the
I'm
right
not
to
prepared to
be
make
able
that
to
ruling
testify to.
here yet today, but I will tell you this, sir. The time has now come for you to present a closing argument. There will be no further delays.
It's
I
not a
will not
delay.
be taking any further adjournments for you to prepare. You were advised yesterday that this court would proceed today with instructing the jury and with the parties making their closing
back, Sharon.
You
arguments.
made that while
It is
violating
up-
my constitutional
Sir,
right.
please don't interrupt me because
Well,
you've now
you did.
interrupted me a couple of times.
No, once. So
Welcome
let's make that
back.
correct.
Welcome
Once.
back.
That's the third time.
Okay, now you can say two.
So, Mr. Brooks, I'm advising you yet again, the
I
time
don't
has now
consent to
come.
being caught
That's
that
another
day, Your Honor.
interruption. The time has now come for you to present your closing argument to this jury. You were
And?
brought back over to this courtroom for that purpose.
I'm going to let them
That's
know.
another interruption.
No, I'm going to let them know that they have rights and they should be informed of the truth. It's not me
Are
trying
you
to
telling
give.
me, sir, that
it's
you are
not
going
trying
to
to give.
let me ask you a
No, hold
question.
on. I'm not trying to give any
Sir, you're
jury
interrupting
instruction.
me and you haven't let me finish. So are you telling me that you are going to disregard my very clear directive to you to not bring up the topic of jury nullification?
That's not what I said.
That's why I'm asking you.
I don't understand that question because that's not what I said.
Sir, you may not argue jury nullification
I'm
to
going
this
to
jury.
inform them of the truth.
So you're going to inform them that they have the power of jury nullification.
They do have the. You just said on the record that they have the power for.
Sir, I direct your
You
attention
just said that.
once
Did you
again.
not just say that, Your Honor?
Sir,
You
the
said I couldn't
jury-
instruct them.
The jury
on
has
that.
the power, but not the right to nullify.
Right.
A
You said the
party-
power. You said the
Listen
power.
to me, sir. You're interrupting me once again.
So I'm going to inform them that they have the power.
Are you telling me, sir,
I'm
that
not
you are
telling you no
going
such
to
thing. I
disregard
just told you what you just said.
my directive to you to not raise the issue of jury nullification during your closing argument?
That's not what I said. You just read and said that they have the power to. That's what you just said, Your Honor.
Sir, State versus Bjerkus says and stands for the proposition that although the jury has the power of jury nullification,
They have the power.
no party has the right to argue for jury nullification.
I'm not arguing for it, Your Honor. I
In
just
that
want them to be
case,
informed. I just want them
Sir,
merely to be informed.
You
That's
can
it.
call it informing, making them aware.
Yeah, they
Whether
should be aware
you
of
are
the
not
rights.
allowed to make them aware of their power to nullify. That
How
is
can I not make
an
them-
improper argument.
Your Honor, how can I not inform them that they have a power? How
Because
can I
that
not
is not a
inform them
right
of a
that
power
you
that they
have,
have?
sir.
I'm not giving a new jury instruction.
That is
That's not what
because
I'm
there is
arguing.
no jury instruction for jury nullification,
Yeah, I'm
sir,
not- I'm
because
not-
it's not allowed.
I'm not attempting to give them a new jury instruction. I'm merely attempting to inform them of the power that they have.
Mr.
That's not
Brooks,
against the law.
I'm advising you one more time. You may not raise the issue of jury nullification
I'm going
before
to
this
inform
jury.
them of the power that they have. I'm not
You are
giving them.
telling me
I'm
that
not
you
giving
are
them a jury
insisting
instruction.
on telling them about jury nullification. That's
That's-
what I hear you saying.
That's not what I said, though. Don't mischaracterize what I'm saying. You just read and said that they have the power. They have the power to do that. So how is
It's an
informing them?
inherent power that they have. They are not to be instructed on it. That is very clear in the law. In
Your
addition to, no, let me finish. In addition to the case that I just cited, I'd cite to you from the jury instructions, the law note on jury nullification 705. What that says, sirs, I'm not going to read it all. It's many, many pages. But the bottom line is, it is improper for a court to allow a defendant or a defense attorney to make an argument or make the jury aware that they have the power to nullify a verdict.
And Your Honor, you just added this last night. That's why I had to sit there for an hour in the holding cell and wait for you to change the whole paperwork, because I brought that up. So you never intended for this to even be an issue.
Mr.
It
Brooks,
never was brought up.
if you
But
think
then
I
when
wasn't-
I raised the issue,
If you
Your Honor, let
think
me
that
finish.
I'm not prepared to deal with and argue on jury
I
nullification,
didn't say,
then you
that's not what I said. That's
You are
not what I
missing the
said. In
mark.
all fairness, that's not what I said.
The record should accurately reflect that you were kept in that holding cell.
Why was I kept
so
in there?
that my clerk could finish
Adding a
the
jury instruction that was not there.
76 verdict forms, and it's ×2 because there's a guilty and a not guilty
Okay.
for each. No, let me finish.
So
or
how
you've
did
interrupted
so how did
me
I have why did I
repeatedly.
have to sit here for that where I could have just went to my cell and had it delivered? We had this
Mr.
at the end
Brooks.
of last night before you called recess.
I'm not going to debate
we had a
that
whole
topic with
we
you
had a whole
further.
conversation about
Mr. Brooks, you
me
are
bringing up about the jury
defiantly
nullification.
disregarding this court. You
Here we go
can
with this.
roll your eyes
Here
at
we-
me
because
all
it's,
you want.
it's ridiculous, Your Honor. You just stated that they have the power to nullify
Would you
any
like,
law,
if you would like,
but then
I
I
will
said
read this to you, sir, the part of the case that's important, but you're not letting me get a word in edgewise. I'm trying my best not to remove you to the other courtroom, but that is oftentimes what I need to do in order for this court to make a full record without you interrupting me. But you need to be fully aware that you may not raise the issue of jury nullification in front of this jury. It is not an allowable argument or an advisement or making them aware. However you want to describe that, sir, whatever verbiage you want to put in front of it, you may not do so. And this court has the power and the authority to limit what you say to this jury, even in a closing argument. And if you're telling me through your conduct, through your words, that you are going to disregard that direction, you will forfeit your right to present a closing argument.
under what lawful law?
Under State versus Anthony.
It doesn't refer to that.
State versus Anthony
it
may
doesn't.
not have dealt with
It hasn't dealt with
the
closing
right
arguments.
to a closing argument, sir, but the reasoning
You just said it right there.
nonetheless is
No.
fully applicable.
No, you
because the more
can't. You can't
general
change the law, Your
principle-
Honor. You can't change the law. That's
I'm not
practicing law
changing
from the
the law,
bench.
sir, but the general principle.
I know you used to be in legislation, but you can't practice law from the bench.
Sir, I'm
You
not
can't do
practicing
that.
law from the bench.
You are if you're changing. Your Honor,
I'm not
you're
making-
attempting to make a separate case pertain to something here that doesn't even pertain to it. It has nothing to do with a closing argument. Nothing that you just
So,
named. Not
Mr.
Illinois
Brooks,
versus
I
Allen.
would like to make a record. Would you please show the courtesy and respect for
I
me
will,
to
Your
do
Honor.
that?
I will.
All right. So looking at the Anthony case, all right, and that case starting at head note 7, paragraph 54 says the following, and you need to let me get all the way through it. We have recognized two distinct ways in which a defendant may give up his rights, waiver and forfeiture. State versus Pino is the first citation that they reference. Waiver is the intentional relinquishment or abandonment of a known right. Multiple citations there, I won't repeat them all. Waiver typically applies to those rights so important to the administration of a fair trial that mere inaction on the part of a litigant is not sufficient to demonstrate that a party intended to forego that right. State versus Soto. Forfeiture, on the other hand, often involves the failure to make the timely assertion of a right. That's a cite to the Dino case and Olano. Rights that are subject to forfeiture are typically those whose relinquishment will not necessarily deprive a party of a fair trial and whose protection is best left to the immediacy of the trial, such as when a party fails to raise an evidentiary objection. However, there is a second aspect of forfeiture, doing something incompatible with the assertion of a right. State versus Vaughn, 2012 Wisconsin Appellate 129, citing Illinois versus Allen, 397 U.S. 337. They went on, the court, that is the Wisconsin Supreme Court in Anthony. As previously noted, we have held that the right to testify is subject to waiver, not forfeiture, insofar as a defendant's inaction in asserting the right is concerned. We now conclude that the right to testify may, in appropriate cases, be subject to forfeiture where conduct incompatible with the assertion of the right is at issue. They go on to discuss Allen, which was not a right to testify, but was a right to be present. And I am utilizing the guidance from Illinois versus Allen and State versus Anthony. It directly guides this court that a defendant may forfeit a right by conduct by doing something incompatible with the assertion of a right. In this particular case, you are very clearly telling me you are going to disregard what I told you about notifying the jury about nullification. You have absolutely no right to raise that in front of the jury. It is improper. And unless you're willing to tell me you will honor this ruling of mine, then you will forfeit your right to present a closing argument. That is my ruling.
I object to that ruling, Your Honor. I object to that ruling.
Are you willing to make a closing argument, sir, that does not reference jury nullification?
I'm going to inform the jury of their power. Again, I never stated that I was making a new jury instruction. I never stated anything like that. And every case law that you just stated made no reference to closing arguments. It was all pertaining to being present for the proceedings of trial and for testifying.
Sir,
Not
what I'm
one time
telling
did you, hold on, I'll let, Your Honor, with all due respect, I'll let you make your record. I didn't interrupt you.
Go ahead.
Not one case law that you just cited made any reference whatsoever to a closing argument. Not one. So how is me merely informing the jury of the power and the rights that they have, how is that a forfeiture of being able to give a closing argument?
Well, in addition to the cases I just cited, sir, I'd also point you to State versus Bajirkas, 163 Wisconsin 2nd at 549. That's a Court of Appeals case from 1991. That is the first published appellate decision in Wisconsin to consider directly several issues relating to the jury nullification issue. In that particular case, the court very clearly said that the defense counsel in that case was allowed to talk in terms of fairness in general terms, but not to go further, and could not argue that the jury, quote, should disregard the instructions and the law and find her not guilty because it seems fair. That's a description of jury nullification. To use the words jury nullification would run afoul even more. And so I am telling you that given my inherent authority in controlling the mode and order of this court to ensure courtesy, decorum, and civility, and to ensure that this jury is presented with arguments that are proper under the law, I am hereby telling you I am in creating a rule for your closing argument that you may not raise the issue of jury nullification in any way.
Your Honor, hold up now. I'm the only one that has to be made rules for closing arguments, but not the prosecution. How is that fair? How is that balanced?
Mr. Brooks, I'm squarely faced with your defiance regarding the issue of jury nullification.
It's
that
not
is
defiance.
requiring
It's
me
not defiance.
to address this issue and to tell you very
Honor,
expressly
I
that that is the
vehemently-
rule
I
for
vehemently
your
object to
closing
that.
argument.
Vehemently object to that.
Your objection is noted for the record, but
May
my
I ask
rule
for a legal
nonetheless
reconsideration of your
stands.
ruling?
That request is denied.
May I respectfully ask for, matter of fact, I reject that ruling and take exception to that ruling. For the record, may I request a legal or factual basis for your ruling? Not one pertaining to being present in the courtroom or testifying. One that specifically talks about a closing argument.
All of those requests are noted and will not reconsider. I've put my findings and my reasoning on the record, and I stand by that record.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law?
Denied.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter?
I'm not the forum for which an appeal would be sought, sir. I cannot
Well,
answer that.
You referred to it before.
You would need
So
to
now I'm
direct your
confused.
appeal to
I'm confused, Your
to
Honor,
a court of
because-
appeals, not this court.
No, this is, I'm supposed to be in this admiralty court. because you haven't, if we're under Article 3, then we should be in common law court. That hasn't even been addressed, if we're in a common law court or an admiralty court.
That's a baseless argument, sir. I don't even
And
need to
what law
address
and
it.
fact? Based on what law and fact?
It's meritless.
Based on what law and fact?
Sir, I intend to bring this jury out and give you
I'm
an
informed. I'm
opportunity
informed of that.
to present a closing argument.
Yeah,
If
but
you
you're
violate,
also,
please let me,
but
sir,
listen,
you're
you just
interrupting me
made a
yet
rule.
again.
You just tried to put me under a rule that no one else was put under.
The circumstances require that I implement this rule, sir, given your
The
stubborn
circumstances
defiance
don't.
on
Your
the
Honor,
issue
that's a
of jury
prejudice to my
nullification.
defense. You can't place me under certain rules and not place the prosecution under the same rules.
Sir, the
It has to
circumstances
be
of
fair.
this case and your insistence on arguing jury nullification has resulted in this
haven't-
court creating this
I
rule.
haven't argued it. I said that I wanted to inform the jury of their power. I never once said I'm going to make an argument. I'm going to give them a jury instruction.
You may not
never
advise
said
them
that.
or make them aware in any way that they have the power
And why
of
not?
jury
Why can't they be
nullification.
informed of their power?
Because it would violate the Bajorkas decision, sir.
Violate what decision?
All right, sir, I am going to bring the jury out.
And I'm going to inform them that they have the power.
And if you do that, I will dismiss the jury and I will declare that your right to present
You
a
can't do
closing
that.
argument
Under what
has
lawful
been
law?
forfeited based upon
Then I make a
how I've
oral,
outlined that
motion
today.
for a
I'm
legal
not going to
finding of
declare that
fact.
at this point because I want to see what you will do. But if you raise the issue of jury nullification, I will immediately dismiss the jury. You will forfeit your right
You can't do
to present a closing
Under what
argument.
lawful law can you,
And then if you continue to
under
interrupt
what
me,
lawful law,
you will be removed to the other courtroom as I
so I'm
complete
being
the
held in contempt
instructions.
again? Is it civil or criminal?
Your
All
Honor,
right. Go ahead.
I apologize. May I ask the court to consider perhaps an alternative, and I fully respect the ruling the court has just made, and I understand the basis for it. We all know the defendant, in his petulance, will say jury nullification in the first 3 seconds the jury's in the room.
Objection
The-
to that.
Proper
I don't
thing
think
to
that
do,
I
I
should be
think,
talked
Your
down
Honor.
Stop
to.
interrupting,
I don't
Attorney
think I
Opper,
should be
please.
talked down to.
Allow him to make his closing arguments. I will object if he misstates the law. You can instruct the jury to disregard any misstatements of the law. And we continue in that fashion, if possible, for a reasonable amount of time. And if it becomes to the point where there's no reasonable, legal, credible argument that's being made, then the court can decide as to whether or not he's forfeited his right to a closing argument. But we could at least try to, by merely objecting and the court telling the jury to disregard and instructing Mr. Brooks to move on to the next topic, we could try to allow him his opportunity to provide a closing argument. If that's unworkable, then I think this record will be very clear as to the efforts of this court. And I think there is materials in the bench book, or I'm sorry, the jury instruction 705 that talk about a jury instruction this court could even give, telling the jury that they are not at liberty to disregard the law, but we're not going that far yet because, frankly, you have told them and you will tell them that closing arguments are not evidence. And I think they will abide by that. So I know it's going to require effort for the court to allow this to allow Mr. Brooks to try and proceed, but I think we should try that or something similar to that in an effort to get through this next step, or else we will continue at this pace forever.
I'm sorry. I just had to stop right here and laugh because Sue Upper is being like, I I'm sorry. I can't help it. It just makes me laugh. It makes me giggle. Because Sue's like, you know what? Let's just do this. And if it doesn't work, it doesn't work. Yay,
I'm certainly
Margaret.
willing to try that.
I'm glad you didn't get stuck under the treadmill.
It's about all we could come up with, Your Honor.
And I'm certainly willing to try it in this courtroom, and then if he disregards that, to excuse the jury and then have him present from the other courtroom would be the second step, and then third would be a forfeiture.
Agreed.
Your Honor, I object to that.
Of course you do.
Your objection is noted for the record. That will be the course of action that this court takes. The first time you violate the rule, you may be subject to forfeiting your right to be present, where you will give the closing argument from the other courtroom. And if you continue in a blatant disregard of the requirement that you not reference in any way jury nullification, I may make that final determination outside the presence of the jury.
I object to that, Your Honor.
All right, with that, let's bring the jury
For the
out.
record, may I respectfully request the legal reconsideration of your ruling? So is that a tacit agreement that you don't have to answer my objection, Your Honor?
Just one time I want to hear her say nope.
I decline to reconsider.
I reject that ruling and take exception to that ruling, Your Honor.
Noted for the record.
For the record, may I request a legal or factual basis for your ruling, Your Honor?
Denied.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law on this issue, Your Honor?
He's
Denied.
like a bad
For the
toothache.
record, may I respectfully move for interlocutory declaratory appeal on this matter?
I'm not the court to address that.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction, which this court has no subject matter jurisdiction.
Denied.
Under,
The jury's
based on
coming
what law
in.
or
All eyes
fact?
for the jury, please.
Based on what law or fact? Because I'm going to inform the jury of their power. They deserve to know.
What power? Power of the babe. What babe? The babe with power.
Thank you, everyone. Please be seated.
Morgana.
Go ahead, Mr. Brooks, your closing argument, please.
Good afternoon. It's been a long day. First off, I'd just like to start by letting you guys know that it's a lot of information that you guys should be privy to, I believe. And one thing that I believe that you have not been privy to is the truth of your rights and your duties,
Here we go.
being the jury. The fact that you and you alone have the power. Not well-prepared DAs with well-prepared and clearly rehearsed speeches and exhibits and a lot of theatrics. Frankly, not the judge. You and you alone have the power. You and you alone decide what is truth and what isn't truth.
Truth.
You should be informed that
Look at Sue.
you have the power to nullify any law that you don't agree with.
Objection, move to strike the statement.
Sustained.
Objection.
I will strike from the record the last statement made by the defendant. The jury
Which
will
is-
disregard it.
Which is clearly what I've been saying. I believe that not only is it fair, but it's essential that you be privy to all knowledge, not knowledge that certain people feel that you should hear and shouldn't hear, disguised under the color of law.
Okay, so if we want to have that knowledge, then what about the knowledge that you tried to run Erica over before all this happened? How about that? How about that? If you want him to know all the truth.
The fact of the matter is, just like I did with my opening statements, I don't have a well-prepared or rehearsed speech. I didn't look in the mirror and say certain points to myself over and over again to make sure I have them right or anything like that. I've chosen to speak from the heart in my opening statements, and now I'm going to speak from the heart.
And that whole thing with Erica is part of the whole prior bad acts stuff that they've been keeping, you know, behind that door that he's been trying to open, but don't want to open. But he's was gonna open, you know, all that stuff.
What you won't hear me do is argue facts. And the reason you won't hear me argue facts is because I believe that it takes away from what should be recognized. The tragedy of this event. It should be recognized. Trying to argue facts of this, facts of that, I'm not gonna waste your time doing that.
Go tell it on the mountain, over the hills.
It's a little emotional.
Everywhere.
I apologize for the long pause.
Well, now he's getting ready to start crying.
It's hard to keep everything together emotionally. And honestly, I don't believe that I have any more tears left. It's been a hard year.
Sorry.
For the families, mostly. And that should not be lost on anyone. It shouldn't be taken away. I said it before and I'll say it again. It's a lot of people that are healing, that are attempting to heal. That opens the door to talk about forgiveness for a little bit. With every healing process, there comes a forgiving process. It's not an easy thing for anyone. What you've been hearing from the prosecution, and not to take anything away from them, but let's call it what it is. You've been hearing a lot of rerunning. Same things over and over and over. No different than when you turn on the radio and you first hear that song that you don't like when you first hear it, but they play it so much that eventually you start saying the words to yourself before you even realize it. And then you sit and you go, I hate that song. Why am I singing it? That's what's been happening. Rerun over and over and over and over and over and over and over. Attempting to make things stick in your head that simply aren't true. Why do I say? What am I saying? I say, look at the testimony. You know, the thing from the prosecution here has been intent, 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 intent. We all know what's been said. We all know the picture that's been painted. Even the prosecution said themselves. How can you look in somebody's head and say, this is what they intended to do? You know, for a year, I've sat and gone through this, feeling so powerless. You know, letting other people run with the narratives. Sitting back helpless while other people paint a picture that has zero truth. Zero. I understand about healing myself, tragedy, pain, all that. A lot of it there's no need to get into. I myself in my own life have had to do a lot of healing. As a man with children myself, I find it hard to believe that anyone who's really had conversations with me, spent time around me, would think for 1 second.
Question, is the 1.5 too fast, or can you guys understand him? Just checking. It's almost, well, it's after 8 o'clock, so I just want to sketch through it. Let me know if 1.5 is too fast for you. If it is, I can drop it back down to 1.25.
That this is an intentional act. I've never heard of someone intentionally trying to hurt someone while attempting to blow their horn. While attempting to alert people of their presence. Which brings me to more information that I believe that you should have been privy to. And I'm sure that the prosecution will beg to differ, but the fact of the matter is, the vehicle in question, make and model of 2010, Ford Escape. The vehicle in question, actually 2008, 2009, and 2010 of that model was in fact recalled.
Objection, misstatement of the facts, facts not in evidence.
Was in fact-
For argument, Your Honor.
It's the same.
Was in fact recalled. Was in fact a class action lawsuit against Ford
Objection,
for those
facts not in
models,
evidence,
for
Your
those
Honor.
model vehicles.
It's the same. The jury will disregard.
Information that you should have been privy to, that you weren't allowed to be privy to. Why? I don't know. That information, malfunctioning throttle bodies,
Mr. Brooks, move on.
it's information that you should have been privy to. Vehicles that malfunction and accelerate, not being able to be stopped.
Objection, that is.
It's information,
completely
it's
inaccurate, Your Honor.
information.
Hold on. Go ahead.
Move to strike statements by.
Sorry
Mr.
for the
Brooks.
interruption.
Facts not in evidence, Your Honor, and it's complete misstatement.
It's the same.
How's it a misstatement when I have the information?
Mr. Brooks, move on.
This is information that I feel like you needed to know. You should have known. Information that was taken away from you. Why? To prove a case? Information that you definitely should have been privy to. The DA says the defendant has an utter disregard for human life. Utter disregard for human life. Not realizing that they're talking about someone that has children. Talking about someone that watched their children come out of the womb and be born into this world, cut the umbilical cord, held them before their mom even did. Moments that I'll never forget. And yet they say disregard, utter disregard for human life. They made reference to a rage. As if they were, or if this particular DA was right there, standing right there. As if this DA is a psychiatrist. I say to myself, what rage? What do you mean rage? How can you characterize that? How can you have the audacity to diagnose what someone's brain is? Where it's at, what it's thinking, why it thinks the way it does? DA makes references to blocks of no one being injured, but then says it's intentional. You add that up with the supposed rage the supposed intent to harm and kill. And it doesn't kick in until well within blocks. And maybe it's just me, but I would think if I was characterizing someone with this intent to kill and this rage and this anger, then why weren't people immediately harmed? Why would someone with intent to kill and rage try to alert people of their presence, repeatedly honk their horn? You heard a detective, if you recall, testify that the vehicle that he observed was not only honking his horn, but was not speeding. So where does this rage kick in? Where does this insatiable intent to kill kick in? They speak as someone who's known someone for years. Which brings me back to the vehicle. What if the vehicle couldn't stop because of the malfunction?
Objection, fact, not in evidence.
What if the driver of the vehicle was unable to stop the vehicle? Because of that fact, what if the driver may have panicked? Does that make the driver a crazed, or not crazed, a rage? Does that make the driver in a rage and intent on killing people? DA played to Exhibit 17. You don't see anyone struck in that vehicle. On that exhibit, you don't see anyone struck. With someone who had this intent to kill, this rage, as she says. If that was their intent, would they have taken the opportunity to hit as many people as they could? Target people, mow down people? Reference was made to this vehicle, the damage. Says this was all caused by bodies, but then later turns around and says hits barricades and other objects. You've heard testimony about hearing loud crashes and things of that nature, but the DA wants you to believe that this all came from people. Evidence doesn't support that. So I go back to trying to wrap my head around everything that's happened in the last year. Praying for those families, praying for the people that tragically lost their life, because that should not be lost either. The fact that there was lives lost, and all the emphasis has been put on the alleged defendant, and the people have been disregarded. Makes me wonder, does the DA even care about those people? There's been prayers going up every day.
Oh, look at her face.
It's been suffering on both sides. It's been threats, hate mail. Because of the narratives that's been put out there. The misconceptions that have been put out there. The lies that have been put out there. Lies that have caused my children not to be able to go to school, to be bullied, for my mother to have to leave her home and stay at a hotel because she's afraid for her safety, because she gets hate mail shoved through her mailbox. My nieces and nephews to fear for their safety. And what's been equally hard is not only having to answer the questions from my daughter, who was 7 at the time, my baby girl, who was 7 at the time, is now 8, attempting to answer her questions that she's asking, and still continue to shield her from what she sees, what she hears. having a newborn son that I haven't even been able to meet. I haven't been able to hold, touch, kiss. Having to navigate everything that comes with this whole situation.
You know, something else I just thought of. I mean, I remember thinking this before, but it like skipped in my mind for a minute. Is he just said his baby girl was 7, just turned 8, and little Jackson Sparks was 8 years old. So, I mean, you'd have to put me in a hole if I would. I mean, I'm going with, if I had hit anyone, God forbid, right? Let alone, I'm not even going to say the words. Not even going to say the words. But if I were in his situation, if I were in his shoes, you'd have to put me in a hole. I would be done. I'd be like, no, I'm out. Bye. And then the thought that he has a child the same age as the child that died. I just can't.
I'm still attempting to wrap my head around it. I can't honestly say how many times I've sat in my cell, especially during lights out, alone, where it's just you. And just been praying and asking myself, how could this happen? Not just for the people, but for everybody involved, the community too. How could this happen? How? The hardest questions you can ask is those that don't have an answer. No matter how much thinking you do, no matter how much you try to look at it from different perspectives and listen to other outside perspectives and listen to people that you trust and that you love, still coming up with nothing. But to think for 1 second, one question I never had to ask was if this was intentional. That's something that I never asked once. Because I know it wasn't. As a matter of fact, it never even crossed my mind to even attempt to ask myself that, because I know it wasn't. And I know sometimes during this trial probably doesn't show. Maybe hard to believe. But trust me when I say no one outside of the families that had to go through this, no one's heart is more in pieces than mine. So again, I go back to all these exhibits. Go back to everything that's been shown, everything that's been testified to. Everything you've heard during this whole process, this trial. And again, I say the same thing that I said earlier. Same thing I said in opening statements. I'm not reading from any paper, any books. Everything you've heard in opening statements, everything you're hearing now is from right here. Everything. You have the decision. You and you alone. All of you. You have the decision. I'm sure you've taken a lot of notes during this process. Some days are longer than others. A lot of movement in and out of the courtroom for various reasons. Remember the power that you have. Don't for 1 second let it be taken away from you. I can never understand the position of sitting on a jury in something of this magnitude, so I'm sure there's a lot of pressure. I pray that the right decision is made. The right decision. It's almost like that message. Well, not message, but that writing. When we're in our vehicles and we got that rearview mirror and it said things are closer than they appear. But it's also another way of saying sometimes things aren't as they appear. I can't speak for anyone else, but me, myself, I believe in Jesus Christ. That's how I was raised. That's what I believe in. None of us are perfect. But I try every day to make sure that I acknowledge him. That's why every time I step in this courtroom, I have my Bible with me everywhere I go. I even read it on breaks, recesses. This is not something that started at the beginning of this incident. This is something that has been instilled in me since I came out of the womb. This is how my family lives their life. This is how we was raised.
Dude, you know, I get it. I believe in Jesus Christ too. He's my, Lord and Savior. I'm glad that you believe in him, and I'm glad that whatever, but that does not absolve you from paying your dues. You know? Sorry, I'm eating dinner now. Husband made French toast and sausage. We're having a breakfast for dinner tonight. Anyway, I just wanted to say that. I think that I don't know. I don't know. Part of me wants to say, if you want to admit your faith in God, okay, but why not admit that what you did was go through that crowd of people? Because you've just now started saying it wasn't intentional and blah, 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 blah. And So you're going to say that in your closing after you spent 25% of your time trying to get the witnesses, trying to get it to say and to get it across to the jury that may not have been you driving that car. I'm sorry. No, he hasn't started
Whatever
crying yet,
mistakes
Margaret.
that I myself have made in my life, I've made peace with God. Made peace.
He's getting ready to.
I'm happy to say that my conscience is clear.
That don't
Because
tell
I
me
believe
nothing.
I trust him with my life.
Because if your conscience were clear, if you even had a conscience, you would be very remorseful, and you have zero remorse. The tears that you're crying right now are because you know the show's over. Your day in court is done.
Nobody will never know why it was his will for this to happen.
Wait, did he just say it was God's?
A lot of lies.
Wait, what? Wait a minute.
We changed that day, mine included. God's way is not our own. And no matter how much sometimes we want to question, we have to have faith. Look inside yourself. Look inside yourself and make the right decision. Look inside your heart. You have everything in your hands now.
Well, isn't that a little bit hypocritical? Isn't that a little bit hypocritical? Because a minute ago, it was God's will. You know, sometimes we don't know why God's will is the way it is. Because God has the power, right? Basically is what he's saying. But now that it's his life in the balance, the power is in the jury's hands, not God's. Okay. Understood.
Everything. Do what's right.
Do what's right. They do. They did. They did. Oh, honey, they did.
Do what's right.
They did. They did.
Don't let the smoke and mirrors take away your power. Don't let the theatrics take away your power. Each and every one of you has a decision. Who's right?
make the right decision.
They did.
It's hard to think about. My younger kids getting older and at some point having to explain everything to them.
Maybe you should
Kids
have
don't
thought
stay
about
kids
that.
forever. And nowadays, kids is frankly a lot smarter than we were when we was kids. I'll tell you that much. I got a letter the other day. My youngest daughter. And she's still learning cursive right now, so she's the best writer when it comes to cursive. She'd rather print. She said, Dad, and this is from the letter. She said, Dad, why are people saying all these mean things about you? I haven't read the rest of that letter yet.
You ain't read it because you probably didn't get one, liar.
The rest of that sentence said, that's not the dad I know. Throughout this year, I've been called a lot of things. And to be fair, I am a lot of things. A murderer is not one of them. Never has been, never will be.
You're a 6-time murderer. Right, Margaret?
So before I close my statements, I just want to say, open your hearts. Go inside yourself when making this decision. Have no fear. Pray and do what you know is right.
They did. They did.
What you know is right.
Margaret, and you know what? They're thinking that right in the middle of him talking. Right now, they're thinking, I think I want to get a club sandwich with a Diet Coke. Yeah, that's what I want. And a pickle on the side. You know it? Where's that? That's why my stomach's growling, man. I'm hungry. God, I wish you'd hurry up, shut up, and let's go.
Think about everything you've heard. Think about everything you haven't been privileged to hear.
Mm-hmm. Don't slap the pickle.
Think about the whole entire picture.
By the way, my French toast and sausage was really good. The sausage was a little spicy, but it was good.
Came above
Very, very
everything.
good. Mm-hmm.
Whatever you decide, make sure you yourself can live with it.
Mm.
Make sure you can live with it.
I'm sure they sleep
That's
very
the magnitude
well
of the
at
power
night.
that you have.
To be honest, I'm sure they sleep very well.
Just like this tissue is in my hand, this is everything. You have everything.
That's a spicy meatball.
Be at peace with what you decide.
Right, Margaret?
Have no regrets.
All right, Darrell Brooks, I had enough of your mouth. Come on.
Don't let this decision weigh on you after it's over.
Don't let the door hit you where the good Lord split you.
Hopefully we got a lot of living ahead of us.
I wouldn't wish that if I were
Lord
you.
willing.
I wouldn't wish that if I were you.
Don't look back and kick yourself in the behind.
Yeah, Cherie, that's why I'm like sniffing.
About 3 weeks with you. And
Sorry, that was gross.
took a lot of courage and a lot of guts to pause your life race,
My nose is running more than his is.
to put important things on hold, to basically stop your life. You should be commended for being able to sit up here with this amount of pressure. I want you guys to know that's not lost on me. I'm sure it's a lot.
Probably not.
And you all should be commended because it took courage to do this. I don't know, but I would bet a lot of people wouldn't want to be sitting in your position right now. And
I
you
mean,
guys have
it's
the guts to do it.
it's 100% for me. I don't know about anybody else, but
Thank you for that. Thank you for taking pretty much a month and setting it to the side for this.
they've known for a
I
month
know
that
it's
you were
probably
going
not
to be
proper,
found
but
guilty.
you guys deserve a round of applause if you could get one.
They get one. I give them a round of applause for what they did. I'm sorry, I'm being super
Thank you guys
snarky
sincerely.
right now.
And I know, and I have faith and I trust that you guys know what's right. Ladies and gentlemen, I don't think it's fair to just say guys, but
Right, dog mom. No pressure at
I
all.
believe in your heart you know what's right.
They do. I'm super snarky, man.
Thank you, sir. Before I give the state an opportunity to present rebuttal, please stand for a minute. So please stand.
Oh, now he's going to sit there and...
All right, have a seat, please. And Attorney Alperay, did time both closings. You have 13:28 left.
Thank you, Judge. I don't think that'll be an issue. Folks, let me just say this. Mr. Brooks stands here and professes to speak to you from his heart. He plays on your sympathy. He talks about his children. He talks about the hardships that he's encountered and his family's encountered. And he brushes over the loss to the community. He wants to talk about how he's never held his newborn son. Never once acknowledges the Sorensen family, the Owen family, the Duran family, the Hospital family, the Kulik family, the Sparks family. Never once. It's nice that Mr. Brooks can get letters from his loved ones. I don't know why he did this. I told you that. But actions define a person. It's that simple. You can stand with the Bible in your hands all day long and profess to be the finest man under God that you can be. But when you drive through a parade route and roll over children with band instruments to the extent that your vehicle heaves up and down, Your intent is known, Mr. Brooks. It doesn't have to be guessed. It's known. You don't have to stand and wonder as he claims to. For him to keep going after he drove over those children in the band and have Jackson Sparks fly off the front hood of his car, lifeless, and keep going. And have Jane Kulik fly off the hood of his car, run her over, and keep going. I'm not going to go on. You get it. You need to look in the mirror, Mr. Brooks. If you want to accuse me of practicing my closing argument, you need to look in the mirror, sir. Your actions are that of a murderer. You murdered these 6 people. You endangered the safety of 61 others. There are 68 victims in this case, folks. That's not an accident. That's not a, gee, I woke up one day and don't know how I found myself in this position. If you have some explaining to do to your children, Mr. Brooks, I recommend you do it.
Objection.
Now, members of the jury, the duties of the parties and the court have been performed. The case has been argued by the parties.
That's it. He says objection.
I recommend you do it.
Objection.
Objection. Look at his face. Now, what happened to all the sad boo-hooey he had 2 seconds ago? Now he's mad again.
Now, members of the jury.
And the judge doesn't even acknowledge his objection. She says, now jury. Now jury.
The duties of the parties and the court have been performed. The case has been argued by the parties. The court has instructed you regarding the rules of law which should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors, selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and as upright citizens to render a just and true verdict. You are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. The following 76 forms of verdict will be submitted to you concerning the charges against the defendant, Darrell E. Brooks. Count 1. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count 1 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 1 of the information.
He big mad.
If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide as charged in count 5 of the information?
So I think she's going to read through the whole, you know, read through all the, I think she reads through all the counts. I'm sure she does. That guy back there looks like he's asleep.
Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 34. One
Now
reading.
she's on
we
count
the jury
34.
Safety as charged in count 55 of the information. I am pulling out.
Now, this is where they do the alternate
30.
jurors.
And the third number I am pulling out is 1. I want to confirm that I still have 12. I know Madam Clerk did it, but I will also do.
He's like, make sure that this is legitimate.
And then do you swear that you will keep all jurors on this trial together and self any person? All right, and just to have all the finalized, all of the verdict forms. well. It's 6:20. The jury instructions as well. For the record, it's 6:24. All rise for the jury as they're excused to begin their deliberations.
You nervous there, Brooksy? You look nervous, Brooksy. Nervous.
But yeah, I'm gonna meet all of them and then I'll take them down and but those are the yeah.
You seem awful nervous.
All right. Participating in the deliberations, they will be in a separate jury deliberation room, and will only be called upon if needed, of course, after consultation with the party. Ordered dinner for them. I believe it will be here shortly, and I really will leave it up to them as to how late they want to deliberate before they would want a break and then to retire for the evening. They are under a sequestration order, so they will be kept separate and apart. Their electronics have been confiscated, and they will not be going home until verdicts have been reached or they are discharged from the court, whichever would occur sooner. Anything else the parties would want me to address at this moment on the state?
Thank you, Judge.
Anything from you, sir?
Yep. So essentially, I'm gonna have to stay here while you're delivering. I'm gonna be able to go back to my unit, use the phone, shower. It is shower day for my body. I get 2 shower days.
I don't, so here's what could happen though, sir. I don't have a problem with you doing that, but they could have questions. And then you would need to become available so we could address any questions. They may ask for exhibits, things of that nature. So as long as you're willing to come back for those things, I don't have an issue if, you know, I probably should talk to the COs or at least the sheriff and make sure I'm not stepping on their toes since they're in charge of all of that. But it's possible that we get a request for exhibits, some exhibits initially. I wouldn't be surprised if we got that. I don't think we do this.
I was curious. 61 charges for the reckless. 61 injured parties did not testify. So how does that work? How
God.
Essentially, how are charges able to be charged if all the injured parties did not testify?
From my perspective, sir, the state presented their theory of the case, and there was sufficient evidence regarding the charges to go forward to the jury. I can't further explain it from there because that would require me to explain the law, and I guess that's all I can really say about it at this point.
I got a point though.
I'm sorry?
I got a point though.
I'm not going to comment on that, sir. Of course, the state bears the burden of proof, and they have to convince a jury beyond a reasonable doubt. For better or for worse, sir, I was not presented with any motions to dismiss, either at the end of the state's case or the close of the evidence, regarding any legal arguments you may have had regarding those issues. And so at this point, the jury has the case, and they will determine their verdicts. If there are issues of law that you want to raise after the verdicts are received, then you'll have to make that determination.
Yeah, that has to be raised because essentially you can't, if no injured party testifies, then it shouldn't be a charge.
I disagree with that characterization, sir, but there is frankly no motion in front of me based in law or fact, so for me to comment any further would require me to give an advisory opinion, which I'm not willing to do.
So you're saying I need to make a motion?
So what I will say at this point is I do have one issue that I would like to raise with the parties. I frankly I need a break a little bit. I mean, obviously the court has to stay open. I know my dinner is coming, and I think it's reasonable. I need to put a few things together, but I do need to make a record of some information that I received earlier today, so that the parties are advised of that. But I will do that. Let me confer with the Sheriff's Department about your requests. I'd like to take in about 30 minutes, address the issues that I need to address, or the issue. And I want to find out if that would interfere with your request about taking a shower and all of that. So if you can hold tight and stay with us for a little bit, that would be great. And I'll confer with the Sheriff's Department and have a more definitive answer for you shortly, okay?
Can I get my filings?
You want the We
I don't
have-
remember
you
what
want the original
information
facts.
she had.
If
Do
Madam
you
Clerk has
guys?
scanned them all in and they're uploaded,
I don't remember what information she had that she wanted to bring to the court to the put on the record. Do you? I don't remember what that is.
I don't have an issue giving you the originals back. Unless, so you're getting 2 copies. Still have that, okay?
See, I didn't interrupt you. See,
I'm sorry.
I said, see, I didn't interrupt you.
Thank you, I appreciate that. Unless there's,
See, I didn't interrupt. Yay.
I would like the parties back in about half an hour.
Weirdo.
Thank you, unless they have a question sooner.
Your Honor, do I have to go in that holding cell or do I get to go?
Why is he being so cutesy now that it's over? Like, I don't get that. Why do you want to kiss her butt now that it's over? What in the world? It's the weirdest thing. So let's go. Here we're back on the record.
Need my court reporter? So I wanted to, I need my court reporter. I'll wait for her.
Yeah, that was weird and gross, right? Ugh.
Thank you. All right, it's 7:05. We're back on the record. I wanted to advise the parties that earlier today I received information from the clerk of court that she had received an email that the person sending the email had found a post on Justice for Darrell on Reddit, so it's a subreddit. I'm not familiar with how Reddit works, but and that the thread on the Justice for Darrell Reddit site was claiming to be a member of the jury pool. And I am going to provide the parties with the information that I was given this morning. It's a color copy of the attachment and the email that was sent. The email was received by the clerk of court at 9:10 a.m. Then my clerk received a notification at 9:30 a.m. that the clerk of court wanted to speak with me. You may recall this morning I stepped off the bench for a little bit of time. I read through the information that was provided to me, which was an email, and then the attachment, which is a color print off. Looks like the person took a screenshot, in that the anonymous post claimed to be a member of the jury on the case, and here are my thoughts on the trial and on this subreddit. And apparently, again, it's a subreddit called Justice for Darrell. All those, Justice, the number 4, and Darrell, all, no spaces. I then had contact with Captain Dussault, advised him that this should be investigated, and basically turned over the matter to law enforcement for a full investigation. At this point, or at that point, I made a determination based upon my review of the information that I would not stop what was happening in terms of the trial with the instructions to the jury and ultimately the closing arguments, and then turning the case over to the jury for deliberations. And of course, I am concerned about the integrity of these proceedings, and I will take whatever action that I deem appropriate once a full investigation is done. But at this point, there is no, I would say, credible information that this is in fact a member of the jury. But I will leave that for law enforcement to determine, and if, of course, if need be, at the conclusion of the case, when the jury reaches a verdict, I certainly will consider whether any questioning of the jurors at that point is warranted. So that's the information I wanted to provide. Again, copies of this information will be provided to the parties, and there is a full investigation underway by the Sheriff's Department. I have no further information about it at this time. I will not be the judge that will further be reviewing it in terms of any requests related to that investigation. I will simply be handling whether any requests as relates to this case in particular. And I hope we have the copies for the parties. And we'll provide those. Go ahead.
I'll make sure you was.
Go ahead.
First. What is this?
All I can tell you, sir, is that there is apparently on the internet, on a site, or maybe it's an application, I'm not entirely sure, called Reddit. There's a subreddit that is entitled Justice for Darrell, and it was on that subreddit that someone wrote an anonymous post claiming to be one of the jurors. That, of course, would be a violation of the rules that I set up for the jurors, which is why I turned over the information to law enforcement so they could make a full and complete investigation.
For the record, I accept for value in return for value these documents. I'm confused.
At this point, sir, I'm providing the information. I trust that the parties will review it, and if a party believes that any request needs to be made of this court, then an appropriate request will be made. But at this point, I'm just advising the parties of the information that I have. And I will add this. I will, of course, it's important that the results of any investigation be turned over to the parties. I don't know how long that will take, but that is also my direction. That was really the only direction I gave to law enforcement, is that the results of the investigation that be turned over to the parties.
Was this? Oh, I'm sorry.
Go ahead.
Was this just found out about this morning?
Yes, the email that was sent to the clerk of court was received at 9:10 a.m. And then that email and the attachment, I'm aware of a second, I will say I'm aware of a second email that was sent to our clerk of court at 10:02
She's like, tell me more.
10:02 a.m.
Tell me more, tell me more.
And I think when we stepped off the bench following the case being given to the jury, I was advised that other emails had been received throughout the court system, and I simply said, obviously that information needs to go to law enforcement. I haven't seen it, haven't reviewed it, but any person who works in the clerk of court's office who has received an email, that email about this topic will be forwarded to the sheriff's department. Their forensic unit is handling the investigation, to my understanding. Attorney Upper, did you have a question or something to state?
Yes, Your Honor, I just wanted to state for the record that I have also received similar emails at my office this afternoon. They were sent not to me directly, but to the district attorney's office website. And I only wanted to point out that in viewing the contents of the posting, well, first of all the emails refer to the exact same posting, and the language is the exact same in all the postings. In viewing the contents of the posting, we question the veracity of the posting because it refers to things that, quite frankly, are not true. And also, upon reviewing it, Your Honor, we came to the conclusion that it does not exhibit any material prejudice against Darrell Brooks that may affect the veracity of any verdict that may be returned in this case. The posting is largely critical of the court and to some extent the prosecution, but the nature of the posting is actually in support of Mr. Brooks. That's why it's under a subreddit called Justice for Darrell. And I don't believe there's any reasonable reading of this post that would lead someone to believe that it suggests the juror harbors substantial or material prejudice against the defendant.
Thank you, I appreciate the additional record.
May I say something, Your Honor?
Go ahead.
Hey, Mary Lou, good to see you.
Just briefly skimming through it, I do want to state for the record that I have no involvement with this. I'm really like shocked like this even came to light. I will say, just by skimming through it, these are definitely things that have been talked about in the court. So common sense would say that this came from someone that has either been in the court to hear what goes on in the court or a jury member. There's no other way.
Well, actually, the proceedings are live streamed worldwide, Your Honor, available on YouTube worldwide, so I don't agree with that assessment.
Well, it's pretty obvious that this would come from somebody who's actually, I think it's pretty clear.
Well, I'm leaving it in the hands of law enforcement to do a full and complete investigation. Again, I take the integrity of this process incredibly seriously, and if there were to be a juror who violated the rules, I would take that very seriously, and I will not hesitate to take any action that I deem appropriate. At this time, it is simply being investigated. This was an anonymous post, and if either party believes any further action needs to take place as it relates to this particular jury, then I trust they'll file the appropriate request with the court. So with that, the courtroom, oh, go ahead, I'm sorry. Something else, Attorney Alpert?
A different topic, Your Honor.
Oh, sure, go ahead.
While we're all together, I just wanted to address exhibits and what the court's procedure would be. We have no objection to any exhibits going back to the jury room if they are asked for, and precluding the requirement that we all assemble every time a note comes out asking for one exhibit. So as long as we're all here and we have some time, maybe we could discuss that.
No, I'm willing to discuss that. Do you have any position on that, sir?
Yeah, I would object from the standpoint that I would need to see any exhibit that's being asked about and the relevancy of that exhibit being asked for. I think that's only fair.
Exhibits that have been received, a relevance objection would no longer be valid because the court has already ruled on the relevance and the admission of the exhibits. The issue is whether it goes back to the jury room. I'll give you a for example. Sometimes in a trial there are medical records that need to be filed in their complete form under the statute, but really maybe only a portion of it would go back to the jury, or depending on why they were offered and whether there was any medical testimony regarding a diagnosis, for example, could impact that. Sometimes there's privacy issues with an exhibit, if there's a social security number for a witness or something like that. But generally speaking, the exhibits have been received, and the jurors can ask to view photographs, written documents. They can even ask to view the videos. The videos would need to be done one of two ways, either which requires everyone to assemble because we do have the technology to play them directly to the jury room, but that simultaneous with that is it would be played in here. So everyone would be seeing what's being played in the jury room at the same time, so that does require the parties to be in court, and that allows the jury to continue.
Okay, you guys, I'm going to skip ahead a little bit.
With their deliberations, talk about what we have here. Could be a still photograph, could be a document, could be a video. We can, sometimes they write notes to us and say they literally tomorrow morning, okay? So even though you're going to stay close by, I'll make sure, I'll work with the jail to make sure that you're given that opportunity. Number 11 is the fourth person.
You said 15, 5, and
55. So I can pull.
I was gonna say I don't know. I know 15.
15 is the map.
15 is the map. Yeah.
Any objection to the map, sir?
Yeah. I want you to rule on everything.
Well, I was gonna go one by one.
If you want to preview it, Your Honor.
Go ahead.
And we are requesting that it be viewed by the jury in their deliberation room.
What I can tell you, if I do allow it, since I would have to we'll verify that the technology is working.
I'll just let you rule on it. I don't particularly.
He's like, I don't know about none of that. Just do what you think. Trying to.
Mr. Brooks?
Well, what's the significance of seeing it as different speeds? Was that in the question?
They just said, can we see exhibit 55 at 40% speed? Obviously, I don't recall specifically if this video was shown at a reduced speed, but many of the videos were shown at reduced speed.
Okay.
During the trial, that was allowed. I think it's proper to.
So they have had a question about wanting to. The jury has had a question about wanting to see this video again. I don't know which video it is. I don't remember.
Also show a video clip to the jurors if they request it at reduced speed. So I'll grant the request.
What would be the significance?
The significance is the jury's requesting it, sir.
Then ask me if I have a position.
Because that's what I'm required to do, sir.
But you're not required to address subject matter jurisdiction, which hasn't been proven for the record. Not allowed to answer any questions I ask. Or your name.
Mr. Brooks, I'm not going to relitigate your case right now.
I mean,
And I've made my decision
I'll
on subject
talk
matter
to you tomorrow,
jurisdiction, so your
Sharon.
request that I address it once again is denied.
Have a good night.
of
Thanks
course
for
it's
joining
not,
us
of
today.
course, because you can't prove it on record. Come on now. It has yet to be proven. has to be proven at some point. Or do I gotta go through the song and dance to get it proved?
Are you ready with the 40%? Was there? Jury's ready?
So they watch whatever portion of the video that
The
they're
video
wanting
clip
to
is
see.
now ended with the stages confirmed, the speed at which it was just played.
And then they're going to go back out. Okay. Back to deliberations. Do they have another question? I can't remember.
Question through the bailiff. We request exhibits 3 and 4. Exhibits 3 and 4 are videos. They are the videos from White Rock, I believe, elementary school. Door 1.
Objection.
Noted for the record. Any specific reason, sir?
Both videos.
And then.
Yeah, grab it.
They're asking it to be stopped. Any objection from the state?
No.
From the defense?
Judge. 35 seconds, I think. Thank you. Is that a good rate?
Sorry, I'm skipping through.
Yeah.
I'm just trying to get to the good spot with. I'm trying to get to the right spot without missing anything important. You know.
Not continue their deliberation. Like to break for the day. I need to basically tell them that because they're breaking for the day, they should not continue their deliberations while sequestered until they're back in the jury room. So I'll read a modified kind of version of instruction 50.
Okay.
Decision that's not based on any law.
I'll have to
You did
go
say,
to
too.
the next day to get
You
the
said one had
verdict.
got excused before, and then another one was getting excused.
No, I reflect I have the different room to not discuss and witnesses will not contact or speak seen radio with anyone about this trial or your
Find it.
experience as a juror by you the juror. A shower.
He wants a shower. All right, let me go find it. Ba-dum bum bum ba-dum bum bum ba-dum bum bum ba-dum dun 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 dun. Okay. Darrell Brooks verdict. Dun 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 dun. Okay. Share this tab. Make it big. All right. So, hold on. Let me X out of that. X out of that. Make sure y'all are still with me. Hey, Kayleen. Good to see you. Kel says, cafe question. What do you serve with BLTs? Probably like potato chips and a pickle. Potato chips and a pickle. I love BLTs though. You could be like Rose Nyland and make bacon, lettuce, and potatoes. Okay, so he's back on day 15 in his orange jail suit. Ooh, steak fries. I love steak fries. All right.
This is please.
Morning, Your Honor. Sue Offer, Leslie Basie, Zach Wichow, all here for the state of Wisconsin.
Thank you. And sir, for your appearance this morning.
Just 1 second, I was napping in here. I'm not sure if I even have everything. I apologize for that, man.
It's all right. When you're ready.
I don't think he's been awake very long.
Third-party intervener in that matter, appearing as authorized representative for my client. I'll set for value in return for value all of the charging instruments in this matter and make my exemption available for discharge.
Or verdict, courtroom will remain open. I'm going to be working in my office on other things.
That's one of the main issues that speaks to. Look at.
Didn't think it would get that far out of.
There can be hidden bias in this jury. It needs to be addressed now rather than later.
Oh, he's going back to that whole jury Reddit post thing.
This is very concerning.
Well, thank you for bringing up your concerns. Let me turn to the state if they want to respond, and then see what other issues they want to cover this morning.
Judge, the original post was on a subreddit thread called Justice for Darrell. That's the copy that the defendant has in front of him. That post was edited last night, claiming that it was a prank from the start, and that the original poster didn't think it would get that far out of hand. The way that Reddit works, the only person who can modify the content of the original post is the original poster, and because the jurors have no access to any electronic devices, I think it's safe to say that our 12 jurors back there are not the original poster.
There we go.
So I think that puts that issue pretty much to bed.
Rest.
It's still obviously under investigation because the court takes it so seriously, but there really is no actionable or any real reason why we should doubt the jury's being unbiased in this case.
I object to that on the grounds, Your Honor, that, like you just said, it is an investigation going on. And if there's an investigation, then that clearly says that something is amiss. We have 15. We have 15 jurors. There's still too many questions that we don't know. Too many. I don't think anything's put to bed because we don't know. It's unfair to say that the issue is put to bed when there's still so many questions left out there.
Good deal, Kel.
I'm sure you
Yum.
reviewed it yourself, Your Honor. You see the language in this, whatever it is, thread. I don't know. I don't know what this is. It's clearly a post from somebody who has intimate knowledge of the trial and what's going on in the trial. I don't think. I mean, common sense would tell you that this is someone who's very close to the case. Whether they were intended to be funny, whether they were intended to try to prank the court or anything like that, we don't know. That could be anybody's guess. The language in this, the way that it's formatted, they lay out 4 specific points of what they think. They point to certain language in the case. They make references to saying when we were in the room. They got certain feelings from when we're.
All right, I'm gonna.
They specifically refer to themselves and a group. That would be discharging the jury. If that's some other type of alternatives that can be looked at,
come back out and make a record of what I had. Come back out and make a record of what I had. To support a mistrial or discharging the jury. I trust the parties will continue in their own independent investigations, that you will continue reviewing case law, make whatever requests that you deem appropriate, should you choose.
Isn't it my choice?
So,
I don't see the relevancy of it.
all right, at this point, unless there are any
raised-
further issues, I am going to go back into my office. The courtroom will remain open, and we'll let you know when the jury communicates
There-
with us, either about a question or verdicts.
There is something that needs to be addressed, subject matter jurisdiction.
The court declines that. I'm stepping off.
Why hasn't it been proven on the record?
He's in his suit at this point of the day. We love Brenner too. We do breakfast for dinner quite a bit. Well, I mean, like I said, we just had French toast and sausage tonight. Yum, it was so good.
Present in a suit. And I will also advise that at 9:43 a.m. this morning, I was advised that the jury had reached verdicts in this matter. And without anything further, I'll have the jury brought out.
Your Honor, I don't consent to being called that name. I'd like to address subject matter jurisdiction for the record that has yet to be proven.
Your objections are noted and will not be addressing subject matter jurisdiction. Please bring the jury out.
Would it be proven for the record, Your Honor?
Put it on normal speed.
Just a reminder to everyone that I do expect everyone in the courtroom to demonstrate appropriate decorum and courtesy as the verdicts are read.
So, in other words, everybody jump up and yell, "Yay!" That would have been appropriate. I'm just saying. Not really, I know. But, all right. Here we go.
And refrain from audible responses. Any disruptions may result in removal from the courtroom.
Your Honor, is that a tacit agreement not to address subject matter jurisdiction for the record?
Jury's coming in. All rise, please.
I respectfully object to that ruling, Your Honor, and request the legal reconsideration of your ruling for the record.
Your requests are noted, sir. We will not be addressing that further.
For the record, may I respectfully reject that ruling and take exception to that ruling, Your Honor? Is that a tacit agreement and a judicial determination that you don't have to answer that question as a public servant, Your Honor? For the record, may I request the legal or factual basis for your ruling, Your Honor?
It might have been a false alarm.
For the record, may I respectfully request a written judicial finding of fact and conclusion of law on this issue, Your Honor?
All your requests are noted for the record. They all are denied, sir. All rise. Jury's coming in.
For the record, may I respectfully move for an interlocutory declaratory appeal on this matter, Your Honor?
Denied.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction?
Denied.
Based on what law or fact, Your Honor? Is that a tacit agreement that you don't have to answer that question? For the record, Your Honor, as a public servant? You don't have to address admiralty law or common law if this court is operating under admiralty law?
We will not be addressing any of those issues.
Respectfully
Thank you, everyone.
object,
Please
Your
be
Honor.
seated. Ladies and gentlemen of the jury, have you picked one among you to be the foreperson? All right, and I see it's juror number 11. Have you reached verdicts on all 76 counts?
Yes.
All right, would you please hand all of the forms to the bailiff?
76 counts. Lord have mercy.
Your Honor, seeing is that we've reached a verdict, is it necessary that I have these shock devices on my ankles?
Jeez. Yes, Miss King. Yeah. Exactly. Gosh, now here come the yawns. I'll scooch on through because my husband's ready for bed. And
of October 20. There are 76 signed verdicts and 76 unsigned verdicts, which would be what I would expect. All right, I will read each one into the record. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 1 of the information, dated this 26th day of October 2022,
Dunzo.
signed by the foreperson, juror number 11. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 2 of the information. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes.
Burn in hell, you piece of shit.
Hey, you are to be removed right now. You will not do that.
I remember that. Did you guys catch that?
We, the jury, find...
Listen to that. I was waiting on that. I couldn't remember how far into the reading of the verdicts it was, but...
A dangerous weapon. Answer, yes.
Burn in hell, you piece of shit.
Hey, you are to be removed right now. You will not do that.
Wow.
We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 3 of the information. And I should state as to count 2, it was signed and dated by the foreperson, same as to count 3. Did the defendant commit
Kel, they said, burn in hell, you piece of shit. Yeah.
First degree intentional homicide while using a dangerous weapon. Answer, yes. We, the
Somebody
jury,
in the
find the
gallery.
defendant, Darrell E. Brooks, guilty of first degree intentional homicide as charged in count 4 of the information. Dated this 26th day of October 2022, signed by the foreperson. Did the defendant commit first degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree intentional homicide as charged in count 5 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree intentional homicide as charged in count 6 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 7 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 8 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged.
Are all of the other charges the reckless endangerment? So the first 6 verdicts were for the homicide. So are all the rest the reckless endangerment?
Charged in count 9 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety? Today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 62 of the information.
They're on count
Dated
62.
today's date and signed by the incident involved death, recklessly endangering safety while using a dangerous weapon. Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 67 of the answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 68 of the information. Did the accident involve death to Virginia Sorensen? Answer, yes. Dated today's date and signed by the foreperson.
So these are the hit and run where each victim is named.
We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 69 of the information, dated today's date and signed by the foreperson. Did the accident involve death to Leanna Owen? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 70 of the information, dated today's date and signed by the foreperson. Did the accident involve death to Tamara Durand? Answer, yes.
Yeah, me too, Kel.
We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 71 of the information, dated today's date and signed by the foreperson. Did the accident involve death to Jane Kulik? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 72 of the information, dated today's date and signed by the foreperson. Did the accident involve death to Wilhelm Hospital? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 73 of the information, dated today's date and signed by the foreperson. Did the accident involve death to Jackson Sparks? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of bail jumping as charged in count 74 of the information, dated today's date and signed by the foreperson.
These are the last handful.
We, the jury, find the defendant, count 75 of battery as charged in count 76 of the information, dated today's date and signed by the foreperson.
Guilty on every single one.
Mr. Brooks, would you like me to poll the jury?
It's like, what does that mean?
Members of the jury, I'm going to ask each one of you individually to stand up, identify your number for the record,
Let's hear
and
them
then
all say
state whether
yes.
the verdicts read in open court are your true verdicts. I'll start with the foreperson. And I'll read your numbers first, so it's a little bit easier. So juror number 11. Were the verdicts read in open court, or are the verdicts, let me rephrase that. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 3. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 6. The verdicts read in open court, are those your true verdicts?
It is.
Thank you. Juror number 14. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 19. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 27.
Lots of men.
The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 34. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 41. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 45. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 46. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 48. The verdicts read in open court, are those your true verdicts?
They are, Your Honor.
Thank you. Juror number 51. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. I should state for the record, I did have the alternates brought back in. Obviously, they did not deliberate, but it was important to have them because there are certain instructions I give at the end. All right, Mr. Brooks, are you satisfied with the polling of the jurors?
No.
I'm sorry?
No.
No.
The court is so satisfied with the polling of the jurors. The court now accepts the verdicts. Ladies and gentlemen, on behalf of myself, the citizens of Waukesha County, and both parties here, I want to thank you for the time and attention that you've spent on this case. Your service in this case is now concluded. There is no requirement that you maintain secrecy concerning what happened in the jury room, but you do not have to discuss the case with anyone or answer any questions about it. On behalf, again, of the court and all of the parties, we thank you for your service over the last 3.5 weeks. You are discharged and free to go. All rise for the jury, please. Thank you. Be seated. Anything from the state at this time?
Your Honor, the state moves for judgment on the verdict as to each and every count.
Anything from you, Mr. Brooks?
What is judgment?
Given the verdicts from the jury here today, the court will enter judgments of conviction based upon the verdicts on all 76 counts. Court will also revoke bond. In this case, I plan on bringing the case in Monday, this coming Monday, the 31st at 1 p.m. to address further scheduling. What I would ask the parties to do between now and then is to determine how long you think each side will need to present their sentencing remarks, whether you anticipate anyone speaking on your behalf. If so, how many, how long, so that I can then look at my calendar and adjust and make sure that I have the appropriate amount of time to do that. I'm not going to sentencing on Monday. It is just for further scheduling at 1 p.m. before my afternoon case.
Judge, would you be willing to consider persons appearing by Zoom for sentencing?
Yes, I would not do anything different than what I've been doing since we started utilizing Zoom, and that is to make it available for both victims and family members.
Okay, thank you.
Thank you, everyone. We are adjourned for today. We'll see you.
All right. So, okay. So we got our verdicts. Dun, 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 dun. So tomorrow my plan is, I'll give you guys a heads up because I know some of you mentioned that you didn't want to see the what do you call it? Victim impact statements. And I totally get it. I totally understand. But at least you have a heads up so you know what's going to be happening tomorrow. Hold on a second, you guys. I feel a little bit of a gas bubble. Hold on. I'm so sorry. Anyway, I didn't want to be disgusting and belch in your ear. So, tomorrow, my plan is to, I've got it all the way to here on day 15. You can see in the screen right here, they're doing their press conference after the trial. So my plan is to resume from here, watch this press conference, hear what the prosecution has to say, and then we will go on into victim impact statements and sentencing tomorrow. That'll be what we do tomorrow. Now, tomorrow will be a later day for me again, like it has been. Yeah, Michelle. Victim impact statements, plus we'll hear from his family. But they've already called and scheduled a 2-hour delay for our schools tomorrow. So her virtual learning is going to be, I need to find out. Let me see if I've gotten a message from her other teacher. Hold on a second. Bum, 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 bum. I don't see anything, but I should have something by in the morning. But anyway, yeah, I'll just play it by ear, but it'll probably be close to the same time, around noon Eastern time or a little later. Because like I said, we're going to be on 2-hour delay tomorrow. So, but thank you guys so much for joining all day. Kel, I know it's been a long day, right? 9 hours and 25 minutes. It has been a long day. And I know husband's ready for bed, so I really got to get up and out of here because I stream in here in our bedroom. But, so I'm going to scooch, but thank you guys for joining all day. Again, a massive, huge shout out to Tanika from Tanika's 2 Cents for sharing her crimey family with my crimey family. And we'll see you guys back tomorrow. I appreciate all of you hanging out for the vast majority of the day. It's been a long day, but it's been a good day. Been a good day. So, thank you guys for the super chats, the super stickers, the gifted memberships, and the milestone chats. Thank you for everybody being respectful in the chat. I love my chat folks. I love you guys. But yeah. See you back tomorrow about the same time. All right? Make sure to hit that thumbs up before you go. Subscribe if you're new. Would love to have you hang around. Hashtag replay in the comments down below if you watch this on the replay. All right. Anything else? Be safe, be warm, all that jazz, right? All right. Love you guys. Mean it. I'll see you tomorrow. Bye.